Thank you for reading our book. My name is Darren Joseph, and I'm the co-author of this book. I have been a long-term resident of Singapore since 2013. Our Singapore-based international tax team works with U.S. citizens and green card holders who invest in or work across Asia. Our team also works with Asian families that invest into the U.S. It is difficult for U.S. exposed families to easily access support in estate planning. Over time, our practice began to take on more and more clients who had issues related to U.S. estate taxes. In June 2020, my own father, Hayden T. Joseph, CPA, NBA, passed away at our family home in Miami after a long illness. I have dedicated this book to him. I am grateful to Dwi Sek Lim for working with me to produce a resource that can help families like ours. U.S. exposed families based in Singapore with estate planning needs. Trusts, wills, powers of attorney, medical directives, etc. I hope that the contents of our book can help you through a challenging process. My name is Darren Joseph, and I'm a partner with Hayden T. Joseph and Company, and a member of the international tax team at Moores Rowland Asia Pacific, with over 30 offices in 11 Asian countries. As an IRS-enrolled agent, I am admitted to practice before the IRS, and I am the author of Taxes for International Entrepreneurs and Expats, Proven Principles for Legally Reducing Taxes, and Adapt or Die, International Entrepreneurship in a Post-Pandemic World, available on Amazon. I have 2 master's degrees in economics, a certified diploma from ACCA, Association of Chartered Certified Accountants in the UK, done extensive education with Columbia Business School, and completed advanced tax coursework at both New York University and the University of London. I have had my views published in the Singapore Business Review, Forbes Asia, the American Chamber of Commerce in Indonesia, the International Business Structuring Association in the UK, Offshore Alert, and the Trinidad Guardian. Finally, I have given seminars on tax issues in the US, Singapore, Indonesia, Malaysia, Vietnam, the Philippines, Hong Kong, Taiwan, Japan, and the Caribbean. Email at help@htj.tax. LinkedIn is www.linkedin.com/in/Darren-EA-0345332. Website www.htj.tax. Essential Estate Planning for American Expats, Resident in Singapore, by Darren Joseph and Dwi Sek Lim. Narrated by Lamont Mapp. Forward. Life planning is important. I think most of us recognize the need to have a plan in life. What is often overlooked, neglected, or ignored completely, but equally as important, is our estate planning. Grasping the urgency of proper estate planning cannot be overstated, and Dwi Sek and Darren do a masterful job of untangling it, succinctly and in an enjoyable reading style. As an American expat living in Asia and an international investor, finding comprehensive and adequate information, much less assistance for estate and financial planning, can be challenging. What I have found is a lot of product pushers, chasing commission heights, peddling fancy-sounding concoctions, rather than actual competent planners. Staring 50 in the face and with a family to think about, it's impossible for me not to have a clear and well-laid-out plan in place for them. The absence of such a plan would be reckless and irresponsible. The bifurcation of life and legacy is meaningful to me, and I'm sure to many others as well. Therefore, estate planning is simply an unavoidable necessity. Having seen the detrimental effects and emotional toll on spouses and children due to the failure of planning, only accentuates why this book is such an indispensable tool. Dealing with wait times due to probate, contested wills, or payments over tax penalties can leave remaining family members anxious, stressed, frightened, and oftentimes ill-prepared to deal with everyday life and expenses. Throw in the limitations of a pandemic, and weeks can easily turn to months, if not years. Catastrophic would not be hyperbolic in describing the outcome in many cases, which could have been avoided with some proactive devising. Darren and Jui have done us all a huge favor with their extensive analysis of the most pertinent issues in the elaborate space of estate planning. This highly insightful, informative, and provocative treatise is prescribed reading for business owners and expats living in Asia in general, but Singapore in particular. Efforts to consume in perfectly sized portions, you will gain invaluable knowledge and education on an array of complex and convoluted issues. Each chapter will start with a takeaway, foreshadowing a deeper, in-depth analysis and explanation of the matter to come, which makes it easy to follow and smooth flowing sections. As an ingress to estate planning, this book should get you on an expedited search to securing a qualified and experienced team in the jurisdictions where one has potential exposure. Jump in and enjoy. J. Knight, J.D. Bio. J. Knight is originally from San Francisco and has been living in Asia for the past 10 years. He graduated from UCLA with a BA in political science and has a JD from San Francisco Law School. Jay also has an active real estate brokerage license in California and is an avid real estate investor. Legal disclaimer. It is important to note that the views expressed in this book are that of the writers and do not reflect the views of the publishers or any other affiliates in any way or form. This book is made available by the writers and publishers for educational purposes only, as well as to give general information and provide a general understanding of certain legal, economic, and social factors. It is not to provide you with a specific legal or financial advice. By purchasing, receiving, acquiring, and reading this book, you understand that there is no attorney-client relationship, nor any other client advisory relationship of any kind, between yourself, the writers, or publishers. This book should not be used as a substitute in any way for competent legal or financial advice from a licensed professional in your country, jurisdiction, area, or state. Under no circumstances shall the writers or publishers or anyone else involved in the production of this book be held liable for any indirect, incidental, consequential, special, or exemplary damages arising out of or in connection with your access, use, or inability to use the content of this book. Enjoy the book. DeAndre T. Joseph. Bio. After spending 4 years in Singapore and Southeast Asia, DeAndre T. Joseph is now based in Miami, Florida. He has a UK law degree and is an associate with Moores Rowland Tax Consultants and is enrolled at the University of Miami School of Law. DeAndre T. Joseph works with U.S.-exposed entrepreneurs doing business internationally. Introduction by Jui Sek Lim. My name is Jui Sek Lim, a Singapore-qualified and Singapore-based financial planning professional with over 20 years of experience. Estate planning is an important area that's often overlooked. I make no apologies for bringing my Christian faith to my duties as a financial planning professional. Estate planning embodies love, care, and responsibility toward all our loved ones and good causes for the society at large. The greatest gift is love, as recorded in the Bible, and now abide faith, hope, love. These three, but the greatest of these is love, or charity. 1 Corinthians 13:13. It is more than duties and obligations required of law and social norms, but how we exercise good stewardship of all that we have and own. 2 striking cases happened to people I know which significantly impacted me and convinced me of the importance and urgency of estate planning. 1. A young couple that died in a ferry mishap off Bahrain on 30 March 2006. This young man, after having completed a project in the Middle East, invited his wife, who is a few years younger, to join him for a holiday before returning to Singapore. Unfortunately, their ferry capsized off Bahrain, and both of them died. Since they both passed away with no wills and no children, the court decided that the man died first in this common disaster. Their 4-room HDB flat, under joint tenancy, and other joint assets go to his wife, according to rights of survivorship. Since the wife also passed on with no children, her estate assets all go to her parents, according to the Interstate Succession Act. It was sad that the aged father of this young man got nothing. 2. An ex-colleague who suffered brain damage and has been in a vegetative state since August of 2008. An ex-colleague of mine suffered brain damage unexpectedly while he was overseas. After he returned to Singapore, it took the family about 4 months and cost about $6,000 for his son to be appointed by the court as deputy to settle some financial matters on his behalf. Since his 2 children were both married with their own properties, his wife considered selling the jointly owned landed property. Unfortunately, the original deputyship did not give his son power to sell the property. If they want to sell this property now, they will have to go through another legal process with fees to secure such power from the court. The impact of these 2 cases and many other cases of no estate planning reported in the news have strengthened my conviction. Hence, since early 2015, I've been 100% focused on estate planning services. I'm concerned that many Singapore residents have not done any estate planning. I strongly believe that only through education can we raise public awareness of estate planning, help everyone to better appreciate its importance and urgency, to know more about the various instruments available and the considerations to structure the most appropriate solution for their estate plan. In this regard, I've been conducting educational talks on estate planning since July of 2018. 2 invited guests: companies, community clubs under People's Association, NTU Alumni Club, and nonprofit welfare organizations. On the 17th of January 2020, 2 days after I conducted a talk on estate planning at the office of Darren Joseph, he asked if I would co-author a book on estate planning in Singapore. While praying over this matter with my family over the next 2 months, came to the enforcement of circuit breaker measures for 4 weeks, starting from the 7th of April 2020. It was necessary for Singapore to be placed under semi-lockdown in order to effectively contain the spread of the COVID-19 virus. It became clear to me that this was the will of God for me to write this book when our government announced on the 21st of April 2020 to extend the CB by another 4 weeks. I made the decision to embark on this challenging task and committed it to my God, for I know whom I have believed, and am persuaded that He is able to keep what I have committed to Him until that day. 2 Timothy 1:12. Subsequently, I emailed Darren on the 23rd April 2020 of my decision together with a draft of the contents and outlines. I thank God for this opportunity and pray that this book will enable more people to know about estate planning. And we know that all things work together for the good of those who love God, to those who are called according to His purpose. Romans 8, verse 28. Please enjoy the book. Jui Sek Lim. Jui Sek Lim is a certified financial planner with the Financial Planning Association of Singapore, FPAS Singapore, since May 2004, and an estate and succession practitioner with more than 15 years of experience dealing with the mass affluent market. Since 2015, he has stopped dealing in life insurance and general insurance matters and focuses only on estate planning matters, offering consultation and services from will writing to integrated estate plan compromising wills, LPA trusts, CPF nominations, and insurance nominations. His passion in the subject motivated him to conduct regular educational talks to companies, institutions, and community clubs since late 2018. How to use this book. I assume that you already have a successful international business, or have enjoyed a successful international expat career, this book is not about growing your wealth. It's all about protecting your wealth and ensuring that it passes to your family intact. To do this, we introduce you to key concepts that we believe that you as an international entrepreneur or expat should consider as you plan for this post-pandemic world. No book can ever replace professional advice from qualified professionals. It's only meant to help you select the right team and highlight key tools that are available for effective estate planning. Note that we use the word team. This is because once you are dealing with more than one jurisdiction, it's highly unlikely that a single person has all the needed skills, knowledge, or experience. You need a team of qualified and certified experts who can completely advise you on the various jurisdictions where you have assets, residency, and/or domicile. In the context of the U.S. in particular, your team should include members qualified in the specific estate in which you have exposure. With our book, you have two choices. You can read it cover to cover. Alternatively, you can use the table of contents and just jump in the sections that are of interest to you. Feel free to reach out to us if you have any further questions. Our contact details are in the introduction. Enjoy our book. Julie Seklim and Darren Joseph. Chapter 1. Overview of Estate Planning. Takeaways. Given the ongoing pandemic, we're more painfully aware of our own mortality. Estate planning is a holistic process involving a wide variety of tools and services. Beware of advisors that equate estate planning with selling you products. The time to start planning is now. Background. The current COVID pandemic and its impact worldwide is a timely reminder that every one of us should seriously consider doing our estate planning and other areas of financial planning. As soon as possible, while we are alive with sound mental capacity. In such planning, we must take into consideration all the likely scenarios that can happen to us, and then structure realistic and optimal solutions to best meet our situation and purpose. This is the most prudent approach to take, so that you may not be caught unprepared and suffer adverse consequences. It is heartening to note that there's a greater awareness of financial planning in Singapore since the establishment of Financial Planning Associate of Singapore on the 1st of December 1998. The enactment of Financial Advisors Act in 2002 and launching the National Financial Education Program MoneySense in 2003, financial planning covers many areas that require the services of specialists and qualified practitioners. There are 6 areas of financial planning, namely, cash flow planning, insurance planning, investment planning, tax planning, retirement planning, and estate planning. While insurance planning, investment planning, and retirement planning are widely advocated by financial planners, advisors, or consultants, unfortunately, public awareness of estate planning is lacking, and the needs for services in this time are great. Definition and objective of estate planning. There is no universal definition of estate planning, but certainly it is not confined to dealing with immovable properties such as land, commercial, and residential properties only. According to Wikipedia, an estate is common law, and the net worth of a person at any point in time, alive or dead. It is the sum of a person's assets, legal rights, interests, and entitlements to property of any kind, less all liabilities at that time. Estate planning is the process of anticipating and arranging during a person's life for the management and disposal of that person's estate during the person's life and/or death. While minimizing gift, estate, generation, skipping transfer, and income tax, estate planning includes planning for incapacity, as well as a process of reducing or eliminating uncertainties over the administration of a probate and maximizing the value of the estate by reducing taxes and/or expenses. The ultimate goal of estate planning can be determined by the specific goals of the client, and may be as simple or complex as the client's needs dictate. Guardians are often designated for minor children and beneficiaries in incapacity. Practical definition. Estate planning is a planning process throughout the lifetime of every adult, for the management and distribution of their assets to ensure that their wishes and intentions will be executed expeditiously for the benefit of the people and causes they care for during their lifetime, after death, and beyond. Death and loss of mental capacity. The significant life event of death and loss of mental capacity are beyond our control and can happen to any person at any time. As such, estate planning is not just simply about distribution and management of our estate assets upon death. We must also consider the situation if we should suffer loss or mental capacity, hence loss of legal capacity. Keep in mind that all legal documents related to a person's estate planning can only be put in place while he's alive and with sound mental capacity. Objectives. It is important and logical that we want our assets to benefit those people and causes that have greater needs and are more deserving, but it is even more significant that estate planning should consider the passing of value and building of legacy beyond generations. For example, to encourage and promote family unity, education, thrift, accountability, entrepreneurship, social responsibility, and philanthropy. Estate assets can be settled into purpose trusts or foundations to provide funding for tertiary education or future generations, to support certain good causes or charity organizations, and for medical, scientific, or technological research and development. Alternatively, estate assets can also be given outright as gifts or donations during your lifetime and after death to entities that advance your objectives. DCUR, Natures of Estate Planning. There are 4 natures of estate planning. 1. Dynamics of asset holdings and values over a person's lifetime. Generally, when people start working, they will also start saving to build up an emergency fund, buying insurance, then go into investments with available money and spare cash flow to grow their wealth. Some may even go into business and riskier ventures. Over time, they may acquire more assets and liquidate some. Invariably, some will make profits, and with some suffering losses. Hence, the type and values of their asset holdings will change over their lifetime. Many people prefer to wait till their business is stabilized or after the completion of the purchase or selling of a property, before looking into estate planning. They failed to understand that our asset holdings are always dynamic, because of market volatility coupled with many other factors, and hardly ever come to a stable state. The financial impact of COVID-19 pandemic to all families and businesses, both in Singapore and abroad, is a case in point. 2. Changing social situation and concerns over a person's lifetime. All of us started as singles with parents and immediately family members. Our family circle is likely to grow over time, especially after getting married or having children of our own. At the same time, our social network is also expanding as we advance in our career. Some people, especially those with greater wealth, who are more caring and philanthropic, will have concerns for others beyond their family circles and want to advance certain good social causes that are close to their hearts. 3. Uniqueness of estate plans for different individuals. In view of differences in asset holdings and values, as well as in social situations and concerns for different persons, it is only logical that their estate plan will be dissimilar and unique to best meet with their situations, objectives, and intentions. There are many singles and married couples with no children in Singapore today, with no siblings, close relatives, or older folks around. Their estate plans would certainly be different from those with bigger families, especially those with vulnerable and special needs dependents. 4. Review estate plans over time. Regular review, update, and making of adjustment to estate plans is necessary from time to time, due to the dynamics of asset holdings and values, changing social situation, priorities and concerns, value system, as well as upon occurrence of significant life events, such as marriage, new births, divorce, and demise of family members. Hence, regular review of estate plans is necessary and realistic. Similar to financial planning, much like review of plans at company or national level because of extreme factors. While the above make estate planning sound straightforward, one of the most important and often most difficult things to do in making an estate plan is to prepare for contingencies. What will happen if children unexpectedly predecease their parents? What if the value of the property expected to be used as a source of income in retirement suddenly decreases in value? What if the children lose interest in a family business the parent hopes to leave them after his or her death? What will happen to a gift in a will if the intended beneficiary elects to refuse it? How will children from a first marriage have their interests protected if their parent remains and starts a new family? What if tax laws are changed that either increase or decrease estate and gift taxes? These are just a handful of the literally thousands of questions that come to mind when pondering the possibility of changes. The best and only answer to this type of problem is to continuously review any estate plan. There are particular events that also warrant a review of estate plans. These include the following: a marriage or divorce, the birth or death of a child or grandchild, the purchase of a home, the receipt of any significant amount of money, i.e. an inheritance or lottery winnings, the onset of a serious illness, significant changes in state or federal tax laws, the death of a spouse, or the opening or closing of a business. Even in the absence of one of these types of significant events, it is prudent for each person to periodically review his or her estate plan. Perhaps a charity that was a favorite several years ago has been supplanted by a new cause. Perhaps a grandchild in need of support a few years ago has completed law school and is making a good living. It is therefore never a bad idea to periodically review all aspects of an estate plan. W5H, Subjects of Estate Planning. In doing estate planning, you have to firstly consider and establish answers to the W5H, i.e., who, what, when, where, why, and how subjects of estate planning. 1. Who? Who are your beneficiaries and personal representatives? Beneficiaries can include individuals, institutions, and special vehicles. Personal representatives can also be individuals or institutions depending on the type of instrument. A. People and legal entities. Draw up your family tree, including individuals and/or class of persons such as siblings, children, and grandchildren. Those for whom you have obligations or concerns. Remember vulnerable family members, including those who have special needs or require long-term care, and those may have character weaknesses. Beneficiaries can also be institutions, such as non-profit and charitable organizations, as well as special vehicles such as trusts and foundations. B. Concerns and values. Estate succession is not just about distribution of your estate assets to your beneficiaries, but more importantly are the concerns and value systems you want to pass on, both within your family circle and beyond, for good causes that will have wider and more significant impact to the society at large. 2. What and where of assets do you have? Take stock of all the assets you have. In general, assets can be categorized into 5 types. A. Businesses. Indicate type of company and the partner or shareholder for each, whether locally registered or in other jurisdictions. Also, the share composition of partners and shareholders in each of these companies. B. Real or immovable properties. Both residential and commercial properties, including land, indicate for each title the type of ownership, sole owner, joint tenancy, and tenancy in common, fully paid or with outstanding mortgages, and also the county and jurisdiction where each of these properties is located. C. Personal value items. Include car, art pieces, antiques, jewelry, and collectible items that are of significant value. D. Insurance policies. Types of policy and sum assured. The insurance company and policy number, if available. Also indicate if these policies are nominated either under Section 73 of Conveyancing and Law of Property Act or under S49M or S49L nominations under Life Insurance Act, and if any policies are already placed in private trusts, particularly for universal life policies. E. Other liquid or movable assets, including cash, bank accounts, shares, and stocks, both listed and non-listed companies, local or overseas, REITs, bonds, and investment funds. 3. When, why, and how of your intention and concept of estate management. These are questions related to the concepts of management, timings, and method of transfer of your assets and estate incomes for the benefit of your beneficiaries. You should think about and have to come to some rough idea of your intentions for each of these assets. For the businesses which you owned, what are your intentions or options, be it for business continuity, succession, merger and acquisition, listing or sell-off? For immovable properties, what is your intention for each of them? To hold for rental income over a long period of time, or maybe for capital gain? Likewise, what is your intention for each of the personal value items? Or who will give it to you? Estate planning instruments. Next, with the help of estate planning practitioners, to gain some understanding of the following estate planning instruments available in Singapore, and the various options of estate plan structures that best meet your wishes and intentions. 1. Lasting power of attorney. This is effective immediately when a person is certified to have suffered loss of mental capacity. In the U.S., we often distinguish between a medical power of attorney and financial power of attorney. This document stipulates what life-saving medical procedures an individual wants or does not want in the event they are physically or mentally incapacitated. A medical power of attorney appoints a person the power to make medical decisions on the individual's behalf, while a financial power of attorney states who can make financial decisions on an individual's behalf. 2. Wills. These are applicable upon or after a person's death, subject to probate for assets in the jurisdictions concerned. From a U.S. perspective, every adult should have a will. In the absence of a will or will alternatives such as trusts or joint tenancy, property is disposed of according to the laws of interstate succession in the decedent's state of domicile. Every individual should have a will that stipulates how and to whom they want their assets distributed. Otherwise, state law may give assets to heirs the descendant would not have wanted to inherit his or her property. 3. Trusts. Once set up and subject to stated terms, trusts can be effective immediately during a person's lifetime, or when certified to have lost mental capacity or upon and after death. From a U.S. perspective, trusts are flexible and useful vehicles that can be used for many reasons, including tax planning, estate planning, and for charitable giving. Like any of the estate planning tools discussed in this book, no one plan is right for every person. However, given their flexibility, there are many different types of people who can benefit by including some type of trust in their overall estate plan. Some of the advantages of a trust include: a trust is a flexible document. It can adapt to the needs of the family. A trust is more difficult to challenge than a will. A trust saves costs by avoiding probate of those assets transferred through a trust. A trust provides privacy. The probate process is public, whereas the public has no right to view a private trust. In some circumstances, there can be tax savings associated with the use of a trust. Trusts can be used to limit the ability of a beneficiary to squander an inheritance, and trusts can also allow an individual to make a gift and at the same time continue to enjoy the property while they're alive. 4. CPF nomination. CPF is a Singapore government-mandated retirement plan. Valid CPF nomination is effective upon and after a person's death. 5. Insurance nominations. These are nominations of the insurance policies, if applicable. They are effective upon the insured person's death. 6. Advance medical directive. After a person has set up his AMD, it will be effective when he is certified by a panel of specialist doctors that he is administered with an extraordinary life-sustaining system to prolong the process of his dying when death is imminent. 7. Gifts. In the U.S., one of the most basic and inexpensive strategies for saving estate taxes, the gift tax exclusion allows an individual to give away, tax-free, a certain amount a year to each beneficiary an individual selects. Thus, a husband and wife could jointly give away a combined amount of money annually to each of their children, grandchildren, or anyone else without incurring a gift tax. Giving gifts to charity, either before death or after death, is another way to reduce the size of an estate subject to estate taxes. This can be done either as an outright gift in life or at death through a testamentary disposition, or through one of the various types of charitable trusts that will be discussed later in this course. More details of these instruments, about their limitations, advantages, and disadvantages, considerations, and applications will be presented in the subsequent chapters. Estate planning process. Effective estate planning can be carried out over a 9-step process as shown in the following diagram. The process is applicable for both the first-timers and those who are reviewing and updating their estate plans in light of significant life events, such as marriage, new birth, divorce, and demise of family members. 1. Awareness. You can gain awareness and understanding of estate planning through educational talks and seminars conducted by professionals, or even reading books and articles on the subject. 2. Preparation and fact-find. The next step is to consider and establish answers to the W5H for estate planning, as explained earlier in this chapter. This is also the starting point for subsequent reviewing or updating of your estate plans. 3. Structuring of estate plan. Based on the answers to W5H in Step 2, appropriate estate plan options can then be structured, with help from professional estate planning practitioners, either for individual or couples, comprising all or some of the instruments mentioned in the previous section. For estate planning review cases, the structure and components of your estate plan may be updated or amended as appropriate. 4. Drafting of documents and applications. Your EPP will advise you on application or review of CPF nomination, insurance nomination, and AMD as necessary, and then proceed to draft your wills, trusts, and LPA as required. Deposits are generally required at this step. For cases of reviewing of estate plan, relevant estate planning instruments or documents will be updated, amended, or redrafted as necessary, consequent to updated information established for W5H in Step 2. Validation and proofreading or drafts. When the draft documents and relevant application forms are ready, your EPP will go through with you to ensure that all personal particulars and details of estate planning will concept and intentions are correct. Amendment and redrafting of these documents at Step 4 may be necessary due to updates or changes to W5H considerations, intentions, and concepts. 6. Prepare final documents. When drafting the will, trust, and LPA are finalized, your EPP will arrange and confirm the date, time, venue, and required witnesses for signing of these documents. 7. Signing and submission of documents. On the appointed date, time, and venue, your EPP will guide you and your witnesses to sign the documents concerned. Final payments are generally required at this step. 8. Custody and safekeeping. Your EPP will also advise you on the appropriate custody services for safekeeping of your original copy of your estate planning documents. Depending on the types of custody service package, additional payment may be required. You will also be provided with a personal asset inventory booklet for you to maintain and update. 9. Review of estate plan. Estate plans will have to be reviewed and updated periodically or upon occurrence of significant events, such as marriage, new birth, divorce, and demise of family members. This process will repeat from Step 2 above. This 9-step estate planning process is consistent with and is within the framework of the 6-step financial planning process as shown in the table below. Financial planning process. Step 1. Establish and define relationship. Step 2. Fact find and data collection. Step 3. Analyze and evaluate. Step 4. Develop and present financial plan. Step 5. Implement financial plan. Step 6. Review of client situation and financial plan. Estate planning process. Step 1. Awareness. Step 2. Preparation and fact find. Step 3. Structuring of estate plan. Step 4. Drafting of documents and applications. Step 5. Validation and proofing of drafts. Step 6. Prepare final documents. Step 7. Signing and submission of documents. Step 8. Custody and safekeeping. Step 9. Review of estate plan. Chapter 2. Importance of urgency of estate planning. Takeaways. It is important to initiate estate planning while healthy and mentally sound. 2. Estate planning is an opportunity to control not just what is to happen, but how it should happen. Importance of estate planning. It is important to do our estate planning while we're healthy and with sound mental capacity. There are many tangible and intangible benefits with the relevant legal documents of our estate planning put in place. Most importantly, we can have peace of mind knowing that our wishes will be done, no matter when unexpected losses of mental capacity or death may strike us. Wishes to be done. The relevant legal documents of estate planning, when properly done, will ensure that your wishes and instructions will be executed to provide for the people and causes you care about. This may include the continuous running of businesses and investment of your assets to grow wealth and generate income to fund long-term objectives across generations. Expeditious execution. With estate plans in place, the execution of your wishes and instructions will be expeditious. Otherwise, it could take months or longer before any action can be done to your assets. For example, for a person passed on with a valid will, the typical probate process is only a few weeks. But with no will, the probate process would take 4 to 6 months, or even longer for complicated cases with disagreement and dispute among family members. Similarly, when a person suffered loss of mental capacity with LPA in place, his appointed representative, i.e. donees, can carry out their duties almost immediately. Otherwise, it could take 4 to 6 months for one of the family members to apply and be appointed by court as deputy to act for him. Minimize expenses and financial loss. Lawyer fees in court proceedings are costly. With a valid will, the expenses for the probate process is only a few $1,000s. But expenses can be many times more for probate of a person passed away with no will, and worse still, if there are disputes among family members and court fights. Then the cost can escalate to tens of thousands. Meanwhile, all his assets are frozen, subject to depreciation, rental loss, and missed market opportunities. All these can result in significant financial losses. Likewise, a standard LPA with your donees appointed while you're healthy with sound mental capacity can be settled within a few $100s, whereas the legal fees for someone to apply to court and be appointed as your deputy can cost up to $10,000 or more. Prevent suffering to family members. For a person with no estate planning, his assets can be frozen for a long time, until the legal proceedings are done. During that period, his family may suffer much due to shortage of money to pay for their daily living needs. The suffering can be compounded by seizure of properties, by creditors, and heated emotional conflicts arising from heightened stress among family members, and with others. But with property estate planning done, there will be sufficient liquidity during the required legal proceedings, and if also subsequently assets can be managed and distributed expeditiously as planned. Hence, proper estate planning will prevent and minimize suffering to family members. Probate avoidance. CPF nomination, insurance nomination, and living trusts are valid estate planning instruments to provide liquid assets for your dependents and those you want to care for upon your demise. More details of these will be provided in later chapters. Minimize duties and taxes. In Singapore, estate duty has been removed for the estates of those who died on or after the 15th of February 2008. But there are many Singapore residents who own assets, including real or immovable properties, in countries such as the USA and United Kingdom, that impose heavy estate duty or inheritance tax for non-residents. Such taxes can be minimized and even avoided through proper estate planning. On the other hand, the prevailing buyer stamp duty up to 4% and additional buyer stamp duty up to 15% for purchasing of residential properties in Singapore on or after the 6th of July 2018 can be avoided or minimized through proper estate planning. Asset protection. The basis of estate planning is to consider all plausible real-life situations and to address each with practical solutions using relevant legal instruments. A person, especially those doing business, can be sued for bankruptcy during his lifetime due to business failure or legal liabilities. His estate assets can also be a caveat and seized by creditors for unpaid debts or obligations. In such a situation, his estate may be depleted or bankrupted, and leaving nothing for his beneficiaries. Estate planning instruments, such as trust and insurance nomination, subject to meeting regulatory requirements, can be effectively used to protect assets from creditors. Business interest protection. People who are running businesses should consider what could happen if they were to suffer loss of mental capacity, struck by death or severe disability unexpectedly. For those with solely their own businesses, they should be concerned with business succession, though they may consider at the same time various exit options. For those with business partners and shareholders, they should be concerned with business continuity and preservation of fair value of their shares. Detailed solutions for businessmen are out of the scope of this book. They should consult professional estate and succession practitioners to secure solutions that best meet their situation. But suffice to say that relevant estate planning instruments such as trusts and insurance are significant components of these solutions. Avoid conflicts and disputes. Proper estate planning will help to avoid conflicts and disputes among family members, especially big families with strong characters, and between shareholders for those who are running businesses with partners. Invariably, such disputes due to conflicts of interest will result in financial losses and broken relationships. Certainly, no one wants such undesirable situations to occur. Peace of mind. With estate planning in place, you can enjoy peace of mind, knowing that everything will be in order should any of the significant life events were to strike you at any time. Urgency of estate planning. Not only is it important for us to do our estate planning, but to do it with urgency. It is critically urgent for all of us to do our estate planning, because all of the relevant legal documents of estate planning can only be lawfully executed and put into place while we are alive and healthy with sound mental capacity. Certainty of death. It is certain that all of us will have to face death one day, but no one can be certain when and how that will happen. There are many causes of death as shown in the diagram below. The risk of death increases especially for affluent societies like Singapore, where people travel more often both for work and for leisure, within the country or overseas. Possibility for mental incapacity. Hopefully, all of us will not suffer mental incapacity, but there is an alarming increase of such cases worldwide, especially in metropolitan societies like Singapore, where they can be competitive and high pressure. So, there has been a universal call for work-life balance. There are many causes of mental incapacity as shown in the diagram below. These are happening to adults of all ages, mostly due to stressful living and unhealthy lifestyles. None of us can be sure if such an unfortunate event would happen to us. These two significant life events of death and loss of mental capacity are real. So the questions we should seriously ask ourselves, if and when either of these significant life events were to strike us unexpectedly, are: 1. Would everything be in order and be carried out according to our wishes and intentions? And 2. What adverse impacts could result, particularly to our loved ones? Since death and loss of mental capacity are not conditional on age, nor married status, nor state of wealth, and certainly not within our control, as elaborated in the next chapter, we should all give priority and do our estate planning with urgency. Impacts of significant life events. Singles and single parents. It is important for singles, and more so for single parents with minor children, to consider the problems and difficulties their dependents would have to face if they were to pass on. The consequences will be much worse if they were to become mentally incapacitated, because the challenges will be multiplied due to the need to care for themselves, burdened with additional health care expenses and compounded by loss of income. Sole and key income earners. If you are the sole or key breadwinner in your family, similarly, you have to consider the situation if either of the two significant life events were to strike you unexpectedly. Certainly, you want to ensure financial liquidity and adequacy for all those dependent on you. Free them of anxiety, conflicts, and any tedious and costly legal issues. Are your family members competent to manage your assets or estate matters? Even if your spouse may not be contributing much to the financial needs of the family, you have to consider the situation is he or she were to pass on or to suffer mental incapacity. The need to employ a maid and provide health care for your incapacitated spouse will surely result in additional burdens for you and your family. Dual income families. There are increased numbers of dual income families in Singapore and the regional countries. These include families with bond husband and wife earning incomes as employees and those with either one or both of them running their own businesses. What would be the impact and challenges if one of this couple were to pass on or suffer mental incapacity unexpectedly? What if both of them were to be struck by either one of these significant life events? The worst situation is when both the husband and wife become vegetables and bedridden. Estate planning is critical to ensure that the daily living and maintenance needs of dependent family members are provided for. Estate assets are expeditiously settled without conflicts, and everyone has a roof over their heads. For families with young children, their estate planning should specify guardians to care for them and to ensure their proper upbringing and education. Loss of legal capacity. It is universally recognized that any official document is valid and enforceable only if the persons involved have the legal capacity to execute. Besides having official title and proper authority, not acting under undue influence or duress at any time of the execution, more importantly is that they must be alive and have sound mental capacity to execute. Chapter 3. Problems with having no estate plan. Takeaways. Financial burdens fall upon loved ones. Potential for dependents to face extreme financial hardship. Your personal financial affairs may become a matter of public record. Potential conflict among loved ones with competing interpretations of your wishes. An estate can take years to go through probate. You may reside far from immediate family. Who cares for the kids and other dependents while financial matters are being settled? There are many serious problems, both tangible and intangible, that will adversely impact you and your family when either of the two significant life events were to strike you unexpectedly, and if you do not have your estate planning documents in place. There are established laws and regulations in Singapore specifying the procedures for dealing with you, your representatives, and your estate consequent to occurrence of your significant life events of death and loss of mental capacity. Legal processes are tedious and time-consuming. There are more filings and submissions required to obtain court orders for the appointment of representatives with defined powers to act on behalf of a person who passed away with no will, or loss of mental capacity with no LPA. The court needs to validate the identity and relationship of these representatives with the deceased, or the person who has lost mental capacity. The court also needs to satisfy with documentary evidence that all other family members renounce their rights to be appointed and have given consent for the appointment of these representatives. Such submissions for a representative, known as administrator, to act for a deceased person typically takes 2 to 3 months to reach the court and to schedule for court hearing. Time taken to apply to be representative, known as deputy, to act for a person who has lost mental capacity is 3 to 4 months, and the process will be given even longer cases for no consent among family members or with contests and disputes. Legal fees are costly. Court fees and lawyer fees are very costly. The current starting pay for a fresh graduate lawyer in Singapore is $5,000 monthly, and law firms typically charge an hourly rate of $300 for the service of a junior lawyer. Rates for senior lawyers could be $800 or more. It is common for cases with disputes and contests to incur legal fees of tens of thousands. Duties and taxes. There is currently no estate duty or capital gain tax in Singapore, but there are many Singapore residents holding assets in other countries that impose hefty estate duty or inheritance tax of up to 40%. On the other hand, the Singapore government has implemented a number of duties and restrictions to contain housing prices of both public and private residential properties here. Higher rates for permanent residents and entities such as companies and trusts. It is advisable that you should consult and engage the services of estate and succession practitioners to minimize expenses for the purchaser and transfer of ownership of residential properties in Singapore, and more for those who own assets in foreign countries in order to minimize and avoid duties and taxes. Assets frozen until court orders are granted. All the assets of a deceased person, or the one who has lost mental capacity, are frozen throughout the period, from the occurrence of death or mental incapacity till the issuance of court orders from the appointment of personal representatives. During this time, no one can access his bank accounts, his car, properties, or investments cannot be sold. Also, his property cannot be rented out or for expired lease to be renewed. Consequently, this will result in financial losses. Inevitable financial losses. No transaction can be carried out while assets are frozen until proper personal representatives are appointed by the court. Missed market opportunities, either for selling or acquiring of assets, will amount to financial losses. Delay in disposing of depreciating assets, like cars, directly translate to loss of value. Leasing of properties or renewal of expiring leases held in abeyance are certainly to result in financial losses too. Suffering of family members. Freezing of assets also leads to cash flow problems that affect the daily living needs of family members and dependents. Having joint bank accounts are no assurance for cases of common disasters that happen to both the account holders, or significant life events inflicted upon both of them in short intervals. Generally, the legal title of a jointly owned asset goes to the last survivor. Is that his intention? What if both joint account holders were to lose mental capacity? I came across a single lady who has a bulk of her liquid assets in joint bank accounts with her younger sister, who is also a single. She thought that there is no need for her to do estate planning, as her younger sister would take care of her and her assets. Conflict and disputes. It is common to see conflicts and disputes erupted among family members and with business partners. When a person who is head of household and running businesses passed away or lost mental capacity. Although eventually his estate matters could be settled and disputes resolved, unfortunately, those conflicts and disputes would certainly result in broken relationships and significant financial losses. Probate in the U.S. The term probate generally refers to the court procedure of validating a will and passing ownership of property from a deceased person to another. Probate is simply the process by which property of the decedent is collected. Debts and taxes are then paid. The remainder is distributed to their heirs. This process is overseen by the appropriate court in each state. Probate costs depend on the complexity of the estate and amount of professional assistance required. In some states, attorneys and personal representatives are allowed to change a percentage of the estate. In other states, they are limited to flat or hourly rates. Factors that complicate probate include the existence of minor beneficiaries, disputes among heirs, insolvency, and other circumstances requiring formal probate. It is both the cost and the time that make probate avoidance an important estate planning goal of many people. In many states, it can take a year or longer to probate an estate, even if there are no legal challenges. While the formal probate process can vary somewhat from state to state, the process involves the following steps: filing the will of the deceased with the appropriate court by the decedent's executor or personal representative. In some states, individuals pre-file their wills with a court prior to their death. Taking an inventory of the property of the deceased. Appraising the property of the deceased, using professional appraisers in appropriate circumstances, e.g. real estate. Paying all debts of the decedent, including estate taxes. Providing to the court that the decedent left a valid will, and distributing the property to their heirs. In some cases, of course, an individual may die without ever having executed a will or executing a will that is, for a variety of reasons, not valid. In such cases, probate is still necessary. Rather than distributing the property according to the wishes of the decedent, a court in such a case will order distribution according to the laws of interstate succession in each particular case. These rules govern the distribution of property when an individual dies without executing a valid will. It is also important to note that probate is not necessarily something to dread. One advantage of probate, for example, is a shortened statute of limitations for creditors who have claims against the decedent's estate. A decedent's creditors generally have a very limited period of time to submit claims against the estate once a personal representative is appointed. If they're not made in a timely fashion, they are barred. If, however, there is no probate because assets are transferred through a living trust, these statutes do not apply. The estates will have to wait longer for creditor claims and has affirmative obligations to notify potential creditors through publication of notices and local newspapers. Time and expense are the two factors cited as reasons to try to avoid probate. Probate avoidance. Executing a valid will does not mean the decedent's estate will escape probate. There are, however, many ways to avoid probate, either totally or in part. These mechanisms are sometimes referred to as will substitutes. They are simply ways to transfer property without the necessity of a will, or, therefore, probate. Common mechanisms include living trusts, gifts, and joint tenancies. Common probate avoidance tools. Tool 1. Gift. Individual transfers title to property to another person before his or her death. Joint tenancy. Descendants' interest or property passes automatically to survivor joint tenants. Pay on death accounts. Funds are immediately dispersed to survivors or beneficiary. Retirement accounts. Funds are distributed directly to named beneficiary. Life insurance. Proceeds are paid directly to beneficiary following death of insured. Trusts. Flexible vehicle that vests interest in money or property in trust subject to conditions established by the truster. Gifts. Gifts made prior to the donor's death are not subject to probate. These gifts are commonly referred to as inter vivos, Latin for during life. These reasons, such as gifts, are not subjected to probate is obvious. Once given, the subject matter of the gift is no longer part of the decedent's estate. In order to make a valid gift before death, all of the following elements must be present. 1. The intention on the part of the donor to make a present transfer. 2. Delivery of the gift, either actual or constructive. And 3. Acceptance of the gift by the recipient. All three elements must be present for the transfer to be effective. One reason gifting is a common probate avoidance tool is that gifts up to a certain amount are not subject to federal gift tax. Not only are such gifts without tax consequence, they reduce the size of the decedent's estate. This is important if the individual's estate is greater than the amount which is exempt from estate taxation. In addition, even if an individual makes a gift that exceeds the yearly maximum, that gift will not be taxable until the death of the donor, and even then, tax is only due if the total value of estate exceeds the current federal exemption level. B. Joint tenancies. Joint tenancy ownership is a terminable interest that terminates at death. When one joint tenant dies, the other joint tenant succeeds to the property without probate. Joint tenancy is an often overrated but sometimes useful probate avoidance device. It is a way for two or more people to own property together. For estate planning, its most important feature is survivorship. When one joint owner dies, the surviving owner automatically inherits the property. No probate is necessary. Joint tenancy can work well as a probate avoidance method for property an individual acquires with someone else, or if an individual transfers property they already co-own with someone into joint tenancy. But making someone else a joint tenant of property an individual owns alone, just to avoid probate, is often a bad idea. The new owner could sell his or her half interest, or the new owner's creditors could go after it. And the individual may be in trouble if he or she changes his or her mind and decides he or she wants the property to go to someone else at his or her death. For people in their 70s or 80s, there's another big disadvantage of adding someone as a joint tenant. the new owner misses out on the potentially huge income tax break. If an individual leaves property to someone upon death, the property gets a stepped-up tax basis. The basis in the amount from which taxable profit is figured. If the new owner ever sells the property, when property is transferred at death, the basis goes up to the value of the property at the decedent's death. This is good, because the higher the tax basis, the lower the taxable profit, if and when the property is sold. On the other hand, if an individual gives away property while he or she is alive by making someone a joint owner of his or her property, the tax basis of that half of the property isn't stepped up at his or her death. It stays what it was when the individual acquired the property. This means that if the property goes up substantially in value before the person's death, the owner will owe a relatively high tax bill when it is eventually sold. Note also that when property is converted from sole ownership to a joint tenancy, it may result in the gift tax to the donor. While there are exceptions, as a general rule, a husband and wife should always hold title to real property as joint tenants. C. Pay-on-death accounts. Informal bank account trusts. Pay-on-death accounts, so-called POD, allow an owner to have the proceeds distributed to a beneficiary at death without any current right to withdraw funds. Pay-on-death accounts are also known as informal bank account trusts, Totten trusts, and bank trust accounts. Using a payable-on-death or transfer-on-death account is the simplest way to keep assets held in bank and brokerage accounts from becoming part of an individual's probate estate. The assets in the account pass directly to the owner's named beneficiary and bypass probate. The court proceedings that validate the owner's will after his or her death and transfers property to the owner's heirs after debts and taxes are paid. An individual's will does not control who inherits POD or TOD accounts. With a POD/TOD account, the owner can name a new beneficiary at any time. The owner does not have to leave anything in it, and his or her beneficiary's creditors cannot grab the assets while the owner is still alive. Not all estates have POD or TOD law. Even without a law, individuals can probably make use of the accounts by doing business with a broker or bank based in a state that has one on the books. 2. FDIC insurance coverage. The Federal Deposit Insurance Corporation normally insures deposits of member financial institutions for up to $250,000 per account. If certain conditions are met, revocable trust accounts are insured up to $250,000 per owner for each qualifying beneficiary. Qualifying beneficiaries are the owner's spouse, child, grandchild, parent, or sibling. Adopted and stepchildren, grandchildren, parents, and siblings also qualify. Others, including in-laws, cousins, nieces, and nephews, friends and organizations, including charities, do not qualify. Note that living trust coverage is based on the interests of qualifying beneficiaries who would become entitled to receive trust assets when the trust owner dies. This means when determining coverage, the FDIC will ignore any trust beneficiary who would have interest in the trust assets only after another living beneficiary dies. The account title for a revocable trust account must include a term such as payable on death, in trust for, living trust, family trust, or singular language or acronym such as POD, to indicate the existence of a trust relationship. In addition, for POD accounts, the beneficiaries must be identified by name in the bank account's records. D. Retirement accounts. Retirement accounts such as IRAs and 401k were not intended to be probate avoidance devices, but can be used that way. All an individual needs to do is name a beneficiary to receive any funds still in the account at his or her death. The beneficiary will get the funds without probate. The only restriction is that to avoid penalties after age 70 and a half, the individual must withdraw a certain amount from the account every year. The amount is recalculated every year based on the individual's life expectancy. E. Life insurance. Life insurance is a contract purchased by an individual that stipulates that, upon his or her death, certain proceeds will be paid to a predetermined beneficiary or beneficiaries. These proceeds are paid directly to the beneficiary or beneficiaries and are not subject to probate. There are a number of different types of life insurance, each of which contains this probate avoidance mechanism. Gifting life insurance is a popular way of transferring wealth without significant tax implication. The gift tax is assessed on the value of the policy at the time of transfer, not on its cash value the time of the insured's death. To be an effective gift for tax purpose, the policy must be given away at least 3 years before the donor's death. F. Trusts. Trusts are flexible mechanism for transferring property, either before or after an individual's death, and avoiding probate. For example, living trusts, also known as family trusts, are formal, revocable trusts created for estate planning purposes. The owner controls the funds in the trust during his or her lifetime. Upon the owner's death, the trust generally becomes irrevocable. There are many different types of trust. Probate reform and informal probate. A. Probate reform statutes. Given the expense and time sometimes involved in probate, a number of states have taken steps to reform or streamline the probate process. In addition, most states have some form of simplified or informal probate, allowing many estates to be probated informally with minimal court supervision. In some states, this is called a small estate probate, generally for estates under $25,000. The California Probate Code, for example, provides that probate estates of $150,000 or less do not need to be probated. In some cases, the actual estate may be well in excess of $150,000, but this provision in the law can still be used. The reason is that many assets are not included in the definition of a probate estate, such as life insurance, unless it was payable to the estate, IRAs, 401ks, assets held by a living trust, and joint tenancy assets. Estates of less than $150,000 of probate assets are administered by preparing affidavits which are presented to the various institutions, banks, brokerages, etc., that hold the assets. The assets are then turned over to the person named as executor in the will, and distributed according to the will. If there is no will, the assets are distributed according to the rules of intestate succession, in other words, to the nearest relatives of the deceased. If the decedent is survived by a spouse, the spouse can file a spousal property petition with the court. The purpose of this petition is to change the titles of the assets to the survivor's spouse ownership. The petition is a simplified probate and takes much less time than a full probate. Legal fees are usually much lower for this type of petition than a full probate. B. Uniform Probate Code. In states that have adopted the Uniform Probate Code, an informal and independent probate administration is available. This informal probate process permits a probate administration to proceed unsupervised by any court. The following states have adopted the Uniform Probate Code in its entirety: Alaska, Arizona, Colorado, Florida, Hawaii, Idaho, Maine, Michigan, Minnesota, Montana, Nebraska, New Mexico, North Dakota, South Dakota, South Carolina, and Utah. C. Steps for informal probate. Informal probate can generally be reduced to the following steps. One of the heirs or personal representative or executor named in the will submits a written probate application. If the application is acceptable, the court appoints the personal representative. court or personal representative publishes a notice of probate. Personal representative notifies heirs, beneficiaries, and decedents' creditors of probate. Court issues a document authorizing the personal representative to act, usually called letters testamentary or letters of administration or letters of authority. Personal representative verifies the deadlines for probate filings and for tax returns and determines who will do the work: personal representative, attorney, or tax preparer. Personal representative lists, values, and collects decedent's property and may sell the decedent's home or other assets. Personal representative files tax returns and pays tax and other debts of the decedent and estate. Personal representative makes a full accounting to the beneficiaries and distributes the remaining property according to the will, or, if none, according to state law. A personal representative notifies the court that the probate is complete. Every state's law is different. However, so financial planners need to work in concert with the state attorneys to provide their clients with the best plan for action. D. Administrative costs. The administration costs of an informal probate can be divided into three categories: direct fees, including court filing fees, and the cost of completing an inventory of the decedent's estate. 2. Transfer costs associated with transferring assets to their beneficiaries, such as transferring title to real property. These costs are normally the same regardless of whether the estate is subject to probate. And 3. Costs associated with computing applicable estate and gift taxes, including appraisals of property. This cost is generally also the same whether or not an estate is subject to probate. Chapter 4. Myths of Estate Planning. Takeaways. There are various objections I received from many people whom I spoke to about estate planning. Basically, these objections can be categorized into 3 myths. Not for me. I don't have much and estate planning is for rich people. Family members will take care of everything. And not ready yet, or I'm too young. Myth of not for me. 1. I don't have much to give away and estate planning is only for rich people. According to HDB statistics for Q1 of 2020, the median resale prices of 3-room HBD flats range from $250,000 to $350,000, depending on their locations. As such, for anyone owning only a 3-room HDB flat, that is quite an amount to manage if he or she should pass on unexpectedly. This is an even stronger reason that these people ought to do their estate planning to ensure that the maintenance of daily living, health care, and education of their dependents are provided for, and to spare them of emotional and financial burdens for having to go through tedious and costly legal processes while their assets are frozen. 2. I'm still young. Perhaps I will think about estate planning when I'm older. Most people wrongly assume that death and loss of mental capacity can only happen to older folks, but in reality, we all know very well that such significant life events can and do happen to people of any age. Perhaps you've personally witnessed such cases, similar to the ones that impacted me. Also, when such events happen to these young adults with no estate planning, will their parents be available, healthy and competent to handle their estate matters? 3. I'm single. I may consider estate planning when I'm married with my own family. Every single adult, except those under special conditions, after working for a few years will surely own some kind of assets. As most singles have immediate or extended family members, so when these singles passed on, their family members are entitled to shares of the estate assets, according to the distribution rules of the ISA. With no estate planning, these singles will actually leaving behind much trouble for their family members, and if no rightful family members or no one comes forward to claim, then their estate assets will go to the government in accordance with the ISA rules. Myth of family members will take care. 1. My husband or wife will take care of everything. Looking at the many common disasters happening around the world, in which many families travel together, in cars, airplanes, passage liners, or ferries, suffered during accidents, some members died on the spot or a few days later, when an accident happened, while some suffered severe injuries and lost mental capacity, and a few survived. There are cases when both parents perished. In estate planning, we should consider all situations, as illustrated in Chapter 2, so as to structure a more robust and wholesome solution. Do not assume that when one of you were strike a significant life event, your spouse will be unscathed. 2. My children will take care of everything. Many people also assume that their children will always be available to take care of them and their assets. When you and your spouse are struck by significant life events, your children might not be around or available. They might have suffered in the same condition, or the same common disaster, or accident, moved overseas to work, study, or even migrated. Even if your children are available, will they be legally qualified? Will they be willing or competent for the tasks at hand? What about disagreement and dispute between your children? 3. My siblings will take care of my estate. I have heard from a few people that they're confident that their siblings will handle their estate well, because they're lawyers, bankers, professionals, and shrewd businessmen. My sincere advice is that you have to consider whether your siblings would be available, willing and competent to shoulder the tasks at hand when you need them. Will there be any conflict of interests? Will your own immediate family members who have the first rights agree for them to act? In the best case, your trusted siblings can merely act faithfully in managing and distributing your assets in accordance with the prevailing regulations. But that may not be what you wish for, including the choice of guardian for your minor children and vulnerable dependents. Even if the spouse, children, and siblings are available, willing and competent to act, the laws and regulations in Singapore require official representatives, i.e., administrator in the case of a person who died with no will, and deputy in the case of person who lost mental capacity with no LPA, to be properly appointed by court, and such court processes are tedious, time-consuming, and costly. Myth of ready or not time yet. What are you waiting to settle? Buying or selling property? Complete a business deal? Setting up or selling a company? Listing your company? Waiting till children get married? Waiting till retirement? And so many other priorities in life. Probably you know the completion dates of some of those priorities, while knowing that for many of the other priorities remain unknown or can be managed. Surely, occurrences of death and loss of mental capacity are certainly not within your control. And, if you were to be struck by one of the significant life events without estate plans in place, then you or your loved ones are very likely to have suffered the realistic problems mentioned in Chapter 3. The truthful advice is that estate planning is important to and urgently needed for all of us. While we're alive with sound mental capacity, irrespective if we are rich or poor, young or old, single or married. Indeed, the significant life events of death and loss of mental capacity do not recognize age, marriage status, and certainly have no relation to the status of wealth we have. We should see estate planning as strategically important and be willing to set priority to get it done. Chapter 5. U.S. Social Security and Medicare. Takeaways. Social Security is part of the retirement plans of almost every worker in the United States. It has been around for approximately 85 years. It is possible but difficult to contribute Social Security while working internationally. The Social Security system is designed so that there is a link between how much workers and their employers pay into the system over their working years and how much they will receive in benefits. Basically, High-wage earners receive a higher benefit payment than low-wage earners. However, the benefit formula is set up so that the lower-wage earners will get a higher percentage of their pre-retirement earnings. Workers can retire as early as 62 and get reduced Social Security benefits, or they can wait until full retirement age and receive full benefits. The full retirement age will continue to increase gradually until it reaches 67 for people born after 1959. Generally, out of every dollar a worker pays in Social Security taxes, 84 cents goes to a trust fund that pays monthly benefits to retirees and their families and to widows, widowers, and children of workers who've died, and 16 cents go to a trust fund that pays benefits to people with disabilities and their families. Social Security taxes also pay for administering Social Security at least 1% per dollar. The entire amount of taxes individuals pay for Medicare, 1.45% of an employee's earnings, goes to a trust fund that pays for some of the cost of hospital and related care of Medicare beneficiaries. Qualifications for retirement benefits. When an individual is employed and pays Social Security taxes, called FICA on some pay stubs, he or she earns Social Security credits. Most people earn the maximum of 4 credits per year. 1. How credits are earned. Workers qualify for Social Security benefits by earning credits when they work in a job or are self-employed and pay Social Security taxes, called self-employment tax for persons who are self-employed. Credits are based on the amount of a worker's earnings. Each individual's work history is used to determine his or her eligibility for retirement or disability benefits, as well as his or her family's eligibility for survivor benefits. Each year, the amount of earnings required to earn a credit increases slightly as average earnings levels increase. The credits an individual earns remain on his or her Social Security record, even if he or she changes jobs or has no earnings for a period of time. 2. Special rules for some jobs. Special rules for earning Social Security coverage apply to certain types of work. If an individual is self-employed, he or she earns Social Security credits the same way employees do. Special rules apply if an individual has net annual earnings of less than $400. Individuals in the military earn Social Security credits the same way civilian employees do. However, there might be additional earning credits under certain conditions. There are special rules about how workers earn credits for other kinds of work. Some of these jobs are domestic work, farm work, or work for a church or church-controlled organization that does not pay Social Security taxes. 3. Number of credits required. The number of credits needed to get retirement benefits depends on each individual's date of birth. Persons born in 1929 or later, for example, need 40 credits, or 10 years of work, to qualify. People born before 1929 need fewer than 40 credits, or 39 credits if born in 1928, 38 credits if born in 1927, etc. Most people earn more credits than are necessary to qualify for benefits. However, extra credits will not increase a person's benefit level. C. Amount of retirement benefit. An individual's benefit amount is based on his or her earnings averaged over most of the individual's working career. Higher lifetime earnings result in higher benefits. If an individual has some years of no earnings or low earnings, his or her benefit amount may be lower than if he or she had worked steadily. An individual's benefit amount also is affected by his or her age at the time he or she starts receiving benefits. Individuals who begin receiving retirement benefits at age 62, the earliest possible retirement age, will have a lower level of benefits than if they had waited to a later date to retire. 1. Full retirement age. Because of longer life expectancies, the Social Security law was changed in 1983 to increase the full retirement age in gradual steps, until it reaches age 67. This change began in the year 2003 and affects people born in 1938 and later. The current rules are shown on the table below. 2. Early retirement. Individuals can elect to start their Social Security benefits as early as age 62, but the benefit amount they receive will be less than their full retirement benefit. If individuals elect to take early retirement, their benefits will be permanently reduced based on the number of months they will receive checks before they reach full retirement age. If an individual's full retirement age is 65 and 2 months, the reduction for starting his or her Social Security at age 62 is about 20.8%. At age 63, it's about 14.4%. At age 64, it's about 7.8%. If an individual's full retirement age is older than 65, that is, he or she was born after 1937, the individual will still be able to take his or her retirement benefits at age 62. But the reduction in his or her benefit amount will be greater than it is for people born before 1938. For example, if an individual's full retirement age is 67, the reduction for starting his or her benefits at 62 is about 30%. At age 63, it's about 25%. At age 64, about 20%. At age 65, about 13.33%. And at age 66, about 6.23%. As a general rule, early retirement will give an individual about the same total Social Security benefits over his or her lifetime, but in smaller amounts to take into account the longer period over which he or she will receive them. Some people stop working before they reach age 62. In that case, it's important to remember that during years with no earnings, they will miss the opportunity to increase their benefit amount by replacing lower earning years with higher earning years. 3. Disability retirement. Sometimes poor health forces people to retire early. If an individual is unable to continue working because of poor health, he or she should consider applying for Social Security disability benefits. The amount of the disability benefit is the same as a full, unreduced retirement benefit. If an individual is receiving Social Security disability benefits when he or she reaches full retirement age, those benefits will be converted to retirement benefits. 4. Delayed retirement. Not everyone retires at full retirement age. An individual may decide to continue working full-time beyond that time. In that case, the individual who elects to continue working can increase his or her Social Security benefits in 2 days. Each additional year an individual works adds another year of earnings to his or her Social Security record. Higher lifetime earnings may result in higher benefits when he or she eventually does retire. In addition, an individual benefit will be increased by a certain percentage if he or she chooses to delay receiving retirement benefits. These increases will be added in automatically from the time the person reaches his or her full retirement age until the individual starts taking his or her benefits or reaches age 70. The percentage varies depending on each individual's year of birth. For example, an individual born in 1943 or later will receive an additional 8% per year, or 2/3 of 1% per month, and the amount of his or her benefit for each year he or she delays signing up for Social Security beyond his or her full retirement age. This is shown more fully below. D. Choosing a retirement date. If an individual plans to start his or her retirement benefits after age 62, it is a good idea to contract Social Security in advance to see which month is best to claim benefits. In some cases, the choice of retirement month could mean additional benefits. It may be advantageous, for example, to have Social Security benefits start in January, even if the recipient does not plan to retire until later in the year. Depending on an individual's earnings and benefit amount, it may be possible for him or her to start collecting benefits even though he or she continues to work. Under current rules, many people can receive the most benefits possible with an application that is effective in January. If an individual is not working, or the person's annual earnings are under the earnings limit, or he or she plans to start collecting Social Security when he or she turns 62, the individual should apply for benefits 3 months before the date he or she wants his or her benefits to begin. E. Social Security benefits. There are 5 major categories of benefits paid for through Social Security taxes: retirement, disability, family benefits, survivors, and Medicare. 1. Retirement. Benefits are payable at full retirement age, with reduced benefits available as early as age 62 for anyone with enough Social Security credits. The full retirement age is 65 for persons born before 1938. The age gradually rises until it reaches 67 for persons born in 1960 or later. People who delay retirement beyond full retirement age get special credit for each month they do not receive a benefit until they reach age 70. 2. Disability. Benefits can be paid to people at any age who have enough Social Security credits and who have a severe physical or mental impairment that is expected to prevent them from doing substantial work for a year or more, or who have a condition that is expected to result in death. Generally, earnings of $1,180 or more per month for 2018 are considered substantial. The disability program includes incentives to smooth the transition back into the workforce, including continuation of benefits and health care coverage while a person attempts to work. 3. Survivors' benefits. Certain family members of a deceased worker may be able to get survivors' benefits. Even though the deceased worker did not work long enough to qualify for retirement benefits, dependent children may get survivors' benefits if the deceased person had 1.5 years of work, or 6 credits, in 3 years before his or her death. The benefits could continue until they reach age 18. A widow or widower may be able to get benefits. Widows or widowers can begin receiving benefits at age 60 or age 50 if disabled. If an individual is receiving widows or widowers, including divorced widows or widowers, benefits, he or she can switch to his or her own retirement benefits, assuming he or she is eligible and his or her retirement rate is higher than the widower. A widower can begin receiving one benefit at a reduced rate and then switch to the other benefit at an unreduced rate at full retirement age. The rules vary depending on the situation. 4. Benefits for family members. If an individual is receiving retirement benefits, some members of his or her family also can receive benefits. Those who can include a decedent's wife or husband age 62 or older, a decedent's wife or husband under age 62 if she or he is taking care of her or his child who is under the age of 16 or disabled, the decedent's former wife or husband age 62 or older, children up to age 18, children age 18 through 19 if they are full-time students through grade 12, and children over the age of 18 if they are disabled. 5. Spouse's benefits. A spouse receives 1/2 of the retired worker's full benefit unless the spouse begins collecting benefits before reaching full retirement age. In that case, the amount of the spouse's benefit is permanently reduced by the percentage based on the number of months before he or she reaches 65. For example, if an individual's spouse begins collecting benefits at age 64, the benefit amount would be about 46% of the individual's full benefit. At age 63, it would be about 42% and 37.5% at age 62. However, If the spouse is taking care of a child who is under age 16 or disabled and receiving Social Security benefits, the spouse gets full benefits regardless of age. If an individual is eligible for both his or her own retirement benefits and for benefits as a spouse, Social Security will always pay the individual's own benefit first. If the benefit as a spouse is higher than his or her retirement benefit, he or she will get a combination of the benefits equaling the higher spouse benefit. 6. Maximum family benefits. If an individual has children eligible for Social Security, each will receive up to 1/2 of that individual's full benefit. But there is a limit to the amount of money that can be paid to a family. If the total benefits due a spouse and children exceed this limit, their benefits will be reduced proportionately. The individual's benefit will not be affected. 7. Benefits for a divorced spouse. A divorced spouse can get benefits on a former husband or wife's Social Security record if the marriage lasted at least 10 years. The divorced spouse must be 62 or older and unmarried. If the spouse has been divorced at least 2 years, he or she can get benefits, even if the worker is not retired. However, the worker must have enough credits to qualify for benefits and be age 62 or older. The amount of benefits a divorced spouse gets has no effect on the amount of benefits a current spouse can get. F. Tax treatment of benefits. A Social Security Administration micro-simulation model projected that 56% of families receiving Social Security benefits will pay income tax on their benefits in 2016. Generally, only people who have substantial income, in addition to their Social Security, are affected by this tax provision. Each January, individuals will receive a Social Security benefit statement, showing the amount of benefits they received in the previous year. This statement can be used when completing federal income tax results to see if any benefits are subject to tax. Although recipients are not required to have federal taxes withheld, some people may find it easier than paying quarterly estimated tax payments. To have federal taxes withheld, an individual must file IRS Form W-4V with the Social Security Administration. Medicare benefits. Medicare is the United States health insurance program for people age 65 or older. Certain people with disabilities who are under age 65 and people of any age who have permanent kidney failure. It provides basic protection against the cost of health care, but it does not cover all medical expenses or the cost of most long-term care. Many people think that Medicaid and Medicare are two different names for the same program. Actually, they're two different programs. Medicare is designed to help with long-term care for the elderly, while Medicaid is a state-run program designed primarily to help pay for health care costs for the poor. The federal government helps pay for Medicaid, but each state has its own rules about who is eligible and what is covered under Medicaid. Some people qualify for both Medicare and Medicaid. Types of benefits. These are 4 parts of Medicare. They are hospital insurance, medical insurance, privately purchased supplemental insurance, and Medicare Part D, which provides prescription drug coverage. Hospital insurance, Part A. Medicare hospital insurance can help pay for inpatient care in a hospital or skilled nursing facility following a hospital stay, home health care, and hospice care. Except for home health care, each is subject to a benefit period, which measures an individual's use of services covered by Medicare Part A. A benefit period starts the day an individual enters a hospital. It ends when an individual has been cut out of the hospital or other facility primarily providing skilled care for 60 days in a row. If an individual remains in such a facility, a benefit period ends when they have not received any skilled care there for 60 days in a row. There is no limit to the number of benefit periods for hospital and skilled nursing facility care, but special limits do apply to hospice care. 2. Medical insurance, Part B. Anyone who is eligible for free Medicare hospital insurance, Part A, can enroll in Medicare medical insurance, Part B, by paying a monthly premium. If an individual is not eligible for free hospital insurance, he or she can buy medical insurance without having to buy hospital insurance. If he or she is age 65 or older and a citizen or lawfully admitted alien who has lived in the U.S. for at least 5 years, the medical insurance premiums are much less costly than the hospital insurance premiums. In addition to the monthly premiums, there are other out-of-pocket costs for Medicare. These are the amounts an individual pays when he or she actually receives medical services, known as deductibles and coinsurance. For example, if an individual is hospitalized, he or she will be required to pay a deductible amount, and may have to pay coinsurance amounts, depending on the length of the hospital stay. If an individual receives medical services from a doctor, he or she will pay a yearly deductible amount, as well as a coinsurance amount for each visit. The monthly premiums, deductibles, and coinsurance for Medicare change each year. If an individual is already getting Social Security retirement or disability benefits or railroad retirement checks, he or she will be contacted a few months before he or she becomes eligible for Medicare and given the information he or she needs. The individual will be automatically enrolled in Medicare Parts A and B. However, because the individual must pay a premium for Part B coverage, he or she does not have the option of turning it down. 3. Privately purchased supplemental insurance, Medicare Part C. Known as Medicare Advantage plans, Part C is paid out of pocket by program participants. Medicare Advantage plans provide all of the Medicare Part A hospital insurance and Medicare Part B medical insurance coverage, and generally offer additional benefits such as vision, dental, and hearing. 4. Prescription drug coverage Medicare Part D. Anyone who has Medicare hospital insurance Part A, Medicare insurance Part B, or a Medicare Advantage plan Part C is eligible for prescription drug coverage Part D. Joining a Medicare prescription drug plan is voluntary, and participants pay an additional monthly premium for the coverage. Individuals can wait to enroll in a Medicare Part D plan if they have other prescription drug coverage, but if they do not have prescription coverage that is, on average, at least as good as Medicare prescription drug coverage, they will pay a penalty if they wait to join later. They'll have to pay this penalty for as long as they have Medicare prescription drug coverage. People who become newly entitled to Medicare should enroll during their initial enrollment period. After the initial enrollment period, the annual coordinated election period to enroll or make provider changes will be November 15th through December 31st each year. There also will be special enrollment periods for the same situations. B. Eligibility. Most people age 65 or older who are citizens or permanent residents of the United States are eligible for Medicare hospital insurance, Part A, without paying a monthly premium based on their own or their spouse's employment. Individuals are eligible at age 65 if they receive or are eligible to receive Social Security benefits on their own work record or on someone else's work record as a spouse, divorced spouse, widow, widower, divorced widow, divorced widower, or parent. Or they receive or are eligible to receive railroad retirement benefits, or they or their spouse, living or deceased including divorced spouses, worked long enough in a government job where Medicare taxes were paid. If individuals do not meet these requirements, they can still get Medicare hospital insurance by paying a monthly premium if they are a citizen or a lawfully admitted alien who has lived in the U.S. for at least 5 years. Before age 65, individuals are eligible for premium-free Medicare hospital insurance if They have been entitled to Social Security disability benefits for 24 months. This includes widows, widowers, and children who receive benefits because of disability, or they receive a disability annuity from the Railroad Retirement Board and meet certain conditions, or they, their parents or spouse, living or deceased, including a divorced spouse, have worked long enough in a government job where Medicare taxes were paid, and they meet the requirements of the Social Security Disability Program. C. Initial enrollment period. When individuals first become eligible for hospital insurance Part A, they have a 7-month period to sign up for medical insurance Part B. This is called their initial enrollment period. If an individual is eligible at age 65, his or her initial enrollment period begins 3 months before his or her 65th birthday, which includes the month he or she turns 65 and ends 3 months after their birthday. If an individual is eligible for Medicare based on disability or permanent kidney failure, his or her initial enrollment period depends on the date his or her disability or treatment began. If an individual is already receiving retirement or disability benefits, he or she will be automatically enrolled in Part B. When he or she becomes entitled to Part A, however, because the individual must pay a premium for Part B coverage, he or she will have the option of paying for the coverage or turning it down. D. Coverage by employer-based plan. If an individual is 65 or older and is covered under a group health plan either from his or her own or his or her spouse's current employment, he or she has special enrollment period in which to sign up for Medicare Part B. This means that he or she may delay enrolling in Medicare Part B without having to wait for the general enrollment period or pay the 10% premium surcharge for late enrollment. The rules allow an individual to enroll in Medicare Part B any time while he or she is covered under the group health plan, or enroll in Medicare Part B during the 8-month period that begins with the month his or her group health coverage ends, or the month employment ends, whichever comes first. If an individual enrolls in Part B while covered by an employer-provided group health plan or during the first full month when covered by that plan, he or she has the option to have his or her health coverage begin the first day of the month he or she enrolls, or to delay coverage until the first day of any of the following 3 months. If an individual enrolls during any of the 7 remaining months of the special enrollment period, his or her coverage will begin the month after he or she enrolls. Special enrollment period rules do not apply if employment or employer-provided group health plan coverage ends during the initial enrollment period. If an individual does not enroll by the end of the 8-month period, he or she will have to wait until the next general enrollment period, which begins January 1st of the following year. People who receive Social Security disability benefits are covered under a group health plan from either their own or a family member's current employment, also have special employment period and premium rights that are similar to those for workers age 65 and older. Chapter 6. Lasting Power of Attorney in Singapore. Takeaways. In this chapter we will take a deeper dive into how it works in Singapore, but consider that powers of attorney or agent appointments are jurisdiction specific. This is where we have an international team. It's very important because a power of attorney would be required for each jurisdiction in which you have assets, residency, or domicile. Remember that even within the U.S., each state may have different rules that impact on the power of attorney and therefore require careful consideration. Governing law. The Mental Capacity Act, first enacted October 17, 2008, is the governing law for matters related to lasting power of attorney in Singapore. Purpose of MCA. The fundamental purpose of the Mental Capacities Act is to protect people who lack mental capacity and are unable to make decisions for themselves. Provisions of LPA. LPA is a legal document specified in the MCA that allows a person to apply from the office of a public guardian, for him to appoint one or more persons called donees to make decisions on his behalf when he lacks mental capacity or has lost mental capacity. Best interests. MCA mandates that donees appointed by such a person while having sound mental capacity in his LPA and deputies appointed by court for a person with no LPA and who has lost his mental capacity must act or make decisions on behalf of such a person in his best interest. There are two areas of decisions donees can make for the donor who appointed them and who has suffered loss of mental capacity. 1. Personal welfare. Decisions on all personal welfare matters including health care. 2. Property and affairs. Decisions relating to financial affairs and property matters such as managing his bank account and property. Although it is not compulsory for anyone to apply for LPA, you are strongly advised to apply as soon as possible while having sound mental capacity. Definition of mental incapacity. MCA defines that a person who suffers mental incapacity as a person lacks capacity in relation to a matter if at any time he is unable to make a decision for himself in relation to the matter because of an impairment of or disturbance in the functioning of the mind or brain. It further defines that a person is unable to make a decision for himself if he is unable to understand the information relevant to the decision, retain that information, use or weigh that information as part of the process of making the decision, or communicate his decisions, whether by talking, using sign language, or any other means. The law requires that a prescribed medical report for activation or deactivation of lasting power of attorney form, duly completed by a registered medical practitioner, must be submitted to OPG to certify that a person has lost mental capacity in order for the appointed donees to exercise their power to make decisions for him. Roles of the Office of Public Guardian. Office of the Public Guardian, or OPG, under the Ministry of Social Security and Family Development, is responsible for all matters related to MCA and LPA. In this aspect, it safeguards the interest of persons who lack mental capacity and supports proxy decisions makers, such as donees and court-appointed deputies, within the framework of the MCA. Some of the OPG's functions are: 1. Approving of all LPA applications. 2. Maintaining registers for LPAs, court orders of appointed deputies, and professional deputies admitted. 3. Dealing with all matters related to donees and deputies. LPA certificate issuers. Categories of certificate issuer. When completing your LPA application form for submissions, the LPA form has to be witnessed, certified and signed by an authorized LPA CI. 3 categories of professionals as listed on OPG website can be engaged as the CI for your LPA. They are: 1. The accredited medical practitioner certified for LPA. 2. Psychiatrists. And 3. Lawyers certified for LPA. Important role of the CI. The CI signs on the LPA form as a witness for the donor to certify that the donor has the mental capacity to make the LPA, understands the purpose of the LPA and the scope of authority granted to donees. The CI also ensures that there is no fraud or undue influence used to induce the donor to make the LPA. In order to prevent a conflict of interest, an authorized professional is disqualified from giving an LPA certificate if that person is: 1. A family member of the donor. 2. A donee of that power. 3. A donee of any other lasting power of attorney which has been executed by the donor, whether or not it has been revoked. 4. A family member of a donee, with subparagraphs 2 and 3. 5. A director or an employee of a person other than an individual acting as a donee, within subparagraphs 2 and 3. 6. A business partner or an employee of the donor or donee with subparagraphs 2 and 3. 7. An owner, a director, a manager, or employee of any care facility where the donor lives or is cared for when the instrument is executed. Or 8. A family member of a person with subparagraph 7. Donee includes a replacement donee. Criteria for donor. Legal capacity. The law requires that a person, donor, who is applying for LPA must be 21 years of age or older, and who is with sound mental capacity. However, if he is an undischarged bankrupt at the time of LPA application, he can only appoint donees for making decisions on personal welfare matters where he lacks mental capacity. Who can apply for LPA? Types of donee. In the LPA application form, a donor can authorize for each of the donees he appoints the types of decisions he wants them to make in the event that he loses his mental capacity. Donees are numbered in numerical order, donee 1 and donee 2. Each donee is then assigned one of the following types of power: personal welfare, property and affairs, or personal welfare and property affairs. Where multiple donees are appointed for the same power listed above, the donor has to indicate if they are to act. 1. Jointly. All decisions must be agreed by both donees. If they're unable to agree on a particular issue, then the donee cannot act on your behalf for that issue. 2. Jointly and severally, i.e., any one of your donees can make a decision for you. Replacement donee. A donor can appoint replacement donees so that in the event when a donee is unable to act, the replacement donee can take his place. A donor has to decide for each replacement donee one of the following conditions in order for him to act. 1. Any donee who is unable to act. 2. Any donee with personal welfare powers who needs replacing. 3. Any donee with property and affairs powers who needs replacing. 4. A specific numbered donee, e.g., donee 1 or specific donee by name. Powers donee and deputy. Powers of donee. Donees who are given powers as stated in the LPA, either personal welfare or property and affairs or both, have the full powers for the respective area of decisions, as stated in the MCA. They are to exercise such powers in accordance with the Code of Practice, Mental Capacity Act, issued by OPG. Details of these powers are appended at the end of this chapter. Powers and deputies. A deputy is a person appointed by the court to make certain decisions on behalf of a person who lacks mental capacity, but who has not made an LPA. Deputies can only make decisions according to the specific powers ordered or approved by the court. These may include all or part of those for donees, under personal welfare and property and affairs. However, court may order other powers outside of that for donees, as deemed necessary and appropriate. This is allowed for within the scope of MCA. Paid professional deputy and donee. Applicable for individuals who are to make LPA but unable to find suitable family members, relatives, or friends as donee. Also allows courts to appoint deputy when no family member or caregiver is able or willing to take on the appointment. Mental capacity. Regulation 2018. The social development trend in Singapore in the last 3 decades shows an increase in the number of late marriages, small families, couples with no children, and singles. This has resulted in many Singapore residents having difficulty finding suitable relatives to be their donees. Hence, the government introduced a system of paid professional donees and deputies in 2018, and published this regulation, which came into operation on September 1st of 2018. Eligible professionals. Registered lawyers, accountants and doctors, and qualified healthcare professionals and social workers who have attended required training courses on duties and responsibilities of professional deputy. Personal welfare and property and affairs can volunteer to register as individual professional deputy with OPG. Licensed trust company can also register as professional deputy for appointment with powers for donee property and affairs. Professional donees and deputies. Individuals applying for LPA can appoint registered professional deputy as their donees, with powers for personal welfare and/or property and affairs. Likewise, family members of a person who lacks mental capacity, but who have not made LPA, also can engage professional deputy and seek court orders to appoint him as deputy for this person. Types of LPA application. There are two types of LPA applications, namely, 1. The LPA Form 1. This is for donors who want their donees to make decisions only to apply to themselves, particularly on property and affair matters. 2. LPA Form 2. LPA Form 2 is for donors who wish to appoint either more than 2 donees, more than 1 replacement donee, or grant specific and customized powers to donees which cannot be addressed in LPA Form 1, such as to make decisions that apply beyond and more than the donor. For example, to provide and care for his dependents and even institutions and good causes of his concern. The law mandates that only practicing lawyers can draft Section 4 of the LPA Form 2. Considerations in LPA application. 1. Form 1 or Form 2. You need to consider if and when you lack mental capacity, do you have dependents, other individuals, or causes that you're obliged to provide the care for, besides yourself? If the answer is no, then you only need to apply for LPA Form 1. Otherwise, you have to apply for LPA Form 2. 2. Choices of donees. There are different considerations for choosing donees: personal welfare and donee, property and affairs. A. Donee personal welfare has to be individuals aged 21 and above, as required by law. This should be a person who knows you well, includes your preferences for health care and daily living matters, and truly is willing to take care of you. B. Donee property and affairs. This can be individuals or licensed trust company. These individuals must be aged 21 and above, and must not be undischarged bankrupts. When you appoint individuals for this power, you should take into consideration their availability, i.e., not very much older than you, not likely to be out of the country for a long period of time, not persons staying overseas. 2. Trustworthiness, i.e., good character with honesty and integrity. 3. Competence, i.e., responsibly educated and experienced. 4. Relationships, e.g., relatives who may not be impartial, and business partners may not be suitable as there could be conflicts of interest. Procedures for application of LPA. All adult Singapore residents, permanent residents, and foreigners in Singapore can submit their LPA applications to OPG for approval. After confirming that all information is in order, OPG will issue a notice of registration letter to the applicant concerned. This process generally takes 8 to 10 weeks, including 6 weeks of mandatory waiting period. All LPA application forms, either Form 1 or 2, must be signed and witnessed by an authorized CI. In addition, for LPA Form 2 application, the Section 4 thereof must be drafted by a practicing lawyer. The CI signs on the LPA form as a witness for the donor, to certify that the donor has the mental capacity to make an LPA. He has to ensure that the donor understands the purpose of the LPA and the scope of authority granted to his donees. The CI also has to ensure that there is no fraud or undue influence used to induce the donor to make the LPA. Currently, OPG charges an application fee for all submissions of LPA applications as shown in the table below. Problems without LPA. There are many tangible and intangible problems for a person who suffers from a lack of mental capacity, but with no LPA. 1. A court-appointed deputy. The law requires that a deputy or deputies to be appointed by court to make decisions for a person who lacks mental capacity, but with no LPA. Family members of this person have to decide and nominate one among them who is willing and also has the support of all other family members to apply as deputy. What if there is no agreement among the family members as to who should be the potential deputy? Or what if no one is willing to step forward? Such situations could result in great stress to family members and even disputes that would strain their relationship. Eventually, whoever is the deputy appointed by court, he or she may not be the person of your choice. 2. Lengthy court process and costly legal fees. The court requires all eligible family members to submit written consent to the appointment of whoever that chosen person to be appointed as deputy. And, if the chosen person is not one of the immediate family members, he has to satisfy the presiding judge on the suitability of his appointment. Whoever is the person to apply as deputy also has to justify the powers to be granted. Invariably, a lawyer has to be engaged to handle the application of a deputy. Indeed, the process of application is tedious, time-consuming, and costly. The entire process from submission of application till final approval is granted typically takes 3 to 4 months. If there's no objections nor disputes, the court fees and lawyer fees can total $6,000 to $10,000. 3. Limited power and burdensome on deputy. The powers of donees appointed by the donor in his LPA is rather extensive and discretionary, so long that decisions made or actions taken by the donees are in compliance with the MCA and are for the best interest of the donor, whereas the potential deputy has to apply for relevant powers required to meet the circumstances and needs of the person who lacks mental capacity. Subsequently, if additional powers are needed for the deputy, for example, to sell a property of the person whom he is deputizing, he has to go through the court process again to apply for that power. In addition, the deputy is also required to submit a periodic report on all the decisions made by him for the powers granted, with proper financial records. 4. Assets are frozen. From the time a person loses his mental capacity until a deputy is appointed by court to make decisions for him, all his assets, including bank accounts and investment accounts, are frozen. A conservative estimate of this period is around 6 months. This duration can be much longer for complicated cases. Certainly, this will pose significant stress to his family members, particularly the dependents. 5. Financial losses. Meanwhile, his property cannot be sold or rented out. Expiring leases to tenants cannot be renewed. Liquidation of his assets, including real properties, shares, and stocks, or purchase of investment assets, could also miss market opportunities that occur during this period. And for business persons, particularly those of solemnly owned businesses or sole proprietorship companies, the businesses would be badly affected or might have to be closed down. All these will result in significant financial losses. Suffering to family. If the person who lacks mental capacity does not have LPA and happens to be the sole bread earner of the family, then with his bank accounts frozen, cash flow needs for his family will be curtailed. This will have a significant impact on the daily living of his family members and dependents, consequently resulting in severe suffering to them. His own well-being during this period will be adversely affected also. Chapter 7. Conservatorship and Guardianship in the U.S. Takeaways. Conservatorship. When an adult becomes incapacitated and has not made other arrangements for care or the management of affairs, family often considers conservatorship. It is a legal process in which a family member or other interested person petitions the appropriate court, depending on the state in which the object of motion resides, to have someone named conservator of the person. The person named conservator is responsible for the personal well-being of the conservatee. The same person may or may not also be responsible for the conservatee's estate. This process, which in some states is referred to as probate conservatorship, is reserved only for persons 18 years or older. When a minor is involved, the process is normally referred to as a guardianship. Guardianship. Similar to conservatorship, it is when a person is in need of protection both for his or her physical and material well-being. It is usually used when the individual in need or care is a minor. As well as conservatorships, the rules are mandated by state law. The minor is normally referred to as a ward. Any interested party can file a petition with the appropriate court. In most states, the probate court, asking for a guardian to be appointed. In some states, a minor above a certain age, i.e. 14 or older, can also file a petition asking for a guardian to be appointed. Before a formal hearing, the court will typically appoint someone called a guardian ad litem to meet with the ward and make an investigation for the court. A formal hearing will then be held to determine whether a guardian should be appointed, and if so, who should hold that position. In some states, minors above a certain age have the right to request the court to appoint someone other than the person stipulated in the will as guardian. If appointed, a guardian may be paid from the ward's estate, depending on all of the circumstances. Conservatorship. An overview. A. Basis of conservatorship. A court will only order a conservatorship when it is clear that the absentee one, the proposed conservatee, will be unable to care for themselves. The specific requirements vary from state to state, but it must generally be shown that the individual is unable to satisfy his or her basic needs absent appointment of a conservator. In certain cases, an individual may decide he or she would like another person to assume responsibility for his or her care, and or the individual's estate. This is referred to as a voluntary conservatorship. B. Appointment of conservator. An application for conservatorship will set forth the reasons why a conservatorship should be ordered. The person making the application may or may not ask to serve as the conservator. Judges have a great amount of discretion in appointing a conservator. There is, however, a general preference to appoint someone with a close relationship to the conservatee, namely the following: a spouse, an adult child, a parent, a sibling. In appropriate cases, a judge will appoint someone else to act as conservator. Some states have a process for the appointment of a so-called public conservator, who is a government official that acts on behalf of a number of conservatees. This is generally done when the conservatee does not have any family members who would be appropriate for the job. When a court appoints a conservator of a person, that person may or may not also serve as conservator of the estate. The conservator of the estate is responsible for the management of the conservatee's assets, while the conservator of the person is responsible for the day-to-day decisions regarding the personal care of the conservatee. The specific powers authorized by the court to any conservator are set forth in the letters of conservatorship issued by the court ordering the conservatorship. C. Decisions on behalf of conservatee. A conservator of the person must make a variety of decisions regarding the well-being of the conservatee. Powers regarding the care of the conservatee normally include the following: making living arrangements for the conservatee, ensuring that the conservatee has food, providing for medical attention, and providing for other basic needs such as transportation and recreation. D. Conservator of the estate. The conservator of the estate generally has the following obligations: manage the conservatee's finances, protect the conservatee's income and property, take an inventory of the estate, develop a plan to ensure that the needs of the conservatee are met, ensure that the bills are paid, invest funds if appropriate, ensure that the conservatee is receiving all benefits, government and private, to which he or she is entitled. Make sure all taxes are paid in a timely fashion. Keep detailed and accurate financial records, and make required financial reports to the court or other persons as required. 1. Inventory of estate property. An individual chosen to be conservator of an estate must make and keep a list of what the estate owns. This includes doing the following: locating property that is part of the estate, ensuring that the estate's property is put into the name of the conservator of the estate, determining the value of estate property, maintaining insurance as necessary for certain estate property, and filing the inventory and appraisal with the court within the time prescribed by the applicable state law. The last step is necessary, since unlike the agent designated through a power of attorney, a conservator is subject to the direction of the court that makes the appointment. The court appointment and oversight helps to ensure that the conservator is carrying out his or her duties and acting in the best interest of the conservatee. Fiduciary duty. Likewise, the conservator of the estate has a fiduciary obligation to act in the best interest of the conservatee. He is prohibited from self-dealing and may not commingle the funds or assets of the conservatee with his own or any other party. There are also specific restrictions, such as borrowing money from the estate or giving away any part of the estate. 3. Record keeping and accounting. A conservator must keep detailed and accurate records of all transactions relating to the estate, including funds received from Social Security, retirement plans, or other sources, payments made on real estate or for insurance, or any other expenses related to the estate. A detailed accounting is required, which includes all monies received and spent, the purpose for which they were received and spent, and the date and purpose for each transaction. The accounting must be filed with and approved by the court on a periodic basis as mandated by applicable state law. E. Conservatee's rights. A conservatee retains certain rights regardless of his or her present incapacity. These are set out by each state in statute and normally include the following: make a change or will, unless they lack required testamentary capacity; receive mail; retain a lawyer; petition the court to remove his or her conservator; petition the court to end the conservatorship; and make his or her own health care decision, if competent to do so. 2. Guardianship. Death of both parents. If both parents die, any minor children will obviously have to be placed in the care of a guardian. In the case of the death of both parents, the parent's will may have a provision naming a guardian. Even when nominated by a deceased parent, a court must still approve the selection of the guardian. Anything that can have an effect on the child's physical, intellectual, moral, or spiritual well-being is considered by the court in selecting a guardian. The presumption, however, is generally in favor of appointing the person or persons nominated in the parent's will. This is one of the many reasons it is so important that adults have a valid will in place. The importance magnifies when they marry and have children. B. Death of one parent. When the parents are married and one dies, the surviving spouse generally retains sole custody of any minor children without any court involvement. The only time the courts normally become involved in this situation is if someone challenges the guardianship and seeks custody of the child. In the absence of evidence that the surviving parent is unfit, the courts will rarely intervene. Where parents are separated or divorced and the custodial parent dies, The surviving parent has custodial rights supervisor to those guardians named in the deceased parent. A natural parent's custody rights cannot be determined by the death of the other parent. If the surviving natural parent is incompetent, unfit, missing, or unwilling to care for the child, the court can award custody to a guardian named by the deceased parent. Additionally, if a guardian named by the deceased parent has provided essential parenting for the child, he or she may have standing to challenge a competent, interested natural parent's rights, but the strong rights of the natural parent are very difficult to defeat. C. Powers of a guardian. A guardian of a minor may have some or all of the powers normally held by a parent. The two types of guardianships of minors are general guardianships and limited guardianships. 1. General guardian. A general guardian is typically appointed when the minor has no living parents. A general guardian can also be appointed when the parents have abandoned the child and cannot be located. A general guardian has all the legal powers of a parent, but is not legally required to provide for the minor out of his or her own funds. 2. Limited guardian. In a limited guardianship, the proposed guardian and the custodial parent decide what powers the guardian will exercise, and both must sign a limited guardianship placement plan. The plan tells the court the reason for the guardianship, how long it will last, how the child will be supported, and how the parent will stay in contact with the child. The placement plan must be approved by the court. If the parent does not keep the agreement made in the plan, the guardian or another person named by the court may ask the family division of the circuit court to terminate the parent's rights to the child and make the child available for adoption. A parent must go to court to end a limited guardianship. In some cases, the court may decide that the parent is not ready to have the child back, and may set some conditions for the parent to meet before the child is returned. If a guardian is unable to keep the child, the guardian must petition the court to appoint someone else. D. Conservatorship of a minor's estate. Conservatorship provides for management and distribution of money and property left to children until they reach the age of 18. One person can serve as both the conservator and the guardian, or different people can serve the two roles. The need for a conservatorship can be avoided by not leaving large sums of money directly to children. For example, parents can choose to create a family trust to be used to care for the needs of their children in the event of their death. For example, insurance proceeds can be paid into the trust if both parents die. Savings accounts in the parents' names can be directed to the trust. The parents select and name trustee to manage the assets. They also prepare a trust agreement giving the trustee the power to manage the trust assets and use the income for the children's benefit. The trust agreement is effective upon the death of both parents. A trust can avoid the inflexibility of conservatorship that passes assets to the children at age 18, when the child may not be financially responsible enough to handle a large inheritance. E. Providing for a disabled child. Parents of disabled children face special hurdles in estate planning. If the child will never be able to care for himself, the parents have to be concerned about both financial support and living arrangements. One alternative is to leave everything to the other children, if any, and instruct them to care for the disabled child. Depending on the level of disability and the interests of the other children, however, this plan may not work. Another alternative is to leave some assets outright to the non-disabled children and some assets in trust to provide income for the support of the disabled child. However, leaving too much money for the child might render the disabled child ineligible for certain government benefits, such as health coverage. The laws of the child's state of residence need to be consulted carefully. In some cases, a trust can be drafted to ensure that the child remains entitled to government benefits. This is one area where an experienced attorney can be helpful. Chapter 8. Wills and Will Writing. Takeaways. Many equate estate planning with getting a will. A will does not equate to estate planning. This chapter considers wills for Singapore residents with Singapore CITES assets, but the principles are applicable to most common law jurisdictions. Like many of the estate planning tools in this book, wills are very jurisdiction specific. So you may need a will for each jurisdiction where you have assets, residency, or domicile. It is unusual for one person to know everything. This means that those of you that live and work internationally need to work with a team with members who are qualified to advise on the jurisdictions in question. This also applies to the U.S., where each state may have different rules to consider. Governing law. The governing law for will writing, and administration of a deceased person, estate are such. 1. The Wills Act. This act sets out the rules for will writing, requirements of a valid will, and revocation of wills. 2. Intestate Succession Act. This act sets out the rules for distribution of estate assets of a person who passed away without a valid will. This act is also applicable for assets a person legally entitled to but are not addressed in his will, and his CPF savings if he did not make CPF nomination or there is no surviving nominee. Details of ISA rules are as shown in the appendix to this chapter. 3. Probate and Administration Act. This act sets out the terms and procedures for the grants of probate, i.e. with will, letters of administration, i.e. with no will, letters of administration with will annexed, i.e. original will or appointed executor not available, roles of the public trustee, and power of High Court and Family Court. 4. Administration of Muslim Law Act. While in compliance with the Wills Act and Probate and Administration Act, Muslim domicile in Singapore must dispose of his property in accordance with the provisions of and subject to the restrictions imposed by the school of Muslim law professed by him. 2 exceptions for Muslims writing their wills are: A. Faraid complete will must not cover more than a third of the deceased's estate. B. Cannot include in his will persons who are already beneficiaries under Faraid, as this would be giving them more benefits than that specified in the inheritance certificate issued by the Syria court. These laws mentioned above are applicable for persons 1. Domiciled in Singapore and possessed beneficiary of property, whether movable or immovable, or both, situated in Singapore, or 2. Domiciled outside Singapore and possessed beneficially of immovable property situated in Singapore. Wills Registry. The Wills Registry has been managed by the Singapore Academy of Law since May 4th of 2020. Previously, it was under the purview of the Public Trustee's Office with the Ministry of Law. The Wills Registry is a confidential registry where testators of their solicitors can deposit information on wills. This registry does not keep a copy of the actual will, but keeps the following information, i.e. will record. 1. Particulars of testator, i.e. the person making the will. 2. The date of the will. 3. Particulars of the person who drew up the will. 4. Details of where the will is held or kept. This registry can be accessed online by logging in at SAL website will.sal.sg to deposit or research for wills recorded by individuals using their SingPass or by companies using their CorePass on behalf of their clients. All information of will record deposited with the Wills Registry is strictly confidential. Fees are payable for both depositing and searching, or will records, i.e. information related to wills. Currently, these fees are shown in the table below. Only the following people may make a research for information related to a will. 1. The testator, who made the will. 2. The solicitor, acting for the estate of someone who has died. The death certificate would be required. 3. The next of kin, of someone who has died. 4. The donee of an LPA, or a deputy appointed or to be appointed by the court, with powers to manage the testator's property and financial affairs in the event that the testator lacks mental capacity. It is not compulsory to register your will information with the wills registry. Hence, there is no guarantee that will record information available in the wills registry of a testator is that of his or her latest will. Public Trustee's Office. The Public Trustee's Office, or PTO, under the Ministry of Law, handles the distribution of CPF funds of CPF members with no valid nomination, including no nomination or no surviving nominee, and the small estate of a person who died intestate. Distributions will be made according to the ISA rules for non-Muslims and the Certificate of Inheritance for Muslims domiciled in Singapore. 1. CPF monies. PTO undertakes the administration of a. CPF monies of CPS members who died with no valid nomination. b. Shares of CPF money of CPF members nominated who is below the age of 18 or who has passed on after the demise of the CPF member. Or c. PTO charges a fee for the administration of unnominated CPF money as shown in the table below. 2. Small estate of deceased with no will. Administration of small fees of $50,000 or below of a deceased who died intestate, but exclude cases involving businesses, HDB and vehicles, and cases with disputes among beneficiaries. PTO charges a fee for the administration of estate as shown in the table below. Valid will. A valid will tenable in court has to meet the following requirements. 1. At the date of execution of the will, the testator must be aged 21 and above, and is with a sound mind. 2. The will has to be in writing, either handwritten or typed. 3. A will shall be treated as property executed by the testator if its execution conform to the internal law in force, a. in the territory where it was executed, or b. in the territory where the testator was domiciled, habitually resided, or was national at the time when the will was executed or at the time of death. 4. Testator is to sign at the end of every page of the will document in the presence of 2 or more witnesses. 5. The witnesses are to sign at the end of every page of the will document in the presence of the testator. 6. None of the witnesses shall be a beneficiary or spouse of a beneficiary. 7. The executor can be a beneficiary but cannot be a witness. 8. The will is not nullified. Wills Act specifies that marriage will nullify a will written at a date before the marriage, except stated with marriage in contemplation in the will. 9. The will is not revoked. Wills Act specifies that a will can be revoked by a. Another valid will made at a later date, b. A written document signed by the testator and 2 or more witnesses to revoke the will, or c. Deliberately destroyed by the testator in the presence of another person. Considerations in will writing. There are many considerations in will writing, besides the related subjects of W5H mentioned in Chapter 1. One should also take cognition of another prevailing law, both of Singapore and foreign jurisdictions, that are applicable to your assets and beneficiaries. Executor/trustee. It is common practice in will writing for a testator to appoint the same person as both executor and trustee, because there are situations where the executor has to hold certain estate assets, such as real properties and business entities, in trust for the beneficiaries over a long period of time. Of course, it is perfectly fine to have another person appointed as trustee to fulfill a certain intention of yours. It is better to appoint individuals or institutions, such as licensed trustee company, as your executor or trustee, or a combination of them. 1. Nature, persons. It is common for testators to name their immediate family members, close relatives, or good friends as executors and trustees. If that is your preference, you should consider their situation in terms of A. Character. This person should be of good reputation and with good character of being reliable, honest, impartial, and trustworthy, particularly in handling valuable assets and large sums of money. B. Emotional stability. This person should have a good EQ, calm and steady in dealing with people, rather than easily overwhelmed by emotion. C. Competence. This person should have reasonable knowledge and experience in solving problems and dealing with people, include ability to seek professional services such as dealing in legal, investment, and real property matters. The duties and responsibilities expected of the executor, as shown in the appendix of this chapter, is very onerous and challenging. D. Age and health. Preferably, this person should have good health and not be too much older than you, even though no one can be certain of their condition in the distant future when they're needed. E. Willingness. This person should be willing to accept additional responsibilities, workloads, and difficulties that are expected of an executor and trustee, on top of his own. F. Availability. Preferably, this person should be resident or based in Singapore rather than working and living in a foreign country. This is particularly relevant as nowadays many Singapore residents are likely to work overseas. G. Acceptance. Preferably, this person should be well respected and accepted by other family members. Family dynamic is real, and you don't want to cause feelings of unfairness or bias that may result in conflict. 2. Joint executor trustee. The option of appointing two persons as joint executor or trustee can prevent the risk of fraudulence for a single individual. However, this may have problems in the execution of their duties if one of them is not available or have disagreements. 3. Substitute executor trustee. If you're appointing a natural person as the executor or trustee in your will, you should always consider appointing substitutes. There could be many reasons a person might not be able to fulfill the roles of executor or trustee many years down the road when their service is needed. By then, they could be struggling with poor health, or too busy with their own work or personal problems, or maybe even have passed on. In any case, the law allows a person to renounce his appointment without giving any reason. 4. Established institutions. Institutions such as licensed trust companies can be appointed as sole or substitute executor trustee. Although they charge a fee for the services they provide, there are significant advantages in appointing them over natural persons. A. Perpetual availability. Companies are considered perpetually available as compared to natural persons who may be busy with work or personal matters, fall sick, get old and weak, and even pass away. B. Professionalism. Companies are staffed with professionals who are trained, qualified, and specialized in dealing with the various estate matters. Their experience and expertise will ensure expeditious and smooth execution of your will. C. Objective. Companies are established to provide good services and will diligently execute your instructions. They are void of issues such as subjectivity and conflict of interest as compared to natural persons, especially close family members. D. Neutrality. Companies and their staff have to abide by professional ethic and code of conduct. They are unrelated to your family members, hence are void of emotional issues, partiality, and unfairness. 5. Combination of natural person and institution. There is an option of appointing a licensed trust company as the financial institute. In addition to the primary and substitute executor trustee, this combination will address the risks of the natural person appointed to becoming unavailable, unwilling, or unable to take on the duties and responsibilities of executor trustee when the time does come. 6. Compensation for executors. Immediate family members appointed to executor trustee are most likely also one of your beneficiaries. As such, they may not expect to be compensated. However, for distant relatives or friends appointed to perform the onerous responsibilities of executor trustee, you should consider compensating them with appropriate gifts in your will. Guardian. If you have young children, you should consider appointing guardians to care for them upon your demise. The Guardianship of Infants Act emphasizes the welfare of infants to be paramount consideration, and the rights of both the father and mother to appoint guardian for their infant, i.e. minor children. By law, guardians are required to care for and see to the upbringing of minors till they are age 21. 1. Rights of spouse. According to the rights of surviving parent as guardian, on the death of the father or mother of an infant, a person under the age 21, the surviving parent shall be guardian of the infant, either acting alone or jointly with any guardian appointed by the deceased parent. 2. Joint guardians. It is advisable that husband and wife should consult one another to appoint the same guardians for their minor children. If different guardians are appointed, then in a situation when they both pass away, these guardians are to act jointly. This may give rise to conflicts among them, and with your minor children caught in between. 3. Home environment. Besides ensuring the basic living needs, health care, and education for your minor children, it is equally important to be concerned about their good moral character and upbringing. Hence, you should consider whether the home environment of the guardian you intend to appoint is conducive for his objective. If your guardians have young children of their own, will your children be neglected or treated differently, especially if your children cannot click well with theirs? 4. Children's preference. Your minor children, especially those in their teens, may have preference for certain nephews or nieces of your family and theirs. You should take this into consideration when appointing guardians, as acceptance by your children will better ensure that they would have a present home to grow up in until their majority. 5. Compensation for guardian. In view of the heavy responsibilities of guardianship over many years to care for your minor children, you should also consider some appropriate giftings as a token of appreciation of the appointed guardian. Beneficiaries. Beneficiaries can be any natural person, class of person, or institutions including trusts and charity organizations. 1. Individual persons. Any individual person with distinct identification, irrespective of nationality, can be named as your beneficiary. However, you should consider appropriate arrangement and other types of estate planning instruments for beneficiaries who are with one or more of the following unique conditions. A. Special needs. Persons with special needs, such as suffering from autism, Down syndrome, or being retarded, are most likely not able to manage their own affairs and financial matters. You should also consider applying for court-appointed deputies for them in accordance with the Mental Capacity Act. B. Severe physical disability. Persons with severe physical disability may need special care, even for their daily living matters, and most likely they may also not be competent in managing their financial matters. C. Vulnerable character. Persons of vulnerable character, such as impulsive, hot temperament, spendthrift, or with addiction for drug and gambling, etc., may not be mature, prudent, or responsible in handling money and assets of value. D. Undischarged bankrupt. Under the Bankruptcy Act of Singapore, any property, assets, or income for a bankrupt person must be channeled to the official assignee under the Ministry of Law. Hence, if a beneficiary of yours were to be an undischarged bankrupt at the time of distribution of your estate, his share of your bequeath or property devised may not benefit him as you had wished. E. Step or illegitimate children. Under the ISA distribution rules, stepchildren and illegitimate children of a person who died intestate are not entitled to receive anything from his estate. Writing a will with such individuals specifically named as beneficiary is the only way for them to benefit from his estate. An alternative is to set up a trust and include such individuals as beneficiaries. 2. Class of person. Beneficiaries can also be a class of persons such as children, grandchildren, or siblings, but namely a beneficiary. This way may pose difficult for the executor, as he has to gather documentary evidence to ascertain the number of claimants in the class and to identify each claimant. 3. Institutions. Registered institutions such as associations, educational institutions, charity organizations, and trusts such as Family Trust and Special Needs Trust can also be named as beneficiaries. 4. Unintended beneficiary. Section 26 of the Wills Act provides that a beneficiary, being a child or other issue of the testator, if he shall die in the lifetime of the testator, but leaving issue living at the time of the death of the testator, his share of devise will go to the estate, as if the death of that person, i.e. the beneficiary, had happened immediately after the death of the testator, unless a contrary intention shall appear by the will of the testator. Hence, it is important to consider the scenario if your beneficiary does not survive you, and to provide in your will an appropriate solution. Concept of estate management. Depending on the types of asset owned, you need to consider carefully how you want to manage your estate, to provide for those who you want to or are obliged to care for, as well as to advance the values and good causes that are important to you. As for legacy and business succession purposes, other types of estate planning instruments and structures, such as trusts, should be considered together with writing of wills. 1. Outright distribution. This is the simplest way of distributing all the assets of your estate, naming the beneficiary and stating their respective percentage, either for the entire estate or for each category of your estate assets. 2. Specific gifts. This is for gifting of certain estate assets, such as the residential property, payout of an insurance policy, or money in a particular bank account, totally to a beneficiary or to be shared in parts or percentages among a few beneficiaries. 3. Distribution in stages. This is particularly relevant for distribution of assets to beneficiaries who are young, inexperienced, or immature. This can either be for distribution of certain assets by percentage to a beneficiary at regular intervals, or when he attains the ages specified. For example, 10% at age 25, 20% at age 30, and balance of 70% at age 35. 4. Life interest benefit. This is when a beneficiary is given an interest in assets under trustee, particular of real property. Throughout his or her lifetime, usually the entitlement includes income derived and or to live in that property without paying rent. It is applicable when you wish for your spouse or any other family member to enjoy the use of a named property during their lifetime, before the disposal of that asset or other beneficiaries. 5. Right of occupation. This is when a beneficiary is given the right to live in a property for a specified time, or for the beneficiary's lifetime, but usually subject to conditions. 6. Longer-term financial support or provision. This is particularly relevant for beneficiaries with special needs, or who are aged and may not be competent in financial management. For such cases, the instructions can be incorporated in testamentary trustee embedded in the will or a separate trust set up for this purpose. 7. Business succession. This concept is not within the scope of this book. Suffice to highlight that for business owners, You should consult estate and succession practitioners for structuring estate plans, most appropriate to your business and intentions. You should also want to consider options of exit plans and business continuity for your business that is co-owned with partners and shareholders. Residuary clause. This catch-all clause should be included in a will to ensure that any residuary estate not bequeathed or devised in your will be distributed to the beneficiaries named under this clause. Without such a clause, the residuary estate will be distributed according to the ISA rules for non-Muslims or certificate of inheritance for Muslims. Residuary estate are assets that you owned or entitled at the end or after your demise, such as 1. Claims from insurance. Claims and payouts from life insurance, travel insurance, and employee benefit policies form part of your estate. If these are not included under specific gifts in your will, the policy monies or payouts will be categorized under residuary estate. 2. Awards from legal suits. Courts awarded for lawsuits brought against at-fault parties also forms part of your estate. Fatal roads accidents caused by reckless drivers is a typical example that may result in court awards for the victim. 3. Inheritance. Assets inherited during a person's lifetime or after his demise form part of his estate. It is not unusual that people inherit property and other types of wealth, especially with the increase in the number of millionaires in Singapore in recent years, as reported by Mothership in the article published on the 5th of January 2020. Singapore saw a rise in the number of millionaires in the country in 2019, with around 207,000 owning at least $1 million in wealth. 4. Failed device. Property devised to a beneficiary who did not survive at the death of the testator will be categorized as residuary estate of the testator, unless there are alternative instructions, such as substitute beneficiary provided. Comorientis clause. The implication of this clause is that if the beneficiary dies within the prescribed survivorship period, for example 30 days or 60 days, he is considered to have died or predeceased the testator. As a result, the device fails and is distributed to the testator's other beneficiaries according to the instructions in his will. You should consider 1. Survivorship period. Probate of a will can only take place after the stated survivorship period from the date of demise of the testator. Hence, the period should not be too long. However, this period should not be too short either. There have been cases of common disasters involving family members in which a person died on the spot and the spouse a few days later. 2. Avoid multiple probate. If a beneficiary B died after the passing of the testator T, then the gifts or inheritance B received after the probate process of T would form part of his own estate. As a result, those assets will have to go through another probate whenever B has a will or not. The ultimate beneficiary may not be who you intended, and worse still, if those assets are in jurisdictions with estate duties or inheritance tax, then those assets are subject to be taxed twice in a short period of time. This is a very significant reason to include the Comorientis clause in your will. Multiple wills. Singapore residents with significant assets in other countries or jurisdictions should consider writing multiple wills, one for each of the countries where their assets are. This is necessary so that probate processes can be carried out concurrently and expeditiously in the respective countries upon their demise. Otherwise, if with only one Singapore will covering worldwide assets, the probate in Singapore must be completed first. Thereafter, resealing of the will followed by probate in each of these countries can then be carried out in sequence, one at a time. Another advantage of multiple wills is for better confidentiality. Because information on assets and beneficiaries of each will are dealt with independently from the others. The only common document required for the probate of each will is the death certificate of the testator. In doing multiple wills, you should consult estate planning practitioners or lawyers who are familiar with the law of the countries concerned, particularly if you have businesses and real properties there. Also, you should consider appointing different executors of each of the countries concerned, or appointing a licensed trust company who has presence in these countries. Most likely, the various wills are executed on different dates in different jurisdictions. It is thus very important that these wills be properly drafted to ensure that they do not revoke any of the other wills, and that none of the wills cover the same asset dealt in with another will. For example, a person domiciled in Singapore with real properties in the UK and Australia, as well as factories in Vietnam, can have 4 wills as follows. 1. A Singapore will to cover worldwide assets, except those in UK, Australia, and Vietnam. 2. A UK will to cover specifically only assets, properties, and bank accounts in the UK. 3. An Australia will to cover specifically only assets or properties and bank accounts in Australia. And 4. A Vietnam will to cover specifically only assets in Vietnam. Will custody. The original will document is required to be tendered in court during probate. Although there are provisions for grant of letters of administration with will annexed for cases of destroyed or lost will documents, the process is much more time-consuming and incurring higher legal fees. As such, it is important for the original will document to be kept in proper custody. There are 3 options available, but each has its advantages and disadvantages. 1. Safe or locked drawer at home. Safekeeping of will documents at home is generally no cost. However, there is a risk of such important documents damaged by fire and water. The risk of documents lost or misplaced during house moving, renovation, or spring cleaning are also not uncommon. In addition, there is risk of unauthorized viewing and tampering of your will document kept at home. 2. Bank safe deposit box. Banks charge an annual rental fee that varies from $150 to $500, depending on size. The most significant disadvantage of keeping a will document in a bank's safe deposit box is upon the death of the hirer, banks only allow access to the safe deposit box by legal personal representatives, with the grant of probate or letters of administration issued by the court. This will inconvenience and delay the probate process, as well as incurring additional legal fees. 3. Will custody services. There are trust companies offering will custody services for safekeeping of important documents in purpose-built security infrastructures they owned or of security service companies. These arrangements allow the testator and his executors or authorized persons to retrieve the will document as the occasion arises. The fees are very reasonable for good security services without the disadvantages of keeping a will document at home or safe deposit box in banks. Problems of passing without a valid will. There are serious challenges, both tangible and intangible, for the probate process of the administration of the estate of a person who has died intestate without a valid will. We will look at what happens in Singapore. 1. Appointment of personal representative. With no will, the immediate family members of the deceased generally include his spouse, children, parents, and siblings, have to discuss and decide who among them is to be the personal representative, i.e. administrator, depending on their relationship and dynamic of personalities. This may take some time to reach a conclusion. Thereafter, each of the rightful beneficiaries, according to the ISA distribution rules, have to formally renounce his or her rights to be appointed as administrator before a commissioner of oath, and to state clearly his or her agreement for the chosen person to be appointed. Invariably, these may delay the probate process. incur expenses, and with potential for disputes among family members. 2. Sureties and security. As provided in Section 29 of the Probate and Administration Act, before the grant of letters of administration by court, the appointed administrator has to submit an administration bond and provide 2 sureties with the amount equal that of the estimated value of the estate. This requirement of financial security posed a great challenge for anyone who came forward. This will cause further delay to the probate process. 3. Financial hardship to immediate family members. Assets of the deceased person's estate are frozen from time to time of the demise until the grant of letters of the administration are issued. This period can be 6 months or longer. Certainly, this would cause shortage of cash flow for his immediate family members, particularly his dependents, and consequently resulted in much suffering from them both, physically and emotionally. 4. Disputes and soured relationships. It is human nature to be edgy under stressful situations. Many issues cropped up, especially if the deceased was running his businesses, leading to disputes, heated arguments, and even soured relationships among family members. For those who owned businesses with partners, disputes and broken relationships can even lead to winding down of businesses. 5. Guardian not of your choice. According to the Guardianship of Infants Act, the surviving parent of an infant, i.e. child below age 21, has the rights of guardianship. Thus, a divorcee should be concerned that without writing will and appointing his guardian, his minor children might have to be cared for by that divorced spouse, who might not be desirable. Guardianship for young children of a couple who died in common disaster with no wills may depend very much on willing relatives to come forward and apply to court for that appointment. That person might not be their choice of guardian. 6. Rightful beneficiaries not of your choice. According to Rules 2 and 3 of the ISA Distribution Rules, as shown in the next section, once you have children, your parents may not be entitled to your estate. If you do not have immediate family members, i.e. spouse, children, and parents surviving you, the rightful beneficiaries under Rules 6, 7, and 8, i.e. siblings, grandparents, uncles, and aunts, are entitled to your estate, but they may not be of your choice. 7. Difficulty to prove rightful beneficiaries' relationship. While the ISA Distribution Rules 7 and 8 provides for grandparents and uncles and aunts as rightful beneficiaries, if you do not have surviving immediate family members and siblings, the administrator may have the onerous duty to establish and prove the number and relationships of these beneficiaries, both of the paternal and maternal lines related to the deceased through documentary evidence such as marriage certificates and birth certificates. Intestate Succession Act Rules of Distribution. ISA Rules of Distribution is evaluated according to the rule numbers in ascending order, as illustrated in the following. Probate and Administration Requirements. When a loved one has passed away, leaving behind property, this is collectively known as the deceased's estate. Where the estate exceeds $50,000, it is mandatory that a person has to be authorized by the court, either as an executor or administrator, to administer and distribute the estate in accordance with the law. Applicant to file for court grant. If the deceased died intestate, i.e. did not have a will, a beneficiary from the family of the deceased or a company engaged by the family can be the applicant to handle the probate matters. If the deceased has a valid will, the executor is allowed to file the applicant himself. However, as filing of court application involves submission of a large number of documents and legal procedures, especially for intestacy cases, it is advisable that you should consider engaging solicitors to make the application. Furthermore, for cases that are likely to be contentious, it is advisable to seek legal advice and services from a law firm. Small estate. If the gross value of the estate does not exceed $50,000, the applicant can consider applying to the public trustee's office for the public trustee to administer the estate. A grant is not needed if the PT agrees to administer an estate. What grant? If the deceased person has a valid will written, the applicant has to file application to the court for grant of probate. If no will, then the applicant has to file application to the court for a grant letter of administration. Which court? If the gross value of the estate does not exceed $3 million, the applicant should be filed in the family justice courts. Otherwise, the application should be filed in the family division of the High Court. Muslim estate. If the deceased person is a Muslim domiciled in Singapore, application must first be filed at the Syria Court to apply for an inheritance certificate in accordance with the Administration of Muslim Law Act. Application for grant of probate. 1. Required documents. Executors should first compile the following documents. A. Death certificate of the deceased. B. Will document include codicil, if any. C. Death certificates of next to kin who have passed, if applicable. D. Inventory of estate assets, including business, real property, personal valuable items, digital assets, insurance policies, CDP, and investment accounts and bank accounts. Documents related to income tax property, tax road, utility bills, etc. F. Documents related to legal suits, particularly against at-fault parties and receivables and debts owed to the deceased. 2. Application procedure. The applicant can be the executor himself or the service provider, such as a licensed trust company or law firm engaged by the executor. A. Preliminary step. Preparation of documents required for the application. Generally, the applicant has to prepare the following documents. 1. Service Bureau form for application for probate. 2. Service Bureau form for schedule of assets. 3. Renunciation of other executors. 4. Death certificate of other executors. 5. Ex parte originating summons. 6. Statement for probate for administration. 7. Certified true copy of the death certificate. 8. Certified true copy of the will. B. Stage 1. Filling of the applicant for grant of probate. 1. Applicant to serve electronically at LawNet and Crimson Logic Service Bureau, using the e-litigation portal. 2. Conduct a search of probate cases and caveats filled in relation to the estate of the deceased. 3. Submit the application together with the prepared documents and make payment for the filing fee. The original will document is required to be presented for verification. C. Stage 2. Filing of supporting affidavit. Prepare and submit the following documents within 14 days from the date of filing of the application. 1. Supporting affidavit. 2. Administration oath. 3. Schedule of assets. 4. Supplementary affidavit. If schedule of assets was unable to be completed and filed together with items 1 and 2. D. Stage 3. Extracting the grant of probate. The executor or lawyer concerned has to conduct another search of probate cases and caveats filled in relation to the estate at the Service Bureau, then submit the request to extract the grant of probate, and make all the required payments. If all documents are in order, and all fees are paid, the court will prepare and issue the grant of probate with the engrossed schedule of asset annexed. E. Distribution of assets. With the grant of probate, the executor may commence the management and distribution of the deceased assets according to the construction stated in the will, after due actions to pay taxes and debts, and making claims of the deceased's estate entitled. Application for grant of letters of administration. 1. Priority of right as administrator. According to the ISA rules of distribution, the order in priority to be administered are spouse followed by classes of next to kin as follows: A. Spouse. B. Children. C. Parents. D. Siblings. E. Nephews and nieces. F. Grandparents. G. Uncles and aunts. 2. Affidavit of renunciation of beneficiary. Family members of the high order and members of the same class of next to kin who do not want to be appointed as administrator have to individually do an affidavit renouncing his or her right to be appointed, completing a renunciation form 53 each before a commissioner of oaths. For example, a family of 3 left behind by a deceased person, comprising the spouse, wife, or mother, a son or daughter. The mother has the right to be administrator. The son and daughter have the equal right to be administrator after their mother, spouse, or wife. Assume that the 3 of them have agreed for the son to be the administrator. Hence the wife and daughter have to furnish a renunciation each, while the son will be the applicant to apply for the grant of letters of administration. 3. Application procedure. The application can be chosen family member or the service provider, such as a licensed trust company or law firm engaged by the family. A. Prepare the required documents. 1. Service Bureau form for application for letters administration. 2. Schedule of assets. 3. Death certificate of the deceased. 4. Renunciation of beneficiary with prior right. 5. Death certificates of next to kin. 6. Divorce certificate of the deceased. 7. Foreign grant, if applicable. 8. Inheritance certificate, if applicable for Muslims. B. Stage 1. Filing of the applicant for grant of letters administration. 1. Applicant to apply at the Service Bureau. 2. Conduct a search of probate cases and caveats filed in relation to the estate of the deceased. 3. Submit the application together with the prepared documents and make payment for the filing fee. C. Stage 2. Filing of supporting affidavit. Submit the following documents within 14 days from the date of filing the application. 1. Supporting affidavit. 2. Administration oath. 3. Schedule of assets. 4. Supplementary affidavit and schedule of assets, if it was incomplete when first filed, or additional assets to be filed. D. Stage 3. Filing of extract the grant of letters of admission. The administrator of lawyers concerned has to conduct another search of probate cases and caveats filed in relation to the estate at the Service Bureau, then submit the request to extract the grant of letters of administration and make payment of all the required filing fees. If all documents are in order and all fees paid, the court will prepare all issues of grant letters and administration with the engrossed schedule of assets annexed. E. Distribution of assets. After extracting the grant of letters of administration, which authorizes the applicant to manage the deceased estate according to the ISA rules of distribution for non-Muslims or Faraday rules for Muslims. Probate and administration for Muslims. The Sharia court has jurisdiction over the method of distribution of a deceased person's estate among his next of kin in accordance with Islamic law, as provided for under sections 111 and 115 of the Administration of Muslim Law Act. All applications are to be done online at the Sharia court website, www.shariacourt.gov. 1. Applicant. The following persons only may apply for the probate of a deceased Muslim. A. A beneficiary of a deceased Muslim's estate. B. A law firm applying on behalf of the beneficiary. C. Consultancy firm agency applying on behalf of the beneficiary. D. MUIS, which is a fund administered by the MUIS. E. Court of law. 2. Trial calculation. This calculation is for the user's own information only. Applicant can go to the Syria Court website, select drop-down menu, Inheritance, and click an online trial calculation. Follow the instructions on screen according to input the required information of the deceased, applicant and male and female beneficiaries to obtain the trial calculation. 3. Stage 1. Apply for inheritance certificate. Applicant to apply online from Syria Court for an inheritance certificate submitting particulars of the deceased applicant and inheritors. B. Upon receipt of acknowledgement email, provide required documents for verification by email within 3 days. C. Upon receipt of completion of verification email, make payment for application within the dates given at the Syria Court Registry with NRIC, Deceased Death Certificate and Statutory Declaration. D. Issuance of inheritance certificate by email from Syria Court. 4. Stage 2. Apply for grants of probate or letters of administration. A. With will. Appointed executor states in deceased will is to apply to the family court for grant of probate in accordance with the procedure detailed above. The inheritance certificate is to be submitted together with the will of the deceased and other required documents. B. With no will. The applicant, as decided by the family of the deceased, is to apply to the family court for grant of letters of administration in accordance with the procedure detailed above. The inheritance certificate is to be submitted together with other required documents. 5. Distribution of the estate. A. With the will. The executor to distribute estate assets of the deceased according to the instructions in the will, and the remaining assets will be distributed according to the inheritance certificate in compliance with the Faraid rules in Syria law. B. With no will. The applicant to distribute estate assets of the deceased according to the inheritance certificate in compliance with the Faraid rules in Syria law. 6. Prevailing civil law. Estate assets and matters related to jointly owned properties, such as HDBs and bank accounts, payouts of life insurance with nomination and CPF money with valid nomination, are not subject to the Faraid rules as these fall under the purview of respective civil laws. Duties and challenges of executor and administrator. The personal representative of a person passed away with a valid will is the executor named therein. However, if a person passed away, intestate with no will, then his family members have to decide and choose a suitable person as the personal representative. Subsequently, this personal representative will be appointed by court as executor by a grant of probate. If there is a will, or administrator by a grant of letters of administration, if there is no will. The duties and responsibilities of the executor and administrator are very onerous. They are expected to carry out their duties with utmost integrity, dedication, and impartiality. They must also carry themselves well in managing expectations of the beneficiaries and any conflict or dispute among them. Some of the common tasks they have to cover are as follows. 1. In consultation with the family member to make arrangements for the funeral of the deceased according to instructions expressed in the will, if there are any. 2. Reading of the will to fully understand the instructions therein, and also to brief the family members accordingly. 3. Engage a lawyer to apply for grant of probate, if there is a will, or to apply for grant of letters of administration if there is no will. 4. Meanwhile, help to obtain required documents such as death certificate, will, and estimates of assets for submission. 5. Mustering of assets and maintaining an accurate inventory of the deceased's assets. 6. Open a bank account for the estate of the deceased upon grant of probate and grant of letters of administration. 7. Close bank accounts of the deceased and transfer the money to the account for the estate of the deceased. 8. Pay tax and duties such as income tax and property tax. 9. Settle debts and liability with creditors, such as outstanding housing loan, car loan, and credit card bills. 10. Make claims and collect receivables, such as insurance, and initiate lawsuits as a plaintiff against liable parties, if any. 11. Give notice of intention to distribute the deceased's assets. 12. Arrange for title transfer or liquidation of real properties and cars. 13. Distribute estate assets to the rightful beneficiaries according to will or according to ISA rules. 14. Set up trusts and trust accounts according to testamentary trust indicators in the will, or if there are any minor beneficiaries. 15. Maintain proper record and accounts of assets, payments, and distributions made. Chapter 9. Trusts in Singapore. Takeaways. Despite what the media tells us, a trust is not a magical tool to illegally evade taxes or hide assets. A trust is an excellent tool for asset protection and probate avoidance. It can be a powerful part of a holistic estate plan. Like many of the estate planning tools in this book, trusts can be jurisdiction-specific. Local rules need to be considered for each jurisdiction where you have assets, residency, or domicile. It is usual for one person to know everything. This means that those of you that live and work internationally need to work with a team with members who are qualified to advise on the jurisdiction in question. This also applies to the U.S., where each state may have different rules to consider. This chapter looks at trusts from a Singapore perspective. Governing law. The governing law in Singapore related to trusts are 1. Trustees Act, Chapter 337. Trustees defined in this act include personal representatives, executor, and administrator holding properties on trust, licensed trust companies, and public trustee. This act also specifies the duty and powers of trustees, appointment, retirement, replacement, and discharge of trustees. 2. Trust Companies Act. This act specifies the requirements of a licensed trust company, including stringent rules for proper keeping of books and accounts and audit of such documents. It also provides the powers of the Monetary Authority of Singapore to supervise and investigate the operations of trust companies and to obtain information. 3. Trust Companies Regulations 2018. This document specifies the licensing requirements of a licensed trust company, including fees, paid-up capital, appointment of resident managers and director. Also, the requirements for keeping of records and periodical submission of reports and returns. 4. Trust Companies, Regulations 2016. This document defines a list of persons exempted from the requirement to hold a trust business license in respect of the carrying on of trust business and the requirements for keeping of records and periodical submission of reports and returns. In particular, the requirement for a private trust company to engage a licensed trust company to carry out trust administration services for the purposes of conducting the necessary checks to comply with any written direction issued by MAS on the prevention of money laundering or countering the financing of terrorism. Valid trust. A trust is a legal document that can be created during a person's lifetime and can be in operation long after death. A trust can also be created by a person in his will, but formed and becoming effective after his death. There are 3 certainties that must be clearly stated in an express trust for it to be valid, and in order for it to be executed effectively. 1. Certainty of intention. The intention of the settlor to create the trust and purpose must be certain for someone to be under a duty to hold property for the benefit of another person, beneficiary. For example, for the maintenance, health care, and education of my children. 2. Certainty of subject, settlement. The identity of the trust property or settlement must be certain, be it an immovable property, a business entity, or other assets, and clearly stated in the trust instrument. For example, the freehold residential property. 3. Certainty of object, beneficiary. The identity of the beneficiaries or legal persons must be certain, that each of them can be clearly identified and not subject to interpretation. Structure of a trust. A trust is a legal structure or contract between the settlor or grantor and trustee, in which the settlor transfers the legal title of properties, known as settlement or trust property, to the trustee for management according to the items specified in the trust deed, for the benefit of the beneficiary, who has the equitable interest in the trust property. The diagram below shows the components of a generic trust structure. A letter of wishes, or letter of intent, is a supplementary document which can be apprehended to a trust to provide guides, or as expression of settlor's wishes, for the trustee in making discretionary decisions in dealing with the trust's proprieties and beneficiaries. It is not legally binding, but can guide the trustees to ensure that the settlor's wishes are best carried out. Settlor can easily update and renew his letter of wishes as appropriate to meet the changing situation and consideration, at negligible cost. The expressed wishes of a settlor are certainly a factor which the trustee may legitimately take into account in exercising his discretion. The law allows the settlor to appoint a protector, an individual or entity to serve as a watchdog over the trustee in the administration of the trust. Typically, the protector is given the power to veto or authorize a trustee's action in certain matters. In particular, he's given the power to remove and change trustees who may not be performing to expectation. The protector also functions as a liaison between the trustees and the beneficiaries. Similar to that in will, beneficiaries can be natural persons, class of persons or institutions, including charity organizations and trusts, such as Special Needs Trust. Duties of a trustee. The duties of a trustee can be varied in accordance to the terms specified in the trust's concern. Primarily, trustees must follow the instructions in the trust document, but certainly they also have to comply fully with the onerous requirements of statutory duty of care specified in the Trustees Act. They are holding and administering the properties in trust on behalf of the settlor and the beneficiary, to the best of their knowledge and experience. They are allowed to engage experts and specialists as necessary, particularly in areas such as running of businesses, dealing in investment, properties, accounting, and related legal matters. Some of the common fiduciary duties trustees expected to undertake or observe are as follows. 1. To comply with the terms of the trust deed. 2. To manage the trust assets for the sole benefit of the beneficiary. 3. To manage the trust assets with an objective standard of care. 4. To protect and safeguard trust assets, including take-up insurance. 5. To handle all tax matters related to trust properties and incomes. 6. To appoint and engage agents objectively at arm's length. 7. To act fairly and impartially between the beneficiaries. 8. To exercise reasonable care and skill in ensuring the financial security and well-being of the beneficiary. 9. To maintain clear and accurate accounts. 10. To keep the settlor, while he is still alive, and the beneficiary appraised of the financial status of the trust and related accounts. Types of trust. The types of trusts can be categorized in various ways according to their natures, operations, or applications. Below are common types of trust according to their natures and operations. 1. Revocable trust. Revocable trusts are created during a person's lifetime, and it can be altered, changed, modified, or revoked entirely by him while having legal capacity. The settlor remains ownership and control of the property in the trust. 2. Irrevocable trust. An irrevocable trust is one that cannot be altered, changed, modified, or revoked after its creation. Legal title and control of the properties in the trust are transferred from the trustee, and subject to certain conditions. These properties are out of reach of creditors both during the lifetime of the settlor and after his demise. 3. Testamentary trust. A testamentary trust is structured by the testator and is embedded in his will during his lifetime. Transfer of legal title of property in the estate of the testator takes place only after his death. It is revocable during the lifetime of the testator, but becomes irrevocable and with its operation starts upon his demise. 4. Living and inter vivos trust. Living trust is established during a person's lifetime with transfer of legal title of properties from the settlor to the trustee. Its operation takes immediate effect upon establishment. 5. Fixed trust. A fixed trust is one where the distribution in shares of the beneficiaries are fixed from the outset, including the quantum and timing. The trustee is expected to follow religiously according to the terms specified in the trust deed. 6. Discretionary trust. A discretionary trust is one where the potential beneficiaries and their shares are not fixed. The trustee is given the discretion to decide, according to the terms and considerations specified in the trust deed and letters of wishes, on potential beneficiaries, their shares, and frequent and timing of distribution of benefits. 7. Standby trust. This is a type of living trust, but with its operation put on standby until the occurrence of certain predetermined condition or event as dictated by the settlor in the trust deed. For example, upon the demise of the settlor, or when the settlor becomes mentally incapacitated, typically the initial settlement is a small sum at the onset. To fulfill the subject requirements of a valid trust, additional properties can be transferred to the trust later or upon occurrence of certain defined conditions through other legal documents such as a will and LPA. Advantages of trust. Trust is a very flexible and powerful estate planning tool that offers many significant advantages. 1. Free from probate. Assets whose legal title have been transferred from the settlor to the trustee are not counted as part of the settlor's estate upon his demise. Such assets are not subject to probate and are immediately available to the beneficiaries of the trust. This is particularly relevant for assigning a life insurance policy to a trust. 2. Asset protection. Assets settled into irrevocable trust are protected from creditors, both during the lifetime of the settlor and after his demise, provided the settlor is not a beneficiary of the trust and the settlement has passed the mandatory clawback period, normally of 5 years. 3. Privacy advantage. Using a living trust as an estate planning tool offers privacy of beneficiaries and distribution of benefits, in comparison with wills the content of which become public. 4. Continuity in incapacity. Living trust with terms provided for situations when the settlor should become incapacitated, either mentally or physically, allows his wishes to be executed by the trustee under those situations and to continue after his demise. 5. Minimize duty and tax. Estate duty has been abolished in Singapore since the 15th of February 2008. In Singapore, incomes generated from assets of a trust are subject to the flat corporate tax rate of 17%, while the progressive personal income tax is capped at 22% for charitable income above $320,000. The 5% difference or advantage in tax rates of corporate tax over personal income tax for a high net worth person to settle his income generating assets into a trust can result in significant savings per annum. That is net savings of $5,000 for every $100,000 of charitable income. On the other hand, the use of an irrevocable fixed property trust, subject to proper drafting of terms, to purchase a second or third residential property in Singapore can save much on the current ABST regulations, up to 12% or 15% respectively of the purchase prices for a Singapore resident beneficiary. 6. Funding for family legacy. Assets can be settled into family legacy trust to provide an advantaged legacy of value to a settler, such as for tertiary education, entrepreneurship, and family unity across generations. 7. Funding for social causes. Likewise, assets can be settled into charity trusts and foundations to support good social causes which are important to the settler, both during his lifetime and long after his demise. Applications of trust. Trust has many applications, particularly in the current era of increased affluence in Singapore and the region. The following are some common applications of trust. However, as customization is necessary to ensure that the structure and context of the trust document best meets your intention, you are advised to consult a professional estate planning practitioner in structuring your estate plan. 1. Estate management for family. Trust is an effective estate planning tool for parents to ensure that their wealth will be well managed to provide and care for their loved ones, including not just their children, but also their aged parents. Wills can only come into operation after the demise of the testators, whereas living trusts can address the situations during the lifetime of the settlers, should they become incapacitated either physically, mentally, or both. 2. Asset protection against liability. Setting up of irrevocable living trust with assets obtained during good times and years of abundance is worthy of serious consideration, particularly for business owners and high-income earners who can afford to put aside substantial amounts of wealth. Should unfortunate events such as lawsuits or failed business ventures, failure in management oversight of lifted companies, and negligence in professional services that may result in bankruptcy strike. 3. Duty and tax optimization. Proper application of trusts can help you to avoid or minimize duty in tax areas such as estate duty, buyer stamp duty, additional buyer stamp duty, and income tax. 4. Charity purpose. Living trusts can be easily set up to advance good social causes of concern to the philanthropist, to help needy and underprivileged families in our society. 5. Business continuity. A business value trust can be effectively structured in conjunction with life insurance policies and/or other functioning mechanisms to provide funding for buy-sell arrangement, hence to ensure business can continue for companies formed under partnerships or shareholders when one of the partners or shareholders passes away. The details of such a solution are beyond the scope of this book, but certified financial planners with experience in estate planning should be competent to advise you. 6. Business succession. Living trust can also be structured for cross-generational success of family business with solely owned company or holding companies. Company shares are transferred from the founder to a trust structured under a private trust company. Instead of distributing to various family members across generations, the company is centrally controlled and managed by a board of directors, initially formed with the founder himself, together with selected family members of his next generation, who are guided by a family charter or constitution. They will work with their best to ensure that the company is doing well for their own benefit, as they and other family members are beneficiaries of that trust. The details of such a solution are beyond the scope of this book as well. You should engage the service of estate planning practitioners from a licensed trust company for advice. Special Needs Trust. Special Needs Trust Company Limited, or SNTC, was established on the 20th of June 2008 as a charity organization with IPC status. Its mission is to provide trust services for the benefit of persons with special needs. SNTC is a government-funded nonprofit organization which works with the Public Trustee's Office to hold and manage funds as trustee for the beneficiary of the respective SNTC trust setup. SNTC works closely with the Ministry of Social and Family Development in developing the trust scheme and collaborates with individuals and institutions of various specialist professionals, such as in the legal, healthcare, and social services sectors, to provide the continuity of financial and special support for their clients. SNTC trusts is an irrevocable trust set up specifically for a person with special needs by the settlor, usually the parent or caregiver of the person with special needs. The beneficiary, with an initial settlement of $5,000, SNTC trust is generally held dominant upon setup and is only activated or operational on conditions as specified in the trust deed, such as when the settlor is unable to care for the named beneficiary, either due to physical disability, mental incapacity, or demise. Parents or caregivers of a person with special needs can approach SNTC for advice and eventually settling up of the required SNTC trust. According to SNTC's definition, persons with special needs are persons whose prospects of securing, retaining places, and advancing in education, training institutions, employment, and recreational as equal members of the community are substantially reduced as a result of physical, sensory, intellectual, and/or developmental impairments. This may also include persons with mental disabilities. Eligibility criteria. The beneficiary must be 1. A person with special needs. 2. A Singapore citizen or PR. 3. Residing in Singapore. Setting up an SNTC trust. Parents or caregivers can simply contact SNTC and arrange to meet the case manager to understand more about SNTC and SNTC trust, and to discuss details of setting up the SNTC trust for your loved one. 1. Create a care plan. SNTC, together with you and the settlor, will go through a holistic needs assessment of your loved one, the beneficiary, that is focused entirely on his or her well-being. This will enable SNTC to develop a care plan that is helpful to protect the amount of trust funds you need to set aside to provide for your beneficiary to receive similar daily care needs after you are no longer able to look after him or her. 2. Write a letter of intent. As the caregiver, you decide and set out your wishes in a letter of intent on how the funds are to be managed and dispersed to meet your beneficiary's daily living needs. Upon your demise or incapacity, the trust will be activated and SNTC will act according to your wishes in dispersing the funds and in the best interest of the beneficiary. 3. Trust account. You only require a minimum of $5,000 to set up the account, and you can top up the trust fund any time thereafter, either in regular or lump sum cash transfer through various estate planning tools, such as will, LPA, trust, insurance nomination, and CPF nomination. The public trustee holds and invests the trust funds with principal guarantee by the government. Structure of a special needs trust. Diagrammatic view of an SNTC trust is as shown below. Activation of the SNTC trust. The trust is normally activated upon the demise or incapacity of the parents or main caregiver. SNTC will act according to your wishes written in the letter of intent in dispersing the funds and always acting in the best interest of your beneficiary. Termination of the SNTC trust. The trust will be terminated. 1. Upon the demise of your beneficiary, SNTC will distribute any balance of the trust funds to your appointed residual beneficiaries named in the trust deed. 2. When the trust funds are fully utilized or otherwise exhausted before the demise of your beneficiary. 3. When your beneficiary no longer resides in Singapore, SNTC will transfer the balance of your funds to another trust fund in the country he or she resides in. Advantages of SNTC trust. The significant advantage of SNTC trust is that the special needs person will continue to be cared for throughout his lifetime, even when the settlor suffered loss or mental incapacity or beyond his demise. The tangible advantages of the settlor of an SNTC trust are 1. Safeguard your loved one's welfare and financial security. 2. The services of SNTC, who is well informed about the rights of persons with special needs. 3. The services of PTO to manage and administer your money for your loved one. 4. Spares your concerns of placing the legal and financial responsibilities of managing the monies on relatives or friends. 5. Spare your concerns that relatives or friends may move away, suffer ill health, and cannot commit to long-term management of the financial affairs of your loved one and to take care of their daily living needs. 6. Principal value of the trust funds managed by PTO is guaranteed by the government. 7. Very affordable fees which are 90 to 100% subsidized by the MSF. Chapter 10. U.S. Individual Retirement Arrangements, IRAs. Takeaways. This chapter discusses individual retirement arrangements, or IRAs. An IRA is a personal savings plan that gives individual taxpayers tax advantages for setting aside money for retirement. Two tax advantages of an IRA are that contributions made to an IRA may be fully or partially deductible, depending on the type of IRA and the taxpayer's individual circumstances. And generally, amounts in a taxpayer's IRA, including earnings and gains, are not taxed until distributed. In some cases, amounts are not taxed at all, if distributed according to the rules. IRAs are jurisdiction-specific, so an IRA that may enjoy preferential tax treatment in one jurisdiction may be penalized by the tax authorities in another. Always get advice from qualified tax professionals. Pay attention to the rules around contributions, distributions, and inheritance. Traditional IRA. This section discusses the original IRA. In this chapter, the original IRA, sometimes called an ordinary or regular IRA, is referred to as a traditional IRA. Eligibility requirements. An individual can set up and make contributions to an IRA if the individual, or he or she files a joint return, his or her spouse receives taxable compensation during the year, and the individual was not age 70 and a half by the end of the year. Individuals can have a traditional IRA whether or not they are covered by any retirement plan. However, individuals may not be able to deduct all of their contributions if they or their spouse are covered by an employer retirement plan. If both the individual and his or her spouse have compensation and are under the age of 70 and a half, each can set up an IRA, but cannot both participate in the same IRA. B. Compensation. Generally, compensation is what an individual earns from working, i.e., wages, salaries, tips, professional fees, and other amounts received for providing services. For self-employed individuals, compensation is the net earnings from their trade or business, provided their personal services are a material income producing factor, reduced by the total amount of the deduction for contributions made on their behalf to retirement plans, and the deduction allowed for 1/2 of self-employment taxes. 1. Self-employment income. When an individual has both self-employment income and salaries and wages, his or her compensation includes both amounts. If an individual has a net loss from self-employment, he or she may not subtract the loss from his or her salaries or wages when figuring his or her total compensation. 2. Alimony and separate maintenance. For IRA purposes, compensation includes any taxable alimony and separate maintenance payments received under a decree of divorce or separate maintenance. C. Types of traditional individual retirement arrangements. A traditional IRA can be an individual retirement account or annuity. It can be part of either a simplified employment pension or an employer or employee association trust account. 1. Individual retirement account. An individual retirement account is a trust or custodial account set up in the United States for the exclusive benefit of one person or his or her beneficiaries. The account is created by a written document. The document must show that the account meets all the following requirements. The trustee or custodian must be a bank, a federally insured credit union, a savings and loan association, or an entity approved by the IRS to act as trustee or custodian. The trustee or custodian generally cannot accept contributions above certain limits. However, rollover contributions and employer contributions to a simplified employee pension can be more than this amount. Contributions, except for rollover contributions, must be in cash. The investor must have a non-forfeitable right to the amount at all times. Money in the account cannot be used to buy a life insurance policy. Assets in the account cannot be combined with other property, except in a common trust fund or common investment fund. And the individual must start receiving distributions by April 1st of the year following the year in which he or she reaches age 70 and a half. 2. Individual retirement annuity. A person can set up an individual retirement annuity by purchasing an annuity contract or an endowment contract for the life insurance company. An individual retirement annuity must be issued in the investor's name as the owner, and either he or she or his or her beneficiaries who survive are the only ones who can receive the benefits or payments. An individual retirement annuity must meet all of the following requirements. The investor's entire interest in the contract must be non-forfeitable. The contract must provide that the investor cannot transfer any portion of it to any person other than the issuer. There must be flexible premiums so that if the investor's compensation changes, his or her payments can also change. This provision applies to contracts issued after November 6, 1978. The contract must provide that contributions cannot be more than the applicable threshold and that the investor must use any refunded premiums to pay for future premiums and to buy more benefits before the end of the calendar year, after the year in which he or she receives the refund. And distributions must begin by April 1st of the year following the year in which the investor reaches age 70 and a half. 3. Individual retirement bonds. The sale of individual retirement bonds issued by the federal government was superseded after April 30, 1982. 4. Simplified employee pension. A simplified employee pension is a written arrangement that allows an investor's employer to make deductible contributions to a traditional IRA, set up for the employee to receive such contributions. Generally, distributions from SEP IRAs are subject to the withdrawal and tax rules that apply to traditional IRAs. D. Contribution limits. There are limits and other rules that affect the amount that can be contributed to a traditional IRA. The following are some rules to keep in mind. In most cases, each spouse figures his or her limit separately, using his or her own compensation. This is the rule even in states with community property laws. Brokers' commissions paid in connection with the traditional IRA are subject to the contribution limit. Trustees' administrative fees are not subject to the contribution limit, and contributions on an individual's behalf to a traditional IRA reduce his or her limit for contributions to a Roth IRA. General limit. The most that can be contributed to a traditional IRA is the smaller of the following amounts: $6,000, $7,000 if you are 50 or older, or the individual's taxable compensation for the year. This is the most that can be contributed regardless of whether the contributions are to one or more traditional IRAs, or whether all or part of the contributions are non-deductible. 2. More than one IRA. If an individual has more than one IRA, the limit applies to the total contributions made on the person's behalf to all of his or her traditional IRAs for the year. 3. Annuity or endowment contracts. If an individual invests in an annuity or endowment contract under an individual retirement annuity, no more than applicable limit can be contributed toward its cost for the tax year, including the cost of life insurance coverage. If more than this amount is contributed, the annuity or endowment contract is disqualified. Spousal IRA limit. For 2020, If an individual files a joint return and his or her taxable compensation is less than that of his or her spouse, the most that can be contributed for the year to his IRA is the smaller of the following two amounts: $6,000 or $7,000 if you're 50 or older, or the total compensation includable in the gross income of both the individual and his or her spouse for the year, reduced by the following two amounts: A, his or her spouse's IRA contribution for the year to a traditional IRA, and B, any contributions for the year to a Roth IRA on behalf of the person's spouse. Note, however, that this traditional IRA limit is reduced by any contributions to a Section 51C, a pension plan created before June 25, 1959, that is funded entirely by employee contributions. Generally, an individual's filing status has no effect on the amount of allowable contributions to a traditional IRA. However, if during the year either the individual or his or her spouse was covered by a retirement plan at work, the individual's deduction may be reduced or eliminated, depending on his or her filing status and income. 5. Less than maximum contributions. A person who contributes less than the maximum allowed in their IRA one year may not contribute more than the applicable limit the following year, or in any subsequent year to make up the difference. 6. More than maximum contributions. If contributions to an individual IRA for the year were more than the limit, the person can apply the excess contribution in one year to a later year if the contributions for that year are less than the maximum allowed for that year. However, a penalty for additional tax may apply. E. Timing of contributions. Contributions can be made to a traditional IRA as soon as it has been established. Contributions must be in the form of money, cash, check, or money order. Property cannot be contributed. However, an individual may be able to transfer or roll over certain property from one retirement plan to another. Contributions can be made to a traditional IRA for each year that the individual receives compensation and has not reached the age of 70 and a half. For any year in which the individual does not work, contributions cannot be made to his or her IRA, unless he or she receives alimony or files a joint return with a spouse who has compensation. Even if contributions cannot be made for the current year, the amounts contributed for years in which the individual did qualify can remain in his or her IRA. Contributions can resume for any years that the individual qualifies. 1. Due date. Contributors can be made to a traditional IRA for a year at any time during the year, or by the due date for filing his or her return for that year, not including extensions. 2. Age 70 and a half rule. Contributions cannot be made to a traditional IRA for the year in which the individual reaches age 70 and a half, or for any later year. An individual attains 70 and a half on the date that is 6 calendar months after the 70th anniversary of his or her birthday. 3. Designating year of your contribution. If an amount is contributed to a traditional IRA between January 1st and April 15th, the individual should tell his or her sponsor which year, the current year or the previous, the contribution is for. If the individual does not tell the sponsor which year it is for, the sponsor can assume and report to the IRS that the contribution is for the current year. F. Deductions. Generally, an individual is entitled to deduct the lesser of the contributions to his or her traditional IRA for the year, or the general limit, or the spousal IRA limit, if applicable, explained above. However, if the individual or his or her spouse was covered by an employer retirement plan, he or she may not be able to deduct this amount. 1. Trustees' fees. Trustees' administrative fees are billed separately and paid in connection with a traditional IRA are not deductible as IRA contributions. However, they may be deductible as a miscellaneous itemized deduction on Schedule A, Form 1040. 2. Broker commissions. These commissions are part of an IRA contribution, and as such are deductible subject to the limits. 3. Employer-sponsor IRA. If an individual or his or her spouse was covered by an employer retirement plan at any time during the year for which contributions were made, his or her deduction may be further limited. Special rules apply to determine the tax years for which an individual was covered by an employer plan. These rules differ depending on whether the plan is defined contribution plan or a defined benefit plan. A. Defined contribution plan. Generally, an individual is covered by a defined contribution plan for a tax year if amounts are contributed or allocated to his or her account for the plan year that ends with or within that tax year. A defined contribution plan is a plan that provides for a separate account for each person covered by the plan. In a defined contribution plan, the amount to be contributed to each participant's account is spelled out in the plan. The level of benefits actually provided to a participant depends on the total amount contributed to that participant's account and any earnings on those contributions. Types of defined contribution plans include profit-sharing plans, stock bonus plans, and money purchase pension plans. If an amount is allocated to an individual's account for a plan year, he or she is covered by that plan, even if he or she has vested interest in or legal rights to the account. Defined benefit plan. If an individual is eligible to participate in his or her employer's defined benefit plan for the plan year that ends within his or her tax year, he or she is covered by the plan. This rule applies even if the employer declined to participate in the plan, did not make a required contribution, did not perform the minimum service required to accrue a benefit for the year. A defined benefit plan is any plan that is not a defined contribution plan. In a defined benefit plan, the level of benefits to be provided to each participant is spelled out in the plan. The plan administrator figures the amount needed to provide those benefits, and those amounts are contributed to the plan. Defined benefit plans include pensions plans and annuity plans. C. Situations in which individual is not covered. Unless an individual is covered by another employer plan, he or she is not covered by an employer plan if he or she is in one of the situations described below. 1. Social Security or Railroad Retirement. Coverage under Social Security or Railroad Retirement is not covered under Employer Retirement Plan. 2. Benefits from previous employer's plan. If an individual receives retirement benefits from a previous plan, he or she is not covered by that plan. 3. Reservists. If the only reason an individual participates in a plan is because he or she is a member of a reserve unit of the armed forces, the individual may not be covered by the plan. He or she is not covered by the plan if both of the following conditions are met. The plan he or she participates in is the established for employees by the United States or state or political subdivision of a state, or an instrument of either A or B. The individual did not serve more than 90 days on active duty during the year. 4. Volunteer firefighters. If the only reason an individual participates in a plan is because he or she is a volunteer firefighter, he or she may not be covered by the plan. The individual is not covered by the plan if both of the following conditions are met. The plan he or she participates in is established for its employees by A. the United States, B. a state or political subdivision of a state, or C. an instrumentality of either A or B above. The individual's accrued retirement benefits at the beginning of the year will not provide more than $1,800 per year at retirement. 6. Limit if covered by employer plan. The deduction an individual can take for contributions made to his or her traditional IRA depends on whether the individual or his or her spouse were covered for any part of the year by an employer retirement plan. The allowable deduction is also affected by how much income the individual had and by his or her filing status. The deduction may also be affected by any Social Security benefits received. If either the individual or his or her spouse were covered by an employer retirement plan, he or she may be entitled to only a partial, reduced deduction or no deduction at all, depending on income and filing status. An individual's deduction begins to decrease when his or her income rises above a certain amount and is eliminated altogether when it reaches a higher amount. These amounts vary depending on an individual's filing status. The amount of any reduction in the individual limit IRA deduction depends on whether the individual or his or her spouse was covered by an employer retirement plan. If an individual is covered by an employer retirement plan and the individual did not receive any Social Security retirement benefits, his or her IRA deduction may be reduced or eliminated depending on his or her filing status and modified AGI. Keep in mind, employer match or profit-sharing contributions aren't included in the limits. 401k and 403b share same limit. The 457 plan limit is separate. You can contribute to both a 401k, 403b plan, and a 457 plan. G. Non-deductible contributions. Although an individual deduction for IRA contributions may be reduced or eliminated, contributions can be made to an IRA of up to the general limit or, if it applies, the spousal IRA limit. The difference between an individual total permitted contribution and his or her IRA deduction, if any, is the individual's non-deductible contribution. 1. Failure to report non-deductible contributions. If an individual fails to report non-deductible contributions, all of the contributions to his or her traditional IRA will be treated as deductible. All distributions from his or her IRA will be taxed unless the individual can show with satisfactory evidence that non-deductible contributions were made. 2. Penalty for overstatement. If an individual overstates the amount of non-deductible contributions on his or her Form 8606 for any tax year, he or she must pay a penalty of $100 for each overstatement, unless it was due to reasonable cause. There is also a $50 penalty for failure to file 8606, unless the individual can prove that the failure was due to reasonable cause. 3. Tax on earnings on non-deductible contributions. As long as contributions are within the contribution limits, none of the earnings or gains on contributions will be taxed until they are distributed. 4. Cost basis. Individuals will have a cost basis in their traditional IRA if they made any non-deductible contributions. Their cost basis is the sum of the non-deductible contributions to their IRA, minus any withdrawals or distributions of non-deductible contributions. Commonly, distributions from a traditional IRA will include both taxable and non-taxable amounts. Inherited IRAs. Individuals who inherit a traditional IRA are referred to as a beneficiary. A beneficiary can be any person or entity the owner chooses to receive the benefits of the IRA after he or she dies. Beneficiaries of a traditional IRA must include in their gross income any taxable distributions they receive. 1. Inherited from a spouse. Individuals who inherit a traditional IRA from a spouse generally have the following three choices. Treat it as their own IRA by designating themselves as the account owner. Treat it as their own by rolling it over into their traditional IRA, or to the extent it is taxable, into a qualified employer plan, qualified employee annuity plan, tax-sheltered annuity plan, deferred compension plan of a state or local government, or treat themselves as the beneficiary rather than treating the IRA as their own. 2. Inherited from someone other than a spouse. If an individual inherits a traditional IRA from anyone other than his or her deceased spouse, He or she cannot treat the inherited IRA as his or her own. This means that the individual cannot make any contributions to the IRA. It also means he or she cannot roll over any amounts into or out of the inherited IRA. However, the individual can make a trustee-to-trustee transfer as long as the IRA into which amounts are being moved is set up and maintained in the name of the deceased IRA owner for the benefit of the individual as a beneficiary. Like the original owner, the individual generally will not owe tax on the assets in the IRA until he or she receives distributions from it. He or she must begin receiving distributions from the IRA under the rules for distributions that apply to beneficiaries. 3. IRA with basis. If an individual inherits a traditional IRA from a person who had a basis in the IRA because of non-deductible contributions, that basis remains with the IRA, with very few exceptions. The beneficiary cannot combine this basis with any basis that he or she has in his own traditional IRA, or any basis in traditional IRAs he or she inherited from other decedents. If the individual takes distributions from both an inherited IRA and his or her IRA, and each has basis, he or she must complete separate Forms 8606 to determine the taxable and non-taxable portions of these contributions. 4. Federal estate tax deduction. A beneficiary may be able to claim a deduction for estate tax resulting from certain distributions from a traditional IRA. The beneficiary can deduct the estate tax paid on any part of a distribution that is income in respect of a decedent. He or she can take the deduction for the tax year the income is reported. Any taxable part of a distribution that is not income in respect to a decedent is a payment the beneficiary must include in income. However, the beneficiary cannot take any estate tax deduction for this part. A surviving spouse can roll over the distribution to another traditional IRA and avoid including it in income for the year received. Moving retirement plan assets. Individuals can transfer tax-free assets, money or property, from the other retirement programs, including traditional IRAs, to a traditional IRA. The following types of transfers are permissible: transfers from one trustee to another, rollovers, and transfers incident to a divorce. 1. Transfers to Roth IRAs. Under certain conditions, individuals can move assets from a traditional IRA to a Roth IRA. 2. Trustee-to-trustee transfer. A transfer of funds in an individual's traditional IRA from one trustee directly to another, either at the individual's request or at the trustee's request, is not a rollover, because there is no distribution to the owner. The transfer is tax-free. Because it is not a rollover, it is not affected by the 1-year waiting period required between rollovers. 3. Rollovers. Generally, a rollover is a tax-free distribution to the owner of cash or other assets from one retirement plan that the owner contributes to another retirement plan. The contribution to the second retirement plan is called the rollover contribution. An amount rollover tax fee from one retirement plan to another is generally includable in income when it is distributed from the second tax plan. It is permissible to roll over amounts from the following plans to a traditional IRA: a traditional IRA, an employer's qualified retirement plan for employees, a deferred compensation plan of an estate or local government, or a tax-sheltered annuity plan. Individuals cannot deduct a rollover contribution. It must, however, be reported on the individual's tax return. In addition, a written explanation of rollover treatment must be given to the owner by the plan, other than an IRA making this distribution. Individuals may be able to roll over, tax-free, a distribution from their traditional IRA into a qualified plan. These plans include the Federal Thrift Savings Fund, deferred compensation plans of state or local governments, and tax-sheltered annuity plans. The part of the distribution that an individual can roll over is the part that would otherwise be taxable. Qualified plans may, but are not required to, accept such rollovers. Ordinarily, when an individual has basis in his or her IRAs, any distribution is considered to include both non-taxable and taxable amounts. Without a special rule, the non-taxable portion of such a distribution cannot be rolled over. However, a special rule treats a distribution he or she rolls over into an eligible retirement plan as including only otherwise taxable amounts, if the amount the individual either leaves in his or her IRAs or does not roll over is at least equal to his or her basis. The effect of this special rule is to make the amount in the individual's traditional IRAs that he or she can roll over to an eligible retirement plan as large as possible. The following are considered eligible retirement plans: individual retirement arrangements, qualified trusts, qualified employee annuity plans under Section 403, deferment compensation plans of state and local governments, tax-sheltered annuities. 4. Time limit for making a rollover contribution. Individuals generally must make the rollover contribution by the 60th day after they receive the distribution from their traditional IRA or their employer's plan. The IRS may waive the 60-day requirement where the failure to do so would be against equity or good conscience, such as in the event of a casualty, disaster, or other event beyond the individual's reasonable control. In the absence of a waiver, amounts not rolled over within the 60-day period do not qualify for tax-free rollover treatment. Individuals must treat them as a taxable distribution from either their IRA or their employer's plan. These amounts are taxable in the year distributed. Even if the 60-day period expires in the next year, individuals may also have to pay a 10% additional tax on early distributions. Unless there is a waiver or an extension of the 60-day rollover period, any contribution an individual makes to his or her IRA more than 60 days after the distribution is a regular contribution, not a rollover contribution. The 60-day rollover requirement is waived automatically only if all the following apply. The financial institution receives the funds on the owner's behalf before the end of the 60-day rollover period. The owner followed all the procedures set by the financial institution for depositing the funds into an eligible retirement plan within the 60-day period. The funds are not disposed into an eligible retirement plan within a 60-day rollover period solely because of an error on the part of the financial institution. The funds are deposited into an eligible retirement plan within 1 year from the beginning of the 60-day rollover period. If it would have been a valid rollover if the financial institution had deposited the funds as instructed, individuals who do not qualify for an automatic waiver may apply to the IRS for a waiver of the 60-day rollover requirement. To apply for a waiver, the individual must submit a request for a letter ruling under the appropriate IRS revenue procedure. A user fee must be paid with the application. In determining whether to grant a waiver, the IRS will consider all relevant facts and circumstances, including whether errors were made by the financial institution other than those described regarding automatic waivers above, whether the individual was unable to complete the rollover due to death, disability, hospitalization, incarceration, restrictions imposed by a foreign country or postal error, whether the individual used the amount distributed, and how much time has passed since the date of distribution. The rules regarding the amount that can be rolled over within the 60-day time period also apply to the amount that can be deposited due to a waiver. For example, if an individual received $6,000 from their IRA, the most they can deposit into an eligible retirement plan due to a waiver is $6,000. 5. Rollover from one IRA to another. Individuals can withdraw tax-free all or part of the assets from one traditional IRA if he or she reinvests them within 60 days in the same or another traditional IRA. Because this is a rollover, the individual cannot deduct the amount that he or she invests in the IRA. An individual may be able to treat a contribution made to one type of IRA as having been made to a different type of IRA. This is called recharacterizing the contribution. 6. Waiting period between rollovers. Generally, if an individual makes a tax-free rollover of any part of a distribution from a traditional IRA, he or she cannot, within 1 year period, make a tax-free rollover of any later distribution from that same IRA. The individual also cannot make a tax-free rollover of any amount distributed within the same 1 year period. From the IRA into which he or she made the tax-free rollover, the 1 year period begins on the date the individual receives the IRA distribution, not on the date he or she rolls it over into an IRA. Individuals can make only one rollover from an IRA to another in a 1 year period, regardless of the number of IRAs they own. The limit will apply by aggregating all of an individual's IRAs, including SEP and simple IRAs, as well as the traditional and Roth IRAs, effectively treating them as one IRA for purposes of the limit. However, trustee-to-trustee transfers between IRAs are not limited, and rollovers from traditional IRAs to Roth IRAs are not limited. 7. Partial rollovers. If an individual withdraws assets from a traditional IRA, he or she can roll over part of the withdrawal tax fee and keep the rest of it. The amount the individual keeps will generally be taxable, except for the part that is a return of non-deductible contributions. The amount kept may be subject to a 10% additional tax on early distributions. Amounts that must be distributed during a particular year under the required distribution rules are not eligible for rollover treatment. 8. Withholding requirement. Generally, if an eligible rollover distribution is paid directly to an individual, the payer must withhold 20% of it. This applies even if the individual plans to roll over the distribution to a traditional IRA. Withholding can be avoided by selecting a direct rollover. The 20% withholding requirement does not apply to distributions that are not eligible rollover distributions. However, other withholding rules apply to these distributions. The rules that apply depend on whether the distribution is a periodic distribution or a non-periodic one. For either of these types of distributions, individuals can still choose not to have tax withheld. 9. Direct rollover option. An employer's qualified plan must give individuals the option to have any part of the eligible rollover distribution paid directly to a transfer IRA. The plan is not required to give employees this option if their eligible rollover distributions are expected to total less than $200 for the year. If an individual chooses the direct rollover option, no tax is withheld from any part of the designated distribution that is directly paid to the trustee of the traditional IRA. If any part is paid to the individual, the payer must withhold 20% of that part's taxable amount. If an individual decides to roll over any part of distribution, the direct rollover option will generally be to his or her advantage. This is because they will not have 20% withholding or be subject to 10% additional tax under that option. If an individual has a lump sum distribution and does not plan to roll over any part of it, the distribution may be eligible for special tax treatment that could lower the individual's tax for the distribution year. The once-a-year limit on IRA to IRA rollovers does not apply to eligible rollover distributions from an employer plan. Individuals can roll over more than one distribution from the same employer plan within a year. 10. Life insurance contract. Individuals cannot roll over a life insurance contract from a qualified plan into a traditional IRA. 11. Co-plans and rollovers. If an individual is self-employed, he or she is generally treated as an employee for rollover purposes. Consequently, if he or she receives an eligible rollover distribution from a co-plan, a qualified plan with at least one self-employed participant, he or she can roll over all or part of the distribution into a traditional IRA. 12. Distribution from a tax-sheltered annuity. If an individual receives an eligible rollover distribution from a tax-sheltered annuity plan, he or she can roll it over into a traditional IRA. 13. Transfers incident to divorce. If an interested in a traditional IRA is transferred from a spouse or former spouse to an individual by a divorce or separate maintenance decree or a written document related to such a decree, the interest in the IRA, starting from the date of the transfer, is treated as that individual's IRA. The transfer is tax-free. There are two commonly used methods for transferring IRA assets to a spouse or former spouse. These methods are 1. Changing the name on the IRA, and 2. Making a direct transfer of IRA assets. If an individual's spouse or former spouse is allowed to keep his or her portion of the IRA assets in that individual's existing IRA, they can direct the trustee to transfer the assets the individual is permitting to keep directly to a new or existing traditional IRA, which is set up in their name. The name on the IRA containing the individual's spouse or former spouse's portion of the assets would then be changed to show his or her ownership. If the transfer results in a change in the basis of the traditional IRA of either spouse, both spouses must file Form 8606 and follow the directions in the instructions for that form. 2. Converting from any traditional IRA into a Roth IRA. Individuals can withdraw all or part of the assets from a traditional IRA and reinvest them within 60 days in a Roth IRA. The amount that an individual withdraws and timely contributes to the Roth IRA is called a conversion contribution. If properly and timely rolled over, the 10% additional tax on early distributions will not apply. However, a part or all of the distribution from your traditional IRA may be included in gross income and subjected to ordinary income tax. Individuals must roll over into the Roth IRA the same property they received from the traditional IRA. They can roll over part of the withdrawal into the Roth IRA and keep the rest of it. The amount individuals keep will generally be taxable and may be subject to the 10% additional tax on early distributions. 1. Periodic distributions. If an individual has started taking substantially equal periodic payments from a traditional IRA, he or she can convert the amounts into a traditional IRA to a Roth IRA and then continue the periodic payments. The 10% additional tax on early distributions will not apply even if the distributions are not qualified distributions. 2. Required distributions. Individuals cannot convert amounts that must be distributed from their traditional IRA for a particular year. 3. Income. Individuals must include in their gross income distributions from traditional IRA that they would have had to include the income if they had not converted them into a Roth IRA. They are not required to include gross income, however, any part of the distribution from the traditional IRA that is a return of their basis. B. Recharacterizations. Individuals may be able to treat a contribution made to one type of IRA as having been made to a different type of IRA. This is called recharacterizing the contribution. To recharacterize a contribution, an individual generally must have the contribution transferred from the first IRA, the one to which it was made, to the second IRA in a trustee-to-trustee transfer. If the transfer is made by the due date, including extensions, for the individual's tax return for the year during which the contribution was made, he or she can elect to treat the contribution as having been originally made to the second IRA instead of the first. Please note, Under a new provision of the Tax Cuts and Jobs Act of 2017, the special rule that allows a contribution to one type of IRA to be recharacterized as a contribution to another type does not apply to the conversion contribution to Roth IRA. Thus, recharacterization cannot be used to unwind a Roth conversion. However, recharacterization is still permitted with respect to other contributions. For example, an individual may make a contribution for a year to a Roth IRA, and before the due date, for the individual's income tax return for that year, recharacterize it as a contribution to a traditional IRA. Requirements. If an individual chooses to recharacterize his or her contribution, he or she must do all three of the following: include the transfer any net income allocable to the contribution. If there was a loss, the net income the individual must transfer may be a negative amount. Report the recharacterization on the individual's tax return for the year during which the contribution was made. And treat the contribution as having been made to a second IRA on the date it was actually made to the first IRA. 2. No deduction allowed. Individuals may not deduct the contribution to the first IRA. Any net income they transfer with the recharacterized contribution is treated as earned in the second IRA. The contribution will not be treated as having been made to the second IRA to the extent any deduction was allowed for the contribution to the first. 3. Effect of previous tax-free transfers. If an amount has been moved from the IRA to another in a tax-free transfer, such as a rollover, the individual generally cannot recharacterize the amount that was transferred. Roth IRA conversion contributes from a SEP, IRA, or simple IRA can be recharacterized to a SEP, IRA, or simple IRA, including the original SEP, IRA, or simple IRA, if an individual mistakenly rolls over or transfers an amount from the traditional IRA to a simple IRA. He or she can later recharacterize the amount as a contribution to another traditional IRA. 4. Recharacterizing excess contributions. Individuals can recharacterize only actual contributions if an individual is applying excess contributions for prior years as current contributions. He or she can recharacterize them only if the recharacterization would still be timely with respect to the tax year for which the applied contributions were actually made. 5. Recharacterizing employer contributions. Individuals cannot recharacterize employee contributions, including elective deferrals, under SEP or simple plan as contributions to another IRA. 6. Recharacterization not counted as a rollover. The recharacterization of a contribution is not treated as a rollover for purposes of the one-year waiting period. This is true even if the contribution would have been treated as a rollover contribution by the second IRA, if it had been made directly to the second IRA rather than as a result of recharacterization of a contribution to the first. 7. Reconversions. Individuals cannot convert and reconvert an amount during the same taxable year, or, if later, during the 30-day period following a recharacterization. If an individual reconverts during either of these periods, it'll be a failed conversion. C. Recharacterization of contributions. To recharacterize a contribution, individuals must notify both the trustee of the first IRA and the trustee of the second IRA that the person has elected to treat the contribution as having been made to the second IRA rather than the first. The individual must make the notifications by the date of the transfer. Only one notification is required if both IRAs are mandated by the same trustee. The notification must include all of the following information: the type and amount of the contribution to the first IRA that is to be recharacterized, the date on which the contribution was made to the first IRA and the year for which it was made, a direction to the trustee of the first IRA to transfer in a trustee-to-trustee transfer amount of the contribution and any net income or loss allocable to the contribution to the trustee of the second IRA, the name of the trustee of the first IRA and the name of the trustee in the second IRA, and any additional information needed to make the transfer. The election to recharacterize and the transfer both must take place on or before the due date, including extensions for filing the tax return for the year for which the contribution was made to the first IRA. 1. Extension. Ordinarily, an individual must choose to recharacterize a contribution by the due date of the return, or the due date plus extensions. However, if he or she misses this deadline, he or she can still recharacterize a contribution. If his or her return was timely filed for the year choice should have been made, and the individual takes appropriate corrective action within 6 months from the due date of his or her return, including extensions. 2. Appropriate corrective action. Appropriate corrective action consists of notifying the trustees of the intent to recharacterize, providing the trustees with all necessary information, and having the trustee transfer the contribution. Once this is done, the individual must amend his or her return to show the recharacterization. 3. Decedent. An election to recharacterize can be made on behalf of a deceased IRA owner by the executor, administrator, or another person responsible for filing the decedent's final income return. 4. Election cannot be changed. After the transfer has taken place, an individual cannot change his or her election to recharacterize. 5. Same trustee. Recharacterizations made with the same trustee can be made by redesignating the first IRA as the second IRA rather than transferring the account balance. D. Reporting a recharacterization. If an individual elects to recharacterize a contribution of one IRA as a contribution to another IRA, he or she must report the recharacterization on his or her own tax return, as directed from Form 8606 and its instructions. The individual must treat the contribution as having been made to the second IRA. 3. Distributions. A. When assets must be withdrawn. Individuals cannot keep funds in a traditional IRA indefinitely. Eventually, they must be distributed. If there are no distributions, or if the distributions are not large enough, the owner may have to pay a 50% excise tax on the amount not distributed as required. The requirements for distributing IRA funds differ, depending on whether an individual is the IRA owner or the beneficiary of a decedent's IRA. The amount that must be distributed each year is referred to as the required minimum distribution. Note also that amounts that must be distributed, required minimum distributions, during a particular year are not eligible for rollover treatment. B. IRA owners. If an individual is the owner of a traditional IRA, he or she must start receiving distributions from the IRA by April 1st of the following year, in which he or she reaches 70.5 years old. April 1st of the year following the year in which he or she reaches the age of 71.5 is referred to as the required beginning date. Persons must receive at least a minimum amount each year starting with the year they reach the age of 70.5. If individuals do not receive that minimum amount in their 70.5 year, then they must receive distributions for their 70.5 year by April 1st of the next year. If an IRA owner dies after reaching age 70.5, but before April 1st of the next year, no minimum distribution is required, because death occurred before the required beginning date. Even if individuals begin receiving distributions before they reach 70.5, they must still begin calculating and receiving required minimum distributions by their required beginning date. More than the minimum received. If in any year an individual receives more than the required minimum distribution for that year, he or she will not receive credit for the additional amount when determining the minimum required distribution for future years. This does not mean that the person does not reduce his or her IRA account balance. It means that if he or she receives more than his or her required minimum distribution in one year, he or she cannot treat the excess, the amount that is more than the required minimum distribution, as part of his or her required minimum distribution for any later year. However, any amount distributed in any individual 70.5 year will be credited toward the amount that must be distributed by April 1st of the following year. 2. Distributions after the required beginning date. The required minimum distribution for any year after the year the owner of the IRA turns 70.5 must be made by December 31st of that year. C. Figuring the owner's required minimum distribution. An individual required minimum distribution for each year can be figured by dividing the IRA account balance, defined next, as one of the close of businesses of December 31st of the preceding year by the applicable distribution period or life expectancy. 1. IRA account balance. The IRA account balance is the amount in the IRA at the end of the year preceding the year for which the required minimum distribution is being figured. Contributions increase the amount balance of the in-year that they are made. If a contribution for last year is not made until after December 31st of last year, it increases the account balance for this year, but not for last year. Contributions made after December 31st of last year in determining an individual's required minimum distribution for this year should be disregarded. 2. Distributions. Distributions reduce the account balance in the year they are made. If a distribution for last year is not made until after December 31st of last year, it reduces the account balance for this year, but not for last year. Disregard distributions made after December 31st of last year in determining an individual's required minimum distribution for the year. 3. Distribution period. This is the maximum number of years over which an individual is allowed to take distributions from his or her IRA. 4. Life expectancy. The IRS publishes life expectancy tables for the use in this calculation. D. IRA beneficiaries. The rules for determining required minimum distributions for beneficiaries depend on who is the beneficiary. 1. Surviving spouse. If the beneficiary is the surviving spouse, who is the sole beneficiary of his or her deceased spouse's IRA, he or she may elect to be treated as the owner and not as the beneficiary. If the spouse elects to be treated as the owner, he or she must determine the required minimum distribution, if any, as if he or she was the owner beginning with the year he or she elects or is deemed to be the owner. However, if the individual becomes the owner in the year his or her deceased spouse dies, he or she is not required to determine the required minimum distribution for that year using his or her own life. Rather, he or she can take the deceased owner's required minimum distribution for that year to the extent it was not only already distributed to the owner before his or her death. 2. Taking balance within 5 years. A beneficiary who is an individual may be required to take the entire account by the end of the 5th year, following the year of the owner's death. If this rule applies, no distribution is required for any year before that 5th year. 3. Death of a beneficiary. If a person who is a beneficiary as the owner's date of death dies before September 30th of the year following the year of the owner's death without disclaiming entitlement to benefits, that individual, rather than his or her successor beneficiary, continues to be treated as a beneficiary for determining the distribution period. 4. Death of surviving spouse. If a designated beneficiary is the owner's surviving spouse, and he or she dies before he or she is required to begin receiving distributions, the surviving spouse will be treated as if he or she were the owner of the IRA. However, this rule does not apply to the surviving spouse of a surviving spouse. E. Miscellaneous rules for required minimum distributions. 1. Installments allowed. The yearly required minimum distribution can be taken in a series of installments, monthly, quarterly, etc., as long as the total distributions for the year are at least as much as the minimum required amount. 2. More than one IRA. If an individual has more than one traditional IRA, he or she must determine a separate required minimum distribution for each IRA. However, he or she can total these minimum amounts and take the total from any one or more of the IRAs. 3. More than minimum received. If in any year an individual receives more than the required minimum amount for that year, he or she will not receive credit for the additional amount when determining the minimum required amount for future years. This does not mean that he or she does not reduce his or her IRA account balance. It means that if he or she receives more than his or her required minimum distribution in one year, he or she cannot treat the excess, the amount that is more than the required minimum distribution, as part of his or her required minimum distribution for any later year. However, any amount distributed to their 70.5 year will be credited toward the amount that must be distributed by April 1st of the following year. 4. Multiple individual beneficiaries. If as of September 30th of the year following the year in which the owner dies, there is more than one beneficiary, the beneficiary with the shortest life expectancy will be the designated beneficiary if both of the following apply. All of the beneficiaries are individuals, and the account or benefit has not been divided into separate accounts or shares for each beneficiary. 5. Separate accounts. Separate accounts with separate beneficiaries can be set up at any time, either before or after the owner's required beginning date. If separate accounts with separate beneficiaries are set up, the separate accounts are not combined for required minimum distribution purposes until the year after the separate accounts are established, or, if later, the date of death. As a general rule, the required minimum distribution rules separately apply to each account. However, the distribution period for an account is separately determined, disregarding beneficiaries of the other accounts, only if the account was set up by the end of the year following the year of the owner's death. The separate account rules cannot be used by beneficiaries of a trust. 6. Trust as beneficiary. A trust cannot be designated beneficiary even if it is a named beneficiary. However, the beneficiaries of a trust will be treated as having been designated as beneficiaries if all of the following are true. The trust is a valid trust under the state law, or would be but for the fact that there is no corpus. The trust is irrevocable, or became, by its terms, irrevocable upon the death of the owner. The beneficiaries of the trust who are beneficiaries with respect to the trust interest in the owner's benefit are identifiable from the trust instrument, and the trustee of the trust provides the IRA custodian or trustee with the documentation required by that custodian or trustee. The trustee of the trust should contact the IRA custodian or trustee for details on the documentation required for a specific plan. The deadline for providing the beneficiary documentation to the IRA trustee, custodian, or issuer is October 31st, or the year following the year of the owner's death. If the beneficiary is the trust on another trust, and the above requirements for both trusts are met, the beneficiaries of the other trust will be treated as having been designated as beneficiaries for purposes of determining distribution periods. The separate account rules cannot be used by beneficiaries of a trust. F. Taxation of distributions. In general, distributions from a traditional IRA are taxable in the year they are received. Distributions from traditional IRAs included in income are taxed as ordinary income. 1. Distributions fully or partly taxable. Distributions from a traditional IRA may be fully or partially taxable, depending on whether the individual's IRA includes any non-deductible contributions. If only deductible contributions were made to an individual's traditional IRA, because he or she has no basis in his or her IRA, any distributions are fully taxable when received. If an individual made non-deductible contributions to any of his or her traditional IRAs, the individual has a cost basis equal to the amount of those contributions. These non-deductible contributions are not taxed when they are distributed. They are a return of the individual's investment in his or her IRA. Only the part of the distribution that represents non-deductible contributions and rolled over after tax amounts is tax-free. If non-deductible contributions have been made or after tax amounts have been rolled over into the IRA, distributions consist partly of non-deductible contributions and partly of deductible contributions, earnings, and gains. Until all of an individual's basis has been distributed, each distribution is partly non-taxable and partly taxable. Recognizing losses on traditional IRA investments. If an individual has a loss on his or her traditional IRA investment, he or she can recognize the loss of his or her income tax return, but only when all amounts in all the individual traditional IRA accounts have been distributed and the total distributions are less than the individual's unrecovered basis, if any. The individual's basis in the total amount of the non-deductible contributions in her traditional IRA. The individual can claim the loss as a miscellaneous itemized deduction subject to the 2% of adjusted gross income limit that applies to certain miscellaneous itemized deductions on Schedule A, Form 1040. Any such losses are added back to taxable income for purposes of calculating the alternative minimum tax. 3. Withholding. Federal income tax is withheld from distributions from traditional IRAs unless the owner chooses not to have tax withheld. The amount of tax withheld from an annuity or similar periodic payment is based on the individual's marital status and the number of withholding allowances he or she claims on his or her withholding certificate, Form W-4P. If an individual has not filed a certificate, tax will be withheld as if the individual were a married individual claiming 3 withholding allowances. Generally, tax will be withheld at a 10% rate on non-periodic distributions. Acts that result in penalties or additional taxes. The tax advantage of using traditional IRAs for retirement savings can be offset by the additional taxes and penalties if an individual does not follow the rules. There are additions to the regular tax for using your IRA funds in prohibited transactions. There are also additional taxes for the following activities: investing in collectibles, making excess contributions, taking early distributions, and allowing excess amounts to accumulate, failing to take required distributions. There are penalties for overstating the amount of non-deductible contributions and for failure to file Form 8606 if required. A. Prohibited transactions. Generally, a prohibited transaction is any improper use of a traditional IRA account by annuity by the owner, their beneficiary, or any qualified person. Disqualified persons include the individual's fiduciary and members of their family. The following are examples of prohibited transactions with a traditional IRA: borrowing money from it, selling property to it, using it as security for a loan, and buying property for personal use. 1. Fiduciary. A fiduciary includes anyone who does any of the following: exercise any discretionary authority or discretionary control in managing an individual IRA, or exercises any authority or control in managing or disposing of its assets, provides investment advice to the individual's IRA for a fee, or has any authority or responsibility to do so, or has any discretionary authority or discretionary responsibility in administering the individual's IRA. 2. Effect on an IRA account. Generally, if an owner or his or her beneficiary engages in a prohibited transaction in connection with a traditional IRA account, at any time during the year, the account stops being an IRA as of the first day of that year. 3. Effect on owner or beneficiary. If an individual's account stops being an IRA because of the individual or his or her beneficiary engaged in a prohibited transaction, the account is treated as distributing all its assets to the owner of the account at their fair market values on the first day of the year. If the total of those values is more than the individual basis in the IRA, he or she will have a taxable gain that is includable in his or her income. The distribution may be subject to additional taxes and penalties. 4. Borrowing on an annuity contract. If an individual borrows money against his or her traditional IRA annuity contract, he or she must include in his or her gross income the fair market value of the annuity contract as of the first day of their tax year. The individual may have to pay the 10% additional tax on early distributions. 5. Pledging on account as security. If an individual uses a part of his or her traditional IRA account as security for a loan, that part is treated as a distribution and is included in the individual's gross income. He or she may have to pay the 10% additional tax on early distribution. 6. Owner participation. If an individual participates in the prohibited transaction with his or her employer or the association, his or her account is no longer treated as an IRA. 7. Taxes on prohibited transactions. If someone other than the owner or beneficiary of a traditional IRA engages in a prohibited transaction, that person may be liable for certain taxes. In general, there is a 15% tax on the amount of prohibited transaction and a 100% additional tax if the transaction is not corrected. B. Exempt transactions. The following two types of transactions are not prohibited transactions if they meet the requirements that follow. 1. Payments of cash, property, or other consideration by the sponsor of the individual's traditional IRA to themselves or to members of the family. Even if a sponsor makes payments to an individual of his or her family, there is no prohibited transaction if all three of the following requirements are met. A. The payments are for establishing a traditional IRA or for making additional contributions to it. B. The IRA is established solely to benefit the individual, his or her spouse, and the individual or the individual's spouse's beneficiaries. C. During the year, the total fair market value of the payments the individual receives is not more than $10 for IRA deposits or less than $5,000, or $20 for IRA deposits of $5,000 or more. If the consideration is group term life insurance, requirements A and C do not apply. If no more than $5,000 of the face value of the insurance is based on a dollar-for-dollar basis on the assets in the individual IRA. 2. The receipt of services at reduced or no cost from the bank where the traditional IRA is established or maintained. Even if a sponsor provides services at a reduced or no cost, there is no prohibited transaction if all 5 of the following requirements are met. A. The traditional IRA qualifying the individual that receives the services is established and maintained for the benefit of the individual, his or her spouse, and his or her beneficiaries. B. The bank itself can legally offer the services. C. The services are provided in the ordinary course of business by the bank or bank affiliate to customers who qualify but do not maintain an IRA or a co-plan. D. The determination for a traditional IRA of who qualifies for these services is based on an IRA or a co-plan deposit balance equal to the lowest qualifying balance for any other type of account. And E. The rate of return on a traditional IRA investment that qualifies is not less than the return of an identical investment that could have been made at the same time at the same branch of the bank by a customer who is not eligible for these services. C. Investment in collectibles. If an individual traditional IRA invests in collectibles, the amount invested is considered distributed to them in the year invested. The individual may have to pay the 10% additional tax on early distributions. Collectibles include artworks, rugs, antiques, metals, gems, stamps, coins, alcoholic beverages, and certain other tangible personal properties. An individual IRA can invest in 1/2, 1/4, or 1/10 ounce U.S. gold coins, or 1-ounce silver coins minted by the Treasury Department. It can also invest in certain platinum coins and certain gold, silver, palladium, and platinum bullion. D. Taxes on excess contributions. In general, if the excess contributions for a year are not withdrawn by the date an individual's return for the year is due, including extensions, the individual is subject to a 6% tax. The individual must pay the 6% tax each year on excess amounts that remain in his or her traditional IRA at the end of his or her tax year. The tax cannot be more than 6% of the value of an IRA as of the end of the tax year. An individual does not have to pay the 6% tax if he or she withdraws the excess contribution made during a tax year and he or she also withdraws any interest or other income earned on the excess contribution. The individual must complete the withdrawal by the date the tax return for the year is due, including extensions. Chapter 11. U.S. Tax Issues to Watch. Takeaways. Tax rules survive death. If you are non-compliant, you may be leaving a mess for your family to clean up. If you are U.S. exposed, citizen, green card, or substantial presence, you are usually taxed on your worldwide income. These tax obligations do not stop because you reside outside the U.S. Even if your earnings are under the threshold of the Foreign Earned Income Exclusion and you reside outside of the U.S., you may still have to file U.S. tax returns. Since the early 1970s, U.S. persons have been obligated to report any foreign financial assets once the maximum aggregate balance exceeds a certain threshold. Tax rules survive death. In our practice, we often find that U.S. exposed persons do not know that U.S. tax delinquency may survive death. On April 27, 2020, yet another U.S. District Court took the position that penalties for willful failure to file foreign bank and financial account reports can survive the death of the penalized non-filer. Do not leave problems for your family. Domicile, gift, and estate taxes. It is nearly impossible to have a meaningful discussion on the U.S. gift, estate, and generation skipping transfer tax without first exploring the concept of domicile. Unlike the statutory definition that can be found to determine resident alien versus non-resident alien NRA status, there is no such definition for U.S. transfer tax purposes, and instead of the facts and circumstances must be reviewed in detail to determine if someone is a U.S. resident alien domiciliary versus a non-resident alien domiciliary. The concept of residence for income tax purposes should not be equalized with residence for estate and gift tax purposes. This is a common mistake. The objective residence definitions under 7701B and the final regulations thereunder issued on April 24, 1992 do not affect the definition of residence for federal estate and gift tax purposes. For estate and gift tax purposes, residence in the U.S. requires physical presence in some place in the U.S. and the intention to make that place a fixed and permanent home. Therefore, the determination of residence in this context must be made independently from the determination of residence for income tax purposes. Also, one's immigration status is not determinative of such a person's U.S. estate and gift tax residence, but is merely a factor in that determination. Because the estate and gift tax regulations in this area are unclear and inconclusive, the determination of a person's residence for estate and gift tax purposes constitutes a difficult and subjective factual determination. 1. Intention and overt act. The estate and gift tax regulations define residence in terms of domicile. A resident, descendant, and descendant who, at the time of his death, had a domicile in the United States. A person acquires a domicile in a place by living there, or even a brief period of time, with no definite present intention of later removing therefrom. Residence without the requisite intention to remain indefinitely will not suffice to constitute domicile, nor will intention to change domicile affect such a change unless accompanied by actual removal. Illustrative cases. Domicile for estate and gift tax purposes is a rather nebulous concept. Thus, although many cases have dealt with the issue, no clear-cut rule has evolved. However, even though most of such cases are old, the decisive factors noted therein may serve as useful guidelines. The decedent, a U.S. citizen, was born in New York in 1870. Between 1912 and 1920, she traveled back and forth between the U.S. and France. In March 1920, she returned to France and lived there until her death in 1932. The decedent's purpose for remaining in France was to seek medical advice for her diabetes and to help her cousin who was experiencing marital difficulties. In addition, she had often stated to a cousin that she intended to return to the U.S. when she regained her health and her cousin's problems were resolved. Whenever she renewed her passports, she stated her reason to travel abroad to be temporary residence and travel, but in later renewals she stated her foreign stay may be indefinite. She always stated her domicile as the U.S., paid U.S. taxes until her death, and never claimed foreign citizenship. The service attempted to classify her as a non-resident descendant for estate tax purposes by arguing that her prolonged stay in France caused her domicile to change. Under the applicable rules at the time of her death, non-resident descendant status would have adversely affected her estate's right to an exemption and deduction of certain expenses. The court, in finding her to be a resident decedent, stated, "Two facts must exist to effect a change over to a new domicile of choice, both resident in the new place and an intention to make the new residence a permanent home. There must be both the fact and the intent." The decedent, who was born in Switzerland in 1883 and died there in 1941, had stated under oath in various documents and in visas, re-entry permits, and tax returns that he was a U.S. resident. Upon the decedent's death, the service attempted to tax him as a U.S. resident. In addition to his dying in Switzerland, the decedent had retained his home and business interests there, and had remained active with Swiss charities and civic organizations. To the court, the problem was not whether or not the decedent had obtained various benefits by perjured statements, but whether or not he was a resident for U.S. estate tax purposes. In finding him not to be, the court stated, "Resident for estate tax purposes is one who at the time of his death had his domicile in the United States. Intention of the person is extremely important. Domicile is the place in which he regards as his home, and where he intends to live. His old domicile continues until it appears that he intends to live there no longer, but has an intention to make his home henceforth at some other place and remain there indefinitely. Because the decedent died in Switzerland, retained his home and business interests there, and remained active with Swiss charities and civic organizations, the court concluded that he intended for that country to remain his domicile. C. An estate of paquet. The decedent, a Canadian citizen, was born in Canada in 1897. He operated 2 retail stores in Montreal. In addition, he owned 2 houses in Canada, one of which was located near stores in Montreal. The other house was utilized by the decedent as a country house, beginning in 1950 and up to the time of his death in 1975. The decedent made yearly vacation trips to Florida, generally during the winter months. Thus, the decedent would generally remain in Florida from October through April, returning to Canada for the summer. In 1955, the decedent retired and sold his business. In 1956, the decedent sold his house in Montreal, and in the early part of 1957, he purchased a house in Florida, which was furnished with the contents of the house he had sold in Montreal. After 1971, the decedent's wife became ill and was not able to accompany the decedent when he returned to Canada for the summer, in the fall of 1971. The decedent sold his country house because it required too much work to maintain, and he intended to buy a small house or rent an apartment in Montreal. In 1972, the decedent began to experience a series of illnesses, and he was hospitalized and treated in Florida. However, he continued to return to Canada to meet with his professional advisors and friends. In 1974, the decedent executed his last will and testament while in Montreal and stated therein that he was a resident of Canada. He returned to Florida in November 1974, and he remained there until he died in January 1975. In concluding that the decedent was domiciled in Canada, the court stated, "In addition to yearly visits to Canada, decedent maintained numerous contacts with his country of citizenship, which evidenced his intention to retain his Canadian domicile." Up until the date of his death, he filed income tax returns in Canada, he voted in Canada, and he maintained a valid Canadian driver's license as well as a valid Canadian passport. In addition, decedent's automobile was purchased, registered, and insured in Canada. Moreover, it was not without significance that most of the decedent's assets, valued at $556,351.76, were located in Canada. He met with Mr. LaRouche and Mr. Burgess regularly in Canada concerning his investments. In order to keep his old assets liquid, decedent's portfolio was divided between deposits in Canadian banks and stocks and bonds of Canadian corporations. Decedent returned yearly to manage his investments. Decedent met at least twice a year with Mr. LaRouche, at which time he personally made the decisions of when and where to invest his money. In fact, Mr. LaRouche was prohibited from making changes in decedent's portfolio unless he received personal authorization. After careful evaluation of all the evidence, including testimony by those who were well acquainted with decedent, we find that decedent never had any intention to establish a United States domicile. Decedent maintained many contacts with his native country, and followed a 25-year-old practice of spending winters in Florida. We find that decedent never intended to remain in the United States indefinitely. The decedent, a Pakistani citizen, had obtained an immigration long-term permanent residence alien green card and a social security number in part to help preserve certain U.S. subsidies. But the decedent died in Pakistan in 1991. And although the 1986 through 1990 U.S. individual income tax returns for the decedent had incorrectly been filed as non-resident forms 1040 NR amended forms 1040 were filed subsequent to the decedent's death. Decedent's estate was desirous of resident alien domiciliary status, and based its argument largely on decedent's possession of a green card. However, the service's position was that decedent and his wife were not resident alien domiciliaries of the U.S. at the time of his death, and the decedent's estate was not entitled to the full unified credit or the marital deduction. In a decision which, in the author's opinion, had numerous factors both for and against resident alien domiciliary status, the court, in finding resident alien domiciliary status, placed significant weight in the decedent's obtaining a permanent resident alien green card, plus a re-entry permit when he left the U.S. to return to Pakistan. The case further substantiates that possession of a green card is not conclusive in determining resident alien domiciliary status, although when taking into account all of the facts and circumstances, it can be an adverse factor. E. In estate of Jack. The parties filed cross motions for summary judgment to determine whether a Canadian citizen employed in the U.S. on the date of his death, having been admitted to the U.S. under a non-immigration temporary professional classification, was legally capable of forming an intent to be domiciled in the U.S. for federal estate tax purposes. The decedent's estate argued that the intent to establish domicile by the holder of a temporary professional visa would be indirect violation of the terms of the visa, so that such an intent would be precluded. The court granted summary judgment to the service, holding that for the federal estate tax purpose, a Canadian citizen employed in the U.S. on the date of his death, who is admitted to the U.S. under non-immigrant temporary professional classifications, was legally capable of forming an intent to be domiciled in the United States. Factors indicative of domicile. As indicated by the illustrative cases above, the factors which are considered in making the determination of whether an alien is a resident for the U.S. estate and gift taxation must demonstrate a certain degree of permanence in the U.S. on the part of an alien before he is classified as having a U.S. domicile. As expressed by the court in Safe Deposit and Trust Company of Baltimore 42 BTA, the acquisition of a domicile of choice involves actual physical presence at the dwelling place in another state, coupled with the concurrent intent to make it a home. Intention involves the idea of fixity, of some degree of permanence in the new abode, and must be more than the mere intention to acquire a new domicile. In the connection with the determination of domicile, some of the most common factors analyzed in the estate and gift tax context are: 1. The amount of time spent by the decedent in the U.S. and other countries, and the frequency of travel both between the U.S. and other countries and between places abroad. However, a period of extended physical presence in the U.S. alone will not suffice to establish a U.S. domicile. 2. The size and cost and nature of houses or other dwellings, and whether those places were owned or rented by the decedent. In a state of Folker, TC 1225, the decedent maintained a large home in New York and a smaller home in Switzerland. The tax court found the decedent to be a U.S. domiciliary. The court compared the size of the houses and their localities, and stressed that the location of the Swiss home in St. Moritz constituted a resort, pleasure-oriented community with international appeal. 3. The area or locality in which the houses and dwelling places are located. See Estate of Falker above. 4. The locations of expensive and cherished personal possessions of the decedent. See Farmer's Loan and Trust. 5. The location of the decedent's family and close friends. See Estate of Nahus. 6. The place where the decedent has maintained and participated in civil leagues, churches, clubs, etc. 7. The location of the decedent's business interests. 8. The location of the bulk of the decedent's assets, and the location of his professional advisors. 9. Where did the decedent file tax returns up until his death? 10. Declarations of residence or intent made in visa applications for reentry permits, wills, deeds of gift, trust, instruments, letters, and oral statements made by the decedent. For example, in Bank of New York and Trust Company 21 BTA, the decedent, a U.S. citizen, spent the last 5 years of her life traveling in France, Italy, and other countries in Europe. The court found that she was a U.S. resident, and that she did not have the intention to abandon her U.S. residence while in Europe, since her purposes for being there were pleasure and health. The decedent's declarations and actions indicated that her home was in the U.S., e.g., when applying for passport renewals, she stated that she was abroad only temporarily, and in 2 trust instruments and will executed by her described herself as a resident of Washington. 11. Whether the decedent used traveler's checks and international credit cards while in the U.S., rather than U.S.-issued credit cards and local accounts. 12. Whether the decedent obtained a used U.S. driver's license as opposed to an international one. 13. Whether the decedent acquired in his own name as opposed to renting an automobile in the U.S. 14. Whether the decedent spent holiday periods with his family, and if so, where. 15. Whether the decedent brought his family to the U.S. 16. Whether the decedent was engaged in political activity, such as voting, public or military service abroad. 17. Reasons or motivation for presence of the decedent in the U.S., e.g., health, pleasure, business, war or terrorism in home country or avoidance of political repression or instability in home country. Estate and gift taxes. The U.S. estate tax is imposed on the gross estate of the U.S. citizen and the U.S. resident. This phrase, wherever situated, imposes the estate and gift tax on worldwide assets. The estate tax and the gift tax attach to all assets, regardless of the location of U.S. cities or residence, or his property, at the time of gift or death. Citizens and non-citizens residents are afforded a unified credit against each estate tax and gift tax which currently shields assets. No gift tax or estate tax is actually payable by U.S. citizens and residents until the value of lifetime gifts and bequests exceed the unified credit. Transfers between U.S. citizens' spouses. U.S. citizens may delay the imposition of either the gift tax or the estate tax transfer between citizen spouses. Such as transfers may be accomplished during life or at death, and either by outright gift or through gifts in trust for the benefit of the other spouse. The first spouse to die may leave his or her entire estate to the surviving U.S. citizen spouse without triggering the estate tax. Thus, any estate tax owned by the first spouse to die may be delayed. This concept is known as the unlimited marital deduction. A U.S. citizen or resident may also port his or her individual exclusion amount to the surviving spouse. Any exclusion amount not used by the first spouse to die by lifetime and testamentary non-spousal gifts may therefore be transferred to the qualifying surviving spouse. The total amount of property excluded from the estate tax may therefore be pooled by the U.S. spouses. Certain limitations are, however, imposed on the marital deduction for property transferred to a non-U.S. citizen spouse. Testamentary transfers to non-citizen spouses. Marital deduction for bequests. The marital deduction on testamentary transfers to non-citizen spouses is restricted. If the surviving spouse is not a U.S. citizen, the survivor may not generally receive a bequest of the deceased spouse's estate tax-free. The restriction is intended to limit the risk that the surviving leaves the U.S. without a taxable estate. A shift in domicile would allow for avoidance of estate tax, as the survivor could permanently leave the U.S. and elude estate tax on worldwide assets. Qualified domestic trusts. Any U.S. citizen or U.S. resident with a U.S. estate may defer estate tax on testamentary transfers to a non-citizen spouse through a special trust. The grantor spouse must leave his or her estate to a qualified domestic trust as a condition to receiving the marital deduction. Only through QDOT may estate tax be deferred until the death of a non-citizen surviving spouse. If the non-citizen surviving spouse becomes a U.S. citizen before the deceased estate tax return is filed, direct bequests to the survivor will qualify for the marital deduction. If the surviving spouse later becomes a U.S. citizen, all QDOT assets may then be distributed directly to the survivor. To qualify for the marital deduction, the QDOT must 1. Be executed under U.S. law, 2. Have at least one trustee that is a U.S. corporation, and 3. Not allow distributions unless the trustee has the right to withhold tax on transfer from the trust to the surviving spouse. The executor of the first spouse to die must elect to treat the trust as a QDOT and pass property directly to the QDOT. Any distribution of principal from the QDOT to the non-citizen surviving spouse is subject to the estate tax at the time of distribution. Any principal remaining upon the death of a non-citizen spouse will also be subject to the estate tax. Treasury regulations permit a modified portability election to be made. Estates of non-residents, non-citizens, or RNCS may not, however, elect portability. The modified portability credit, applied through the QDOT, delays the imposition of estate tax until the death of the second citizen spouse. Upon the death of the non-citizen spouse, the first spouse unused estate tax exemption is applied. The determination of the amount exemption available to the non-citizen spouse involves a series of valuation procedures. The formula is influenced by the appreciation or depreciation of assets in the QDOT. Rules of administration exempt the QDOT from foreign trust. Lifetime gifts to citizen and non-citizen spouses. Only citizens enjoy an unlimited deduction. No tax imposed for lifetime spousal gifts. Similar to the restriction on tax-free testamentary gifts to non-citizen spouses, tax-free lifetime gifts are also limited. If the spouse receiving a lifetime gift is not a U.S. citizen, the gifting spouse may only deduct $147,000 in tax-free spousal gifts during any calendar year. The limitation on lifetime gift applies even if both spouses are domiciled in the U.S. The time of the gift, the domicile of both the donor and done is irrelevant. Annual lifetime gifts to non-citizen spouses are taxed on value exceeding $147,000. Interestingly, the limitation on gifts to non-citizen spouses does not limit tax-free gifts by non-citizen spouses to a U.S. citizen spouse. A NRNC considering U.S. residency should make any intended large spousal gifts of foreign property and U.S. intangible property before moving to the U.S. Once domiciled in the U.S., the grantor is subjected to the gift tax on all assets held worldwide. The U.S. grantor spouse then faces the $147,000 limitation on tax-free spousal gifts. This leaves the U.S. spouse the options of 1. Applying his or her remaining estate tax and gift tax exclusion, or 2. Deferring the gift until death. Deferral until death of the U.S. spouse will potentially avoid gift and estate tax entirely, though either 1. A testamentary QDOT trust, or 2. Applying the grantor's estate tax credit. Estate tax imposed on non-resident non-citizens. The estate tax imposed on non-resident non-citizens is limited to property owned, which at the time of the NRNC's death is situated in the United States. The U.S. taxable estate of an NRNC also includes U.S. assets held in a foreign or U.S. trust, generally controlled by or accessible to the NRNC. To avoid the estate tax, the NRNC should avoid having assets situated in the United States. To determine where an asset is situated, one must first look to the U.S. Treasury regulation, which deems certain assets U.S. CITES property. Such assets deemed located in the U.S. include U.S. real estate, stock in U.S. corporations, and certain tangible personal properties. Determining the CITES of other assets is a more factual inquiry. Factors include the owner's rights to the assets and the connections between the asset and a given country. Rate of estate tax and credit. The rate of estate tax imposed on NRNCs is identical to that imposed on U.S. citizens and U.S. residents. The estate tax credit for NRNCs is significantly lower than the credit allowed in U.S. citizens and residents. NRNCs are allowed only a $13,000 credit against the estate tax. The credit may not be applied against taxable gifts. Marital bequests are not taxable, but non-citizen spouses must receive testamentary gifts through a QDOT trust. The estate of an NRNC may not elect portability of any unused estate tax credit to the surviving spouse. Gift tax on non-resident citizens. NRNCs are subject to U.S. gift tax on U.S. assets. Intangible assets are, however, excluded. A non-resident non-citizen may therefore make unlimited gifts to U.S. stocks and bonds free of gift tax. Although neither Congress nor the IRS has defined intangible property, case law allows for certain generalizations. Assets whose value is derived from contract law or a cause of action similar to contract law are considered intangible property. Such assets include annuities, shares of stock, membership interests, and other entity ownership rights. Life insurance policies and bank deposits also qualify as intangible properties. Interestingly, if U.S. securities are not given away, They become subject to estate tax upon the NRNC owner's death. NRNC gifts of tangible U.S. property are taxed to the extent of value exceeding $14,000 per year. Smaller gifts fall within the annual gift tax exclusion, unlike gifts made by U.S. residents or citizens. Gift tax incurred by NRNCs may not be avoidable by offset against the estate tax credit. There are also significant restrictions on tax-free lifetime gifts to non-citizen spouses. The most significant is the absence of the unlimited lifetime marital deduction. As noted above, U.S. gift tax does not apply to lifetime transfers of intangible property by NRNCs. The rule allows for avoidance of estate tax through lifetime gifts of U.S. untangible property. NRNCs may therefore reduce their taxable estate by making lifetime transfers of U.S. intangibles. Certain U.S. intangible assets are, however, excluded from the estate tax. These exclusions are integral to U.S. estate tax planning for NRNCs. Cash-only deposits by NRNCs in U.S. banks are not subject to estate tax, provided the deposits are not effectively connected with the conduct of trade or business in the United States. Deposits connected with a U.S. trade or business are excluded from estate tax if held in foreign or offshore branches of domestic banks. Deposits at a U.S. branch of a foreign bank are, however, subject to estate tax. To qualify as a bank deposit, the account must be maintained in behalf of or for the decedent, meaning that the decedent must have had a direct and enforceable claim on the account. To establish an exempt bank account, the decedent must own or control the account. Life insurance. Life insurance proceeds receiving by the estate of NRNC are not subject to the estate tax. The Internal Revenue Code explicitly states that life insurance proceeds insuring the life of an NRNC shall not be deemed property within the United States. Proceeds are therefore not included in the estate of the NRNC owner insured. This makes life insurance a very attractive asset. The life insurance exclusion does not apply to the cash surrender value of insurance. If a NRNC owns a U.S. CITIS policy on the life of another person, the value of the policy forms part of the owner's taxable U.S. estate. Life insurance policies are treated as a U.S. CITIS property if issued by a U.S. insurer outside the U.S. Direct ownership of U.S. life insurance on another person may be avoided by holding the policy in a foreign entity. If life insurance is owned by and benefits a foreign corporation, neither the cash value nor the payment of proceeds to the owner upon the death of the insured creates a taxable event. This is the case because life insurance proceeds are not subject to income tax and the foreign entity owning valuable life insurance has no taxable estate. Shifting assets from U.S. CITIS. Although lifetime gifts of U.S. intangible by NRNCs are exempt from gift tax, all U.S. CITIS assets, both tangible and intangible, are taxable upon the death of an NRNC owner. Those same assets held in foreign corporation are, however, excluded from the estate tax. Shares of corporate stock in a foreign entity held by a NRNC are subject to neither gift tax nor estate tax. Real property. Real property has CITIS in the jurisdiction in which it is located. Consequently, U.S. real estate is included in the taxable estate of a NRNC. If real estate is instead owned by a foreign corporation, the property is excluded from the gift tax and estate tax. The NRNC acquiring U.S. real estate should initially do so through a foreign corporation. If U.S. real estate is initially purchased during the NRNC, later transfer of the property to an offshore corporation could have tax consequences. Appreciated U.S. real estate held by a NRNC will trigger taxable gain upon transfer to a foreign corporation. Beware the PCICs. While many portions of the U.S. tax code possess confusing and sometimes harsh rulings, the tax regime for passive foreign investment companies is almost unmatched in its complexity and almost draconian features. Countless times, our international clients have come to us to prepare what they thought would be a straightforward tax return, only to later learn that the small investment they had made in a U.S. non-U.S. mutual fund or insurance policy or pension was now subjecting them to all the concomitant filing requirements and tax obligations. While it is beyond the scope of this article to cover all the numerous details related to PFIC reporting requirements, my hope is to provide guidance and insight into the world of PFICs. History. The PFIC tax regime was created via the Tax Reform Act of 1986, with the intent to level the playing field for U.S.-based investment funds, i.e. mutual funds. Prior to the legislation of 1986, U.S.-based mutual funds were forced to pass through an investment income earned by the fund to its investors, resulting in taxable income. In contrast, foreign mutual funds were able to shelter the aforementioned taxable income, as long as it was not distributed to its U.S. investors. After the passage of the Tax Reform Act of 1986, the main advantage of foreign mutual funds was effectively nullified by a tax regime that made the practice of delaying the distribution of income prohibitively expensive for most investors. To employ this punitive regime, the IRS requires shareholders of PFICs to effectively report undistributed earnings via choosing to be taxed through one of three possible methods. Basics. Defined in the Internal Revenue Code, a passive foreign investment company is any foreign corporation that has either 1. 75% or more of its gross income classified as passive, or 2. 50% or more of its assets are held for the production of passive income. While there are few exceptions to the above rules, most foreign mutual funds, pension funds, and money market accounts would be good examples of PFICs. Furthermore, many foreign rates also get trapped in the PFIC web. Finally, a foreign holding company that possesses passive income, like rental real estate or government bonds, would be subject to PFIC regulations if the company was set up as a corporation. When it comes to PFICs, always get professional advice. Chapter 12. U.S. Insurance. Takeaways. Life insurance can be a good estate planning tool for a number of reasons. Most notably, the insured usually pays little upfront for the policy. The proceeds of the policy pass directly to the beneficiaries without going through probate. The benefits are not generally subject to federal income tax. However, today's complex financial markets give individuals a host of other options when considering life insurance, including policies that can add to retirement income. This section will outline the major types of life insurance available and provide some pointers for determining what type of insurance is best in a certain situation, particularly considering its tax implications. A. The nature of life insurance. A life insurance policy is a contract. In the contract, the insurer promises to pay the proceeds of the policy to the beneficiaries in the event of issue dies. The owner of the policy has the right to name the beneficiary and change the beneficiary as often as he or she likes, unless the designation is made irrevocable. The primary beneficiary is entitled to the proceeds only if he or she survives the insured. Contingent beneficiaries must likewise survive the insured. Thus, in cases of a class that has both surviving and deceased members, only those surviving will receive payment. Settlement options include both installment payments or payment at a future date. The owner of the policy can select the settlement option. B. Who needs insurance? Almost anyone with dependents should have some type of life insurance policy. The exception may be someone who is so wealthy that it's totally unnecessary to provide the additional assets to survivors upon death. But for the most part, the only questions are the amount of insurance they should have and the type. In analyzing the amount of life insurance someone should have, the following list of questions is a good place to start. Are you married? Do you still have children living at home? Or if not living at home, are they still dependent? Do you own a small business that would likely suffer if you were to suddenly die? Is there anyone else you support, such as an elderly parent? What type of financial obligations do you have, i.e., a large mortgage on your home or a loan to support your business? The answers to these and other questions can help determine if the amount of insurance that is right for a particular individual, clearly, for example, someone who has a spouse and several small children living at home with a large mortgage, is going to need more life insurance than a single person whose children are grown and whose house is paid for. Making the precise determination about how much insurance is needed also depends on other assets that are likely to be available at the time of death. Will a surviving spouse be entitled to the deceased retirement's benefits? Will they be entitled to continuing employer-sponsored health benefits? A thorough examination of an individual's current and future expected finances is necessary to determine an appropriate amount of life insurance. As a rule of thumb, however, some financial experts recommend that individuals have a life insurance policy sufficient to replace 2 to 6 times their annual income. Depending on individual needs, therefore, if an individual has an annual income of $100,000, his or her insurance policy should be between $200,000 and $600,000. C. Selecting a beneficiary. If an individual is married and has dependent children, his or her spouse is most likely going to be the beneficiary of his or her life insurance policy. If the individual is unmarried and has small children, he or she will likely need to select a trustee to manage the proceeds of the insurance policy. In such a case, the children would technically be the beneficiaries, but not the proceeds would be placed in a trust managed by a third party. Each person's circumstances are different. Generally, the life insurance should be paid to the person or persons for whom the deceased was responsible during his or her lifetime. D. Overview of life insurance. Traditionally, there were basically 2 types of life insurance: term or pure life insurance, or whole life, also referred to as investment insurance. Term insurance provides protection for a specified term of years. It is normally cheaper than whole life insurance, particularly when the insured is relatively young. It has value only if the insured dies. Whole life insurance, on the other hand, has some cash value even if the insured does not die. It is normally more expensive than simple term insurance. Its utility as an estate planning or an investment tool is normally fairly limited. In today's marketplace, individuals have only 4 other options to consider: variable life insurance, universal life insurance, universal variable life insurance, and guaranteed universal life insurance. Term life insurance. The term life insurance is pure life insurance. It has a value only if the insured dies during the life of the policy. If the insured outlives the stated term of the policy, it has absolutely no value. Most term life insurance policies have specific terms. When purchasing a term life insurance policy, one should always determine if and under what circumstances the policy is renewable. That is because such a policy might be relatively inexpensive for an individual who is healthy and 30 years old. But what happens if when the policy expires, the individual has become quite ill? Will they have the option of renewing? And at what price? Term life insurance is cheapest to buy when the individual is young. Rates generally increase with age. 2. Whole life insurance. Whole life insurance offers the combination of pure life insurance along with an investment component. The cost of the premiums covers the pure insurance as well as amounts invested by the insurance company. As a result, it is more expensive than term life insurance. Whole life policies often guarantee a minimum rate of return, often between 4 and 6%. If the investment selections are good, the cash value of the account can exceed the guaranteed return. A. Income tax liability. There's no income tax liability on the account unless the policy is canceled and the proceeds withdrawn. Many such policies will allow the insured to borrow against their account. The interest on these loans is generally credited to the insured's account. By borrowing the cash from a whole life insurance policy, no taxable event is triggered. B. Cash value. Technically, the cash values are supposed to be explained as tax-deferred, non-tax-free. The truth is, they may only be tax-deferred, meaning tax will have to be paid on them someday, or they may end up being tax-free altogether. If the individual dies, the actual life insurance portion and the cash value are lumped together as one whole and called the death benefit of life insurance proceeds, which under most circumstances are exempt from the income tax. 3. Variable life insurance. Variable life insurance is similar to whole life insurance, except the cash value and/or the death benefits are not fixed. They vary depending on the results of the investments made from the owner's separate account. The owner of the policy chooses how the money is invested. The insurance company will offer a list of different types of investment accounts to choose from, such as stock funds, bond funds, or money market funds. The individual investment accounts are managed by either the insurance company itself or by an outside investment firm. The goal of variable life insurance is for the death benefits to keep up with the rate of inflation. 4. Universal life insurance. Universal life insurance is permanent life insurance that includes both pure insurance and investment components, similar to whole life. However, universal life insurance allows the owner to adjust either the amount of premiums to be paid or the amount of the death benefits to be paid at death. The rate of return on the investment component is based on the results of the company's general asset account. The owner is not allowed to dictate what type of investments are made. Because universal life insurance is intended to be a policy that individuals maintain during their entire life, the premiums can be adjusted so that they are equal over their lifetime. They can pay them only for a set of numbers of years, or they are more in the beginning years and then lower in later years, for example, after the individual retires. 5. Universal variable life insurance. Universal variable life insurance combines the features of universal insurance and variable insurance. The owner is able to choose the types of investments made by the cash value account, and the account grows according to the returns on those investments. The owner can also adjust the amount of premiums or death benefit of the policy. This type of policy offers the owner the most flexibility in meeting his or her insurance needs. 6. Guaranteed universal life. Guaranteed universal life insurance offers coverage up until age 90, 95, or even until your death, but is less expensive than whole life insurance or universal life insurance. It does not have a cash value or investment component, or the accompanying management fees, and the premiums can be paid as level premiums for a lifetime or for a shorter term. Similar to whole life insurance. Unlike regular universal life insurance, the policy is not at risk of becoming underfunded and requiring additional premiums to remain in force. This type of policy can be appealing to seniors who still need coverage. It can be cheaper and provide better protection than term life insurance in that situation. The policy has a guaranteed death benefit in the amount you selected when you take out the policy. Some guaranteed universal life policies are at risk of lapsing and policyholder misses at premium payment. Other policies are no-lapse policies and do not carry this risk. It is a relatively simple product that can be a good alternative to term life insurance for individuals that want permanent coverage. E. Impact of insurance on taxable income. The proceeds from a decedent's life insurance policy paid by reason of his or her death generally are excluded from income. The exclusion applies to any beneficiary, whether a family member or any other individual, a corporation, or partnership. 1. Veterans insurance proceeds. Veterans insurance proceeds and dividends are not taxable either to the veteran or to the beneficiaries. Interest on dividends left to deposit with the Department of Veterans Affairs is not taxable. 2. Life insurance proceeds. Life insurance proceeds paid because of the death of the insured or because the insured is member of the U.S. Uniformed Services who is missing in action are not taxable unless the policy was turned over for a price. This is true even if the proceeds are paid under an accident or health insurance policy or an endowment contract. Accelerated death benefits. Accelerated death benefits received on the life of an insured individual can be excluded from income if certain requirements are met. Accelerated death benefits are amounts received under a life insurance contract before the death of the insured. These benefits also include amounts received on the sale or assignment of the contract to a viatical settlement provider. This exclusion applies only if the insured was a terminally ill individual or a chronically ill individual. This exclusion does not apply if the insured is a director, officer, employee, or has a financial interest in any trade or business carried by the beneficiary. A. Terminally ill individual. A terminally ill individual is one who has been certified by a physician as having an illness or physical condition that reasonably can be expected to result in death in 24 months or less from the date of certification. B. Chronically ill individual. A chronically ill individual is one who has been certified as one of the following: an individual who, for at least 90 days, is unable to perform at least 2 activities of daily living without substantially assistance due to loss of functional capacity, and an individual who requires substantial supervision to be protected from threats to health and safely due to severe cognitive impairment. A certification must have been made by a licensed healthcare practitioner within the previous 12 months. C. Exclusion limited. If the insured was a chronically ill individual, the exclusion from accelerated death benefits is limited to the cost incurred in providing quality long-term care services for the insured. In determining the cost incurred, do not include amounts paid or reimbursed by insurance or otherwise. Subject to certain limits, payments received on a periodic basis can be excluded without regard to cost. 4. Insurance received in installments. If an individual receives insurance proceeds in installments, the individual can exclude part of each installment from his or her income. To determine the part excluded, an individual must divide the amount held by the insurance company, generally the total lump sum payable at the death of the insured person, by the number of the installments to be paid. The individual includes anything over this excluded part in his or her income as interest. A. Specified number of installments. If an individual will receive a specific number of installments under the insurance contract, he or she can figure the part of each installment he or she can exclude by dividing the amount held by the insurance company by the number of installments to which he or she is entitled. A secondary beneficiary, in case the individual dies before receiving all the installments, is entitled to the same exclusion. B. Specified amount payable. If each installment an individual receives under the insurance contract is a specified amount based on the guaranteed rate of interest, but the number of installments the individual will receive is uncertain, the part of each installment that he or she can exclude from income is the amount held by the insurance company divided by the number of installments necessary to use up the principal and guaranteed interest in the contract. C. Installments for life. If, as the beneficiary under the insurance contract, an individual is entitled to receive the proceeds in installments for the rest of his or her life without a refund or period certain guarantee, the individual must figure the excluded part of each installment by dividing the amount held by the insurance company by his or her life expectancy. If there is a refund or period certain guarantee, the amount held by the insurance company for his purpose is reduced by the actuated value of the guarantee. 5. Interest option on insurance. If an insurance company pays an individual interest only on proceeds from life insurance left on deposit, the interest the individual is paid is taxable. 6. Flexible premium contracts. A life insurance contract, including any qualified additional benefits, is a flexible premium life insurance contract if it provides for the payment of one or more premiums that are not fixed by the insurer as to both timing and amount, for the flexible premium contract issued before January 1, 1985. The proceeds paid under the contract because of the death of the insured will be excluded from the recipient's income only if the contract meets the requirements explained under Section 10F of the Internal Revenue Code. Chapter 13. CPF Nomination, Insurance Nomination, and AMD in Singapore. Takeaways. This chapter is very Singapore-specific and deals with the government's Social Security program. CPF savings. The savings of a CPF member include money in his CPF ordinary account, special account, MIDI-save, retirement account, unused CPF, life premiums, and discounted single shares at the time of his demise. Independent from your estate. CPF savings of a CPF member do not form part of his estate upon his demise, and cannot be distributed by his will, even if he has one. CPF nomination. Governing law. The governing law of CPF nomination in the Central Provident Fund Act. The CPF board mandated in this act is responsible for all matters related to the CPF nomination scheme. This scheme provides CPF members with the option to specify who will receive their CPF savings, and how much each nominee should receive upon their demise. Application of CPF nomination. All CPF members, age 16 and above, who've made CPF contributions can make CPF nominations. Furthermore, in view of changes in social situations over a person's lifetime arising from significant life events such as marriage, divorce, childbirth, and demise of nominees, every CPF member should review his CPF nomination regularly to ensure that it continues to fit his intentions. Types of nominee. There are two types of CPF nominees, according to his consideration and intention to receive his CPF savings upon his demise. 1. Natural persons. These individuals can be Singapore citizens, Singapore permanent residents, or foreigners, with proper personal identification details, such as name, NRIC passport, number, and mailing address. They can be his family members, relatives, or friends. 2. Legal entities. These can be institutions with registered UENs, such as businesses, local companies, LLPs, societies, charities, and registered trusts, such as charity trusts, family trusts, and special needs trusts. Types of CPF nomination. There are 3 types of nomination methods available for CPF members to choose for each of their nominees to receive their CPF savings based on their needs. 1. Cash nomination. This is the default nomination type. Your nominee will receive their share of your CPF savings due to them in cash via check or giro. 2. Enhanced nomination scheme. Your nominee will receive their share of your CPF savings due to them in their CPF special account or retirement account and MedSave account, subject to the prevailing limit for each of these accounts of the nominee. Any amount in excess of these limits will be distributed to the nominee in cash. Special Needs Savings Scheme nomination. This scheme allows parents to nominate their children with special needs to receive fixed amounts from their CPF savings due to them on a monthly basis. This scheme is administered by the Special Needs Trust Company Limited, which you will have set up by Special Needs Trust for your special needs child first. You're required to obtain a certification from CNTC for your child before going to any CPF service center to apply for the SNSS. However, you have to consider long-term funding needs for your child as his special needs trust account, as he may outlive the CPF savings you bequeath to him under the scheme. You can decide for each of your nominees who are natural persons the type of nomination and how much to each to receive, and percentage of your CPF savings based on their needs and your wishes. The total of all your nominations must add up to 100%. However, for nominees who are legal entities, only cash nomination is acceptable, i.e., payment can only be made to them via cash by giro or check. Application procedure. You can apply for CPF nomination and resubmit to make changes either online or in person. For applications of cash nomination type, you can do it by soft copy or hard copy submission. Soft copy submission. Go online by logging into your CPF member account through the CPF website, www.cpf.gov.sg, and complete the form with all required information. Your appointed witness will be notified by email and/or SMS to log in with their SingPass and affirm your intention to make the nomination. 2. Hard copy submission. You must complete and sign your CPF nomination form in the presence of 2 witnesses, then mail the form with required supporting documents to the CPF board. Alternatively, you can do that in person at any CPF service center where CPF staff can serve as your witness. However, for nominations of ENS and SNSS schemes, you have to apply in person at any CPF service center. CPF staff will explain to you the details of these schemes and the various limits so that your intentions can be best met. Implications. The following unique implications are specified or provided at the CPF ad. 1. Protection from creditors. Your CPF savings is protected from creditor claims on any outstanding debts that you have during your lifetime. As such, your nominees are assured to receive their share of your CPF savings upon your demise. 2. Probate exempted. A CPF member who has made nomination, the savings in his CPF accounts upon his passing will be distributed directly to his nominees and is not subject to probate. Nominees can expect to receive their share of payments within 5 weeks from the date CPF board is notified of the member's death. 3. No nomination. If a CPF member has not made any CPF nomination, then upon his demise his CPF savings will be transferred to the public trustee for distribution to the legally entitled beneficiary, according to a. the Intestate Succession Act, if the member is a non-Muslim at the time of his demise, or Section 112 of the Administration of Muslim Law Act, if the member is a Muslim at the time of the demise. Limitations and concerns. Nomination is nullified by marriage. CPF nominations made before the marriage of a person are nullified by marriage. This rule applies to CPF nominations made by widows, widowers, and divorcees. However, divorce of a person does not affect the CPF nomination made before the divorce. Hence, CPF members should review their CPF nominations subsequent to marriage and divorce in order to make sure that their CPF savings go to the right beneficiaries. Status of nominees. There are 4 situations that CPF members should be concerned with when deciding their choice of nominee. 1. Nominee's age below 18. Upon passing of a CPF member, all his nominees who are below 18 years of age will not receive their shares of his CPF savings. Instead, their shares will be transferred to the PTO for safekeeping until they're 18. 2. Nominees who are young. CPF Act specifies that nominees age 18 and above at any time of payment can receive the money. Nominees at the young age of 18 or even early 20s may not be mature enough to or competent to handle large sums of money. 3. Nominees who are undischarged bankrupts. If any of your nominees were to be an undischarged bankrupt at the time of your demise, CPF Board is legally obliged to inform the official assignee and transfer his share of your CPF savings to the OA in accordance with the Bankruptcy Act of Singapore. 4. Nominees who lack mental capacity. The deceased CPF savings would be paid to a donee, who is given power of property and affairs in the LPA made by the nominee, or a deputy appointed by court to act on the nominee's behalf under Mental Capacity Act. No substitute nominee. The CPF nomination scheme does not have provision for naming the substitute nominee to replace any of the nominees who pass away before or upon the demise of a CPF member. In circumstances like this, the share of a nominee who died before the CPF member will be shared proportionately among the surviving nominees. However, if a nominee who passed away after the demise of a CPF member but before disbursement of the deceased member's CPF savings, then his share will be transferred to his estate for cash nomination type or to his CPF accounts for enhanced nomination scheme type. Last nominee. If there is one surviving nominee upon the demise of a CPF member, then he or she is entitled to receive the deceased CPF member's entire CPF savings. But if the last nominee also died upon the demise of the CPF member, or died before the CPF member who subsequently also passed away without making a new nomination, then the CPF savings of his member will also be transferred to the PTO for distribution in the same ways as in the case of no nomination. Single nominee. CPF members who make nomination with only one nominee should be aware that if the sole nominee predeceased him at the same time of his demise, his CPF savings will be transferred to the PTO for distribution in the same ways as in the case of no nomination. Distribution through PTO. The process for the legally entitled beneficiaries to resubmit their claims according to the ISA rules is tedious and time-consuming, and has to incur legal fees too. The requirements to prove their relationship with the deceased CPF member and their entitlement of his CPF savings often deter many to forego their claims. As reported in the Straits Times of 21 October 2019, a total of $211 million, largely made up of the Central Provident Fund monies, has been left unclaimed with the Insolvency and Public Trustee's Office over the last 6 years. These fees are inclusive of GST and are deducted from the CPF money administered. Also, PTO charges a minimum administration fee of $15 for the administration of CPF members' money transferred to it. Conclusion on CPF nomination. CPF nomination allows CPF members to decide as they wish to bequeath their CPF savings to their intended beneficiaries at no cost. It is thus important for every CPF member to do their CPF nomination while they are healthy and with a sound mind. They should review and update their CPF nomination regularly, also due to changing situations and considerations, particularly upon occurrence of significant life events such as marriage and divorce, new births, and passing of family members. However, in view of the limitations and concerns mentioned above, you should consider CPF nomination together with other instruments when doing your estate planning and subsequent review of your estate plan. Insurance nomination. Governing law. The Insurance Act and the Insurance Nomination of Beneficiaries Regulation in 2009 are the governing law for insurance nomination in Singapore. This act and regulations are under the supervision of the Monetary Authority of Singapore and have come into operation on 1 September of 2009. This act has since superseded and replaced Section 73 of the Conveyancing and Law of Property Act and Section 45 of the Cooperative Societies Act, Income Life Policy Holders for Insurance Nomination. Insurance nominations made under Section 73 of CLPA for relevant policy before September 1, 2009, and only with spouse and/or children named as nominees, are considered default trust and are still valid. But such nomination can be revoked by the policy owner when he makes a fresh nomination of the policy after September 1, 2009, as followed under the Insurance Act. If you have any other insurance nominations made before September 1st of 2009, you should clarify with the insurance companies concerned regarding the validity of those nominations and to seek advice before taking necessary action to either revoke those nominations or renominate those policies under the current law. Application of insurance nomination. Relevant policy. Insurance policies that are allowed for insurance nomination are life insurance policy or accident and health policy with death benefit. Furthermore, these policies must be issued by licensed insurers governed by Singapore law. Certain types of policies are not applicable for insurance nomination. 1. Insurance policies, such as whole life and universal life, that have been assigned or placed under trust cannot be nominated as the life assured, are no longer policy owners. 2. Annuity policies under minimum sum scheme and CPF Life are excluded, as any balance monies in these policies have to be refunded to the retirement account of the CPF members upon their demise. 3. The Dependent Protection Scheme, CPF Investment Scheme, are also excluded for S49L. Trust nomination because the investment and premium are paid for by members' CPF savings for which they must have control, as required by the CPF Act. 4. Policies under the Supplementary Retirement Scheme, Elder Shield, Life Shield, and Integrated Shield plans also cannot be nominated under the S49L trust nomination, as these policies are for retirement and healthcare purposes of the policy owners. Policy owner and life assured. In line with the minimum entry of age 18 required for a person to take up an insurance policy in Singapore, insurance nomination can only be made by a person aged 18 and above. Furthermore, any relevant policy can only be made by a person who is both the policy owner and life assured. One policy, one nomination. A person can make multiple insurance nominations, but each nomination is allowed only for one of the relevant policies for which he is both the policy owner and life assured. Total policy money payable to be nominated. Each insurance nomination must cover the total policy money payable under the relevant policy. Every named nominee must be assigned with a percentage of the policy benefit of the policy concerned, and the total percentage of shares for all nominees must add up to 100%. Types of nomination. There are two types of insurance nomination under the Insurance Act, namely S49L trust nomination and S49M revocable nomination. These two types of nominations have different features, implications, limitations, and concerns as detailed in the subsequent sections. Application procedure. Prescribed nomination forms. The nomination forms for Trust Nomination Form 1 and Revocable Nomination Form 4, as prescribed in the Insurance Nomination of Beneficiaries Regulations 2009, must be used for the respective type of nomination. These forms must be duly completed by the policy owner and signed in the presence of two witnesses. Witnesses. These witnesses must be 21 years or above and must not be a nominee or spouse of a nominee. They must also sign the nomination form in the presence of the policy owner. Lodging of nomination form. All insurance nomination application forms, after duly completed and signed, should be submitted to and lodged with the licensed insurer that issued the relevant policy together with all required supporting documents. Lodging of nomination form is necessary to avoid complication when claiming policy money, because the Insurance Act gives licensed insurers the privilege not to be bound to give effect to the nomination purportedly made. S4NL Trust Nomination. Implications. Before you make an S4NL trust nomination to a relevant policy of yours, you should consider the following implications. 1. Legal ownership. You, being the policy owner of a relevant policy concerned, want to and are transferring the legal ownership of the policy to the trustee, named in the nomination form. You must be aware that upon execution of the trust nomination, A. You will no longer have any interest in, or any right or control over all or any of the policy money payable under the policy. B. You will not be able to vary any term or condition of the policy, or give any instruction in relation to the policy which may directly or indirectly alter the benefits payable under the policy. 2. Trustees. You must appoint at least one trustee, who can be an individual who must have attained the age of 18 years, or a licensed trust company. You may name yourself, the policy owner, as trustee, but you will not be able to A. Consent to the revocation of the trust nomination, B. Consent to the variation of a term or condition of the relevant policy, include altering the benefits payable under the relevant policy. C. Surrender the policy, withdraw cash benefits, nor make policy loan. And D. Give any valid discharge to the licensed insurer that insured the relevant policy for any payable made, pursuant to the trust nomination, from the policy money payable under the relevancy policy. 3. Nominees. Only immediate family members of the policy owner, i.e. spouse and children, can be nominated. 4. No probate. Policy proceeds, both living and dead benefits, are not subject to probate. The trustee can claim all the policy proceeds directly from the insurer concerned with the death certificate of the life assured. 5. Protection from creditors. The policy proceeds do not form part of the estate of the life assured and are protected from creditors. All your nominees are assured to receive their share of the proceeds. However, if it is proven that the relevant policy was affected and the premiums for the relevant policy were paid with intent to defraud the creditors of the policy owner, the creditor shall be entitled to receive out of the policy money a sum equal to the premiums so paid. 6. Trust nomination unaffected by will. Trust nomination has higher precedence over wills. A will which is written after the trust nomination is executed also does not have an effect on the nomination and cannot revoke it. Limitations and concerns. You should also be aware of the following limitations and concerns. 1. Death of nominee. The trust nomination will not be affected from the death of any or all nominees. Upon the death of a nominee, his interest of such policy monies to be paid out upon the demise of the life assured forms part of his estate. 2. No substitute nominee. S49L trust nomination does not have provisions for naming a substitute nominee to replace any of the nominees who passed away before or upon the demise of the life assured. 3. Revocation of a trust nomination. A S49L trust nomination may be revoked, if and only if with prior written consent of a trustee, who cannot be yourself, or so long as a nominee has died. The prior written consent to the revocation has been obtained from all nominees and the parent legal guardian of a nominee who is below the age of 18 years old. 4. Status of nominee. There are 4 situations that you should be concerned with when deciding your choice of nominee. A. Nominee's age below 18. Upon your demise, all your nominees who are below 18 years of age will not receive their shares of the policy monies. Instead, their shares will be transferred to their legal guardian or held by a trustee. B. Nominees who are young. Nominees age 18 and above at the time of your demise can receive their share of policy money. Nominees at the young age of 18 or even early 20s may not be mature enough or competent to handle large sums of money. C. Nominees who are undischarged bankrupts. If any of your nominees were to be an undischarged bankrupt at the time of your demise, your trustee should be exercised discretion to hold his share of money on trust. An undischarged bankrupt is obliged to notify and hand over any money received to the OA in accordance with the Bankruptcy Act of Singapore. D. Nominees who lack mental capacity. Your trustee will hold the share of the policy money of a nominee who lacks mental capacity at the time of your demise. He can only pass to the donee property and affairs of his nominee after duly confirming with OPG that he has a valid LPA. Otherwise, your trustee has to wait till a deputy is formally appointed by court for his nominee and then pass the money to the deputy accordingly. 5. Marriage and divorce. S49L trust nomination is not affected by the marriage or divorce of a life assured who has given up his ownership of the relevant policy to the trustees. S49M revocable nomination. Implications. Before you make a S49LM revocable nomination to a relevant policy of yours, you should consider the following implications. 1. Legal ownership. The policy owner remains as the owner of the relevant policy put under S49 revocable nomination, He can make changes to the nominations, revoke or make new revocable or trust nomination at any time. 2. Nominees. Any individual including immediate family members of the policy owners, his relatives and friends, and registered entities such as companies, associations, and institutions can be nominated. 3. No probate. Policy proceeds, both living and death benefits, are not subject to probate, but all living benefits belonging to the policy owner or his estate. The death benefits only are shared by the nominees upon the demise of the policy holder. 4. No protection against creditors. The policy monies of a relevant policy put under S49M revocable nomination offers no protection against claims by creditors. Hence, your nominees may not receive their share of policy monies as you intended. 5. Revocable by will. A revocable nomination can be revoked by a valid will executed by the policy owner at a date later than that of the nomination, and with particulars of the relevant policy specified in the will. It is advisable that the insurer concerned be notified according to avoid confusion. 6. Revocation by later nomination. A revocable nomination can be revoked by another nomination made by the policy owner at a later date, either under S49L trust nomination or S49M revocable nomination. Limitations and concerns. You should also be aware of the following limitations and concerns. 1. Death of a nominee. On the death of a nominee, his interest in such policy to be paid out upon the demise of the policy owner will be shared proportionately by the surviving nominees. If upon the demise of the policy owner there is only one surviving nominee, he will be entitled to all the policy monies. 2. Death of sole or last nominee. If there is no surviving nominee, the nomination is revoked, and the policy money will form part of the estate of the policy owner. 3. No substitute nominee. S49M revocable nomination does not have provision for naming a substitute nominee to replace any of the nominees who pass away before or upon the demise of the life assured. 4. Status of nominees. There are 4 situations that you should be concerned with when deciding your choice of nominee. A. Nominees aged below 18. Upon your demise, all your nominees who are below 18 years of age will not receive their shares of the policy monies. Instead, their shares will be claimed by their parent or legal guardian. B. Nominees who are young. Nominees age 18 years and above at the time of your demise can receive their share of policy money. Nominees at the young age of 18 or even into their early 20s may not be mature enough or competent to handle large sums of money. C. Nominees who are undischarged bankrupts. If you and your nominees were to be an undischarged bankrupt at the time of your demise, the insurer concerned is obliged to notify and hand over any money from this nominee to the OA in accordance with the Bankruptcy Act of Singapore. D. Nominees who lack mental capacity. The insurer concerned will hold the share of the policy money of a nominee who lacks mental capacity at the time of your demise and wait for his donee. Property and affairs. If he has a valid LPA, or for the court-appointed duty of the nominee to claim. 5. Marriage and divorce. S49K revocable nomination is also not affected by the marriage or divorce of the life assured who are also the policy owners. Conclusion on insurance nomination. Insurance Act, Cap 142, provides options for policy owners of a relevant policy to nominate and name beneficiaries to receive the policy money upon demise. But it is not compulsory for anyone to execute insurance nomination for their relevant policy. While there are favorable features in both the S49L trust nomination and S49M revocable nomination, these options do have their limitations and concerns. Hence, insurance nomination should be considered together with other estate planning instruments highlighted in this book in order to structure an optimal and effective estate plan that best meets your intentions for your loved ones and best supports the values and good causes close to your heart. If you have existing insurance nominations that were done before the 1st of September 2009, it is advisable that you seek advice from the insurance company concerned to ensure their validity and relevance. Advanced Medical Directive. Governing Law. The governing law for Advance Medical Directive is the Advance Medical Directive Act, and the Director of Medical Services under the Ministry of Health is responsible for all matters related to AMD. This act provides for and gives legal effect to advance directives to medical practitioners against artificial prolongation of the dying process of a terminally ill patient and for matters connected therewith. The act does not condone, authorize, or approve abatement of suicide, mercy killing, or euthanasia. This act is not applicable to palliative care and does not affect any right, power of duty which a medical practitioner or any other person has in relation to palliative care. This act shall not affect the right of a patient to make decisions in relation to use of extraordinary life-sustaining treatment, so long as he is able to do so. A medical practitioner is obliged to inform a patient who is conscious and capable of exercising a rational judgment of all the various forms of treatment that may be available in his particular case, so that the patient may make an informed judgment as to whether a particular form of treatment should or should not be undertaken. AMD is a legal document that you sign in advance to inform the doctor treating you, in the event you become terminally ill and unconscious, that you do not want any extraordinary life-sustaining treatment to be used to prolong your life. Making an AMD is a voluntary decision. It is entirely up to you whether you wish to make one. Application of AMD. A person who has attained the age of 21 years and with sound mental capacity and who desires not to be subjected to XLST in the event of his suffering from a terminal illness may at any time make an AMD using the prescribed Form 1. AMD made by a person is valid only after it has been properly registered with the Registry of Advanced Medical Directives, Ministry of Health, and acknowledgment has been issued by the registrar to the person who made the directive. AMD made by you is effective and applicable only by you. While being unconscious, have been determined to have incurable terminal illness, and the following strict chains of action must be observed before your decision can be carried out. 1. A panel of 3 registered medical practitioners, including your attending doctor, 2 of those in the panel must be specialists, have unanimously agreed that your terminally ill condition is incurable, otherwise your attending doctor has to notify the Director of Medical Services for a decision. 2. A committee comprising 3 specialists appointed by the Director of Medical Services have unanimously agreed that your terminally ill condition is incurable. 3. After a unanimous decision either made by a panel or committee mentioned above, a certificate of terminal illness has been submitted to the registrars of AMD by attending your doctor to obtain confirmation that you have a valid AMD. With confirmation of AMD and certificate of terminal illness, your attending doctor will then arrange to speak to your next of kin of the date and time to remove the XLST, so they can prepare the necessary after-death matters. Exceptions. XLST shall not be withheld or withdrawn from a patient known to the medical practitioner to be pregnant, so long as it is probable that the fetus will develop the point of live birth with continued application of XLST. Application procedure. The procedure for application of AMD is rather simple. 1. Obtain an AMD Form 1 either by downloading from the MOH website or from any doctor, either from a private clinic, polyclinic, or hospital whom you are consulting. 2. Complete the prescribed AMD Form 1 and signed in the presence of his doctor and another witness, who is aged 21 and above. This doctor is responsible to ensure that you are A. of sound mind, B. aged 21 years or above, C. not being forced or induced into making the AMD, and D. informed of the nature and consequence of making the AMD. This doctor and the witness must not have any vested interest in your demise. Submit the executed AMD Form 1 to the Register of AMD. 4. An acknowledgment form is issued to you by the Registrar of AMDs and MOH. Importance of making AMD. There are good reasons why you should make your AMD while having a sound mind. Spare family members of emotional stress. With AMD made in advance, you can spare your family members significant emotional stress and potential disputes and souring of relationships. 1. With AMD made in advance, when you're diagnosed by your attending doctor as suffering from an incurable terminal illness while being unconscious, it only requires a panel of 3 doctors or specialists to unanimously agree on your condition, and the XLST can be taken off. 2. Without AMD, even after a panel of doctors or specialists have concluded your incurable condition, your attending doctor still needs a decision from your next of kin to stop the XLST. This can be very difficult and emotionally stressful for your family members who are close and very attached to you. The situation can be worsened if there is no agreement among your next of kin for whatever reason. It is very likely quarrels and disputes will erupt and even result in soured or broken relationships among them. Avoid costly hospital bills. A patient who is undergoing XLST most likely has to be watched at an intensive care unit or high dependency unit. The charges for ICUs and HDUs average $700 to $800 per day in Singapore. These charges, together with fees for the consultant doctors, use of specialized medical facilities, drugs, and consumables, all can add up to a few $1,000s a day. If you have not made AMD, and if your next of kin will need a few days or longer to make the decision, the total hospital bills can balloon to tens of thousands. Spare further suffering. XLST invariably inflicts much discomfort and pains, both physically and mentally, to the patients. Some terminally ill persons who are unable to express their wishes to make AMD at the same time, they might want to be spared further suffering and be allowed to die naturally in peace and with dignity. Conclusion on AMD. The law allows you to decide in advance through making of AMD that you do not want to undergo extraordinary life-sustaining treatment if you were diagnosed to suffer from incurable terminal illness while being unconscious. With valid AMD made, you will certainly reduce suffering to your immediate family members and avoid costly hospital expenses should you be in that unfortunate condition. You can easily apply to make AMD through your family doctor at a small fee of about $50 to secure the advantages explained earlier. Why not? Chapter 14. Structures of the Estate Plan. Takeaways. It is a common saying that many people this day are asset-rich but cash-poor. The basic requirements of estate liquidity and estate adequacy are 2 important aspects within the realm of financial planning should be considered to ensure that your estate plan can be successfully executed and with certainty to fulfill your objective. Estate liquidity. It is important to ensure that there will be sufficient liquidity to support cash flow requirements during the initial period of your demise or critical disability. Without having to liquidate assets quickly, besides maintaining a reasonable amount of cash in hand, one effective solution is through insurance planning to provide immediate cash in case of death, disability, and major illness. These insurance policies can be assigned to a standby trust for effective management according to your wishes. Estate adequacy. It is necessary to ensure that your estate should have adequate financial capability to fund your giftings and support your estate planning objectives. Hence, it is important to have a clear worksheet of your current assets and liabilities to show your net asset, hopefully of which is positive, so as to avoid a situation of insolvent estate. It is prudent also to discount your investment assets with market risks and to provide hedging for business risks. If you own businesses, as it is better to err on the cautious or conservative side rather than being overconfident. Estate planning should be done in conjunction with other areas of financial planning, namely cash flow, insurance, tax, investment, and retirement planning. Estate plan structure for individuals with no dependents. The estate plan structure shown in Diagram 9.1 is applicable to individual adults with no dependents, including singles with no siblings and no surviving parents, as well as singles with siblings, parents, and with grown-up children who are financially strong and independent. These individuals should consider the advantages and benefits of the relevant estate planning tools proposed. 1. LPA Form 1. This is necessary to ensure that in case of loss of mental capacity, your appointed donees can immediately attend you, making decisions concerning your daily living and all financial matters rather than waiting for a court-appointed deputy. 2. Will. This is necessary so that your estate can be distributed expeditiously to beneficiaries of your choice upon your demise, incurring less legal expenses for the application of the grant probate rather than that for grant of letters of admission. 3. AMD. This is necessary to spare you of much suffering and costly medical expenses when you need a life support system to keep you alive, yet with no prospect of recovery. And certainly with AMD made, your surviving family members, if any, will also be spared the emotional stress of having to decide for you on when to pull out the life support system. 4. CPF nomination. Certainly it is better to give your CPF monies to beneficiaries of your choice, including family members, relatives, friends, and institutions, by making your CPF nomination. Otherwise, your CPF monies may go to the government in accordance to the ISA rules of distribution, if no family member coming forward to stack a claim. 5. Insurance nomination. This estate planning tool is not proposed here, as the policy payouts will form part of your estate and distributed according to institutions of your will. Nevertheless, if you would like the payouts of a certain policy to benefit some special persons, then the S49M revocable insurance nomination can be considered. S49L trust nomination is not recommended, as this scheme is irrevocable and only spouse or children, if you have, are allowed to be nominated. With likely changes of family and social situations in the future, such as subsequent marriage and surfacing of important dependents, insurance policy with S49M revocable nomination can be easily revoked and considered together with reviewing and restructuring of your estate plan. Estate plan structure for individuals with dependents. The estate plan structure shown in diagram 9.2 below is an applicable thing to both singles and single parents who are with dependents, as well as for married adults who are the sole or main income earner of the family. Singles with dependents are typically those individual adults with aged or retired parents to care for, while single parents are typically with minor children and aged or retired parents to care for. This category of singles or individuals should consider the advantages and benefits of the relevant estate planning tools proposed. 1. LP Form 2. This is necessary to ensure that in case of loss of mental capacity, your appointed donees can immediately attend to you, making decisions concerning your daily living, including healthcare matters and decisions on financial matters to provide for you and the needs of your dependents. Without LPA Form 2, the court-appointed deputy may be given the discretion to provide for your minor children, according to the Guardianship of Infants Act. But it will be difficult for your deputy to apply from court the discretionary power to provide for your dependent parents. However, they certainly can be cared for and provided for by your trustee through a living trust, i.e., the proposed standby trust you have set up. 2. Will. The main purpose of the will in this proposed structure is to serve as a legal instrument for your executor to pour assets from your estate, as specified in your will, into the standby trust upon your demise. The will also serves your wishes to bequeath special gifts to certain beneficiaries. 3. AMD. This is necessary to serve the purpose as explained in the previous section. 4. CPF nomination. Making CPF nomination is the only way to avoid your CPF monies from having to be distributed according to the ISA rules of distribution by the public trustee. With a standby trust set up, you can nominate this trust as the beneficiary, and to receive all your CPF monies within a few weeks from the notification of your demise of the CPF board. This CPF money can serve to provide immediate cash flow needs and carry out the intention specified in your standby trust, which is activated upon your demise as provided in the trust deed and letter of wishes. 5. Standby trust. The standing trust, with its terms specified in the trust deed, supplemented by wishes and preferences expressed in the letter of wishes, will be activated upon occurrence of the conditions stated therein. Upon activation, the trustee will then carry out his duties to execute the wishes of the settlor, coordinating with the executor and donee, property and affairs, if these are different persons from the trustee himself, In order to ensure smooth and seamless execution and administration of assets across different life stages, it is better to have the same persons appointed as trustee, executor, and donee. 6. Insurance nomination. Insurance nomination is not included in this proposal because payouts of all insurance policies form part of your estate and will be distributed by your executor according to the institutions in your will, both to pour into the standby trust and to distribute to other beneficiaries, if any, under the specific gift clauses of your will. However, insurance nomination still can be made, after due consultation with your estate planning practitioner through a comprehensive estate planning process, to meet certain purposes of yours. For example, execution of an insurance trust nomination with your spouse and children as beneficiaries, so that they will be assured of the policy payout which is protected from liabilities and creditors. Estate plan structure for couples with no dependents. The estate plan structure shown in diagram 9.3 below is applicable to couples both of whom are career persons with reasonable income each. They are either with no children and no parents to care for, or with grown-up children and parents who are all independent. This category of couples should consider the advantages and benefits of the proposed estate planning tools to ensure efficient management of their estate, should either one or both of them be struck with a loss of mental capacity or unplanned death. 1. LPA Form 1. The LPA Form 1 proposed in this structure is on the basis that both the husband and wife only need their respective donees to care for them should either one of them or both become lacking in mental capacity. In fact, they should appoint each other as a donee, personal welfare and property and affairs, and their respective LPA Form 1 they can then appoint other persons as their donee and replacement donee, in case the spouse becomes unable or not available to take on the duties. 2. Will. The main purpose of the two wills in this proposed structure is to serve as legal instrument for the executors of the husband and wife to expeditiously distribute their respective estate to their beneficiaries. These two sets of beneficiaries can be the same, imaged, or different. 3. AMD. This is necessary to serve the purpose as explained in the previous section. 4. CPF nomination. You should not nominate only your spouse as the sole nominee, because if your spouse were to predecease you, then your CPF monies upon your demise will be handled as with no nomination. To avoid this situation, you can simply add a charity organization of your choice as nominee with a small percentage assigned. Or, alternatively, you can add 1 to 2 relatives as nominee with a small percentage to each of them. With either or both of these additional nominees, the bulk of your CPF money upon your demise will go to your spouse if she survives you. If not, your CPF money will go to the charity and or relatives and not subject to the ISA rules of distribution. 5. Standby trust. This is not applicable for this category of couples who have no dependents to care for after their passing. 6. Insurance nomination. Insurance nomination is not included in this proposal because payouts of all insurance policies form part of their estate and will be distributed to their beneficiaries according to the instructions in their will. Estate plan structure for couples with dependents. The estate plan structure shown in diagram 9.4 is applicable to couples both of whom are career persons with reasonable income each. They are with minor or young children to care for, and also may or may not have other next of kin whom they have an obligation to care for. The category of couples should consider the advantages and benefits of the proposed estate planning tools to ensure efficient management of their estate should either one or both of them be struck with loss of mental capacity or unplanned death. 1. LPA Form 2. This is particularly relevant to ensure that in case both the husband and wife suffered loss of mental capacity, their appointed donees can immediately attend to them, making decisions concerning their daily living, including healthcare matters and decisions on financial matters to provide for themselves and the needs of their dependents. This is important also to address the situation where one of them suffered loss of mental capacity soon after the demise of his or her spouse. This situation frequently arose in common disasters seen in Singapore and other countries. 2. Will. The main purpose of wills in this proposed structure is to serve as a legal instrument for the executors to pour assets from the respective estates into the standby trust upon your demise, in the condition that your spouse predeceases you. With survivorship clause included in these wills can also avoid the trouble of multiple probate of your assets for classes of simultaneous deaths or that in quick succession from common disasters. These wills serve also to expeditiously distribute specific gifts to you and your spouse, which you may wish to bequeath to other beneficiaries. 3. AMD. This is necessary to serve the purpose as explained in a previous section. 4. CPF nomination. With this estate plan structure, both the husband and the wife should just nominate 100% of their CPF money to the standby trust setup. 5. Standby trust. The standby trust is the central and most important document in the estate plan structure. Concept of estate management under all possible scenarios can be detailed in the trust deed and the associated letter of wishes, both of which can be easily updated from time to time as needed. Activation of this trust can be any one of the 9 states from the combinations of good health, mental capacity, and rest in peace of owned and spouse as shown in the matrix of life states below. As determined and stated in the trust deed by the joint settlers, assets can be settled into this trust when it is activated, or as decided by the settlers. However, payouts from CPF nomination and insurance nomination, if any, of the husband and wife can only be settled into this trust upon their demise. 6. Insurance nomination. Insurance nomination is not necessarily under this estate plan structure, because payouts of all insurance policies from part of their estate and will be poured into this trust according to institutions in their will. Distributions and benefits to their beneficiaries can be executed by a trustling according to expressed wishes stated in the trust deed and letter of wishes. However, insurance nominations can still be made for asset protection purposes against liabilities and creditors as detailed in previous sections. Estate plan structure for businessmen. The estate plan structure shown in diagram 9.5 below is applicable for businessmen who wish to keep their family business and wealth for succession across generations. This private trust company structure has gained greater acceptance in recent years since the publication of the Trust Companies Regulations in September 2016. It is particularly attractive to business founders who wish to keep holding of company shares intact, rather than being distributed and diluted to more and more family shareholders generation after generation. Much customization and legal works are necessary for the setting up of such a structure to best suit the situation and intentions of the founder. Certainly, the services of professional estate and succession practitioners and licensed trust company have to be engaged. However, details of developing such an estate plan structure, which is a hybrid of trust company and holding company, and the required legal documents to ensure its effective operation is out of the scope of this book. Nevertheless, the following highlights will give readers a good understanding of this PTC structure for businesses and wealth succession across generations. 1. PTC as holding company and trustee. The founder transfers legal ownership of his company shares to a family, with the PTC, that acts as a trustee. Under the Trust Companies Regulations, a PTC is exempted from stringent requirements of a trust company under the Trust Companies Act and Trust Companies Regulations. However, it is mandatory for the PTC to engage a licensed trust company as company secretary to ensure compliance of anti-money laundering and counter-terrorist financing measures required of a trust company. 2. Board of Directors and Family Constitution. The initial board of directors is chaired by the founder himself, with key family members as directors. This is particularly relevant for the founder to groom and guide his children for succession. The BOD typically also functions as the family council, and its members are instrumental in drafting the family constitution, with the help of specialist consultants in trust and corporate services. This document serves as a comprehensive guide for successive leadership of the family business, including value system, mission and vision, duties and responsibilities, criteria for selection and appointment of leaders and office holders for successive generations. The culture and value to respect and care for the elders and young are also included to inculcate and foster unity. 3. Beneficiaries. The law requires that all beneficiaries under this PTC structure must be persons connected to the settlers, i.e. founders or members of BOD, FC, and office holders together with their families are the primary beneficiaries of the trust. This privilege directly incentivizes and motivates them to perform to their best because all profits generated ultimately are for their own good. 4. Criterion and injection of wealth. Promoting education and higher learning for family members is an important principle or strategy to build up expertise and professionals among members of younger generations. This enhanced human resource is critical to build capacity for wealth generation. Besides the transfer of company shares to the PTC upon setup, other assets which the founder of his spouse owned, such as the real properties and financial assets, some can be injected or transferred either during their lifetime or upon their demise by wills. On the other hand, life insurance policies taken up for family members and assigned to the trustee is another effective strategy to inject wealth upon the occurrence of death of the family members concerned into the PTC. 5. Diversification and succession. In-house expertise and professionals built up through formal education and higher learning, coupled with encouragement of entrepreneurship and supported by accumulation of family wealth, will lead to business expansion across markets and diversification across industrial sectors. Estate planning structure for special needs dependents. The setting up of Special Needs Trust, as explained in Chapter 7, is to ensure that a person with special needs will continue to be cared for when his or her parents and caregiver are no longer able to do so. It is on this premises that a SNTC trust, which parents and caregivers set up, with the help of the Special Needs Trust Company, is normally put on standby and with only an initial settlement of $5,000. In order to provide long-term funding for fees and expenses of the SNTC trust, when it is activated and the special needs beneficiary throughout his or her lifetime, two practical estate plan structures can be considered. 1. Special needs trust funded by lump sum transfer. And the estate plan structure as shown in diagram 9.6 below, lump sum transfer or funds upon demise of the parent through his or her CPF nomination specified for special needs saving, is nominated specifically for special needs savings scheme and bequeath specified in her will. In case of loss of mental capacity, the donee can transfer a suitable lump sum to the trust fund account of SNTC Trust. 2. Special Needs Trust funded by Standby Trust. In the estate plan structure as shown in diagram 9.7 below, the standby trust set up by the parent will be activated to make periodical transfer of money to the trust fund account of the SNTC Trust when he or she is not able to care for the special needs person, either due to loss of mental capacity or upon demise. Upon demise of the settler, the executor of his or her will then transfers the assets into a standby trust, which is activated by then. His trustee will carry his duties to fund the SNTC trust and distribute to other beneficiaries according to the wishes of the settler. For CPF nomination, it is more effective to nominate in full to the standby trust instead of specifying certain percentages of SNSS for the SNTC trust. Standby trust and related letter of wishes offer better flexibility to accommodate changes such as upon termination of the
Chapter
SNTC
15.
trust. Special situations. Takeaways. In the last chapter of this book, we highlighted additional considerations needed for people under special situations, namely, Singapore permanent residents, foreigners with or without assets in Singapore, and estate planning for Muslim residents in Singapore. Exceptions and qualifications. The 6 types of estate planning tools are generally applicable for everyone doing estate planning in Singapore. However, you have to be aware of some specific exceptions and qualifications pertaining to each tool. 1. CPF nomination. This is only applicable to persons who are CPF members having valid CPF accounts with the CPF board. This includes Singapore citizens, Singapore PRs, and foreigners who have been employed by the registered Singapore company under a contract of service, and those self-employed persons who are paying income tax in Singapore for income derived from performing work or providing a service for others under a contract for service. 2. Insurance nomination. This is the only applicable for a person who is both the policy owner and life insured for the relevant policy, i.e. life policy or accident and health policy with death benefits, and that the policy is issued by an insurance company licensed in Singapore. 3. Advance Medical Directive. The AMD made by a person is only applicable when he or she is unconscious, undergoing extraordinary life-sustaining treatment, and is being treated in a Singapore hospital. It is not recognized in the jurisdictions outside Singapore, hence it is important for Singapore residents to take up proper travel insurance when traveling outside of Singapore, to cover costly medical bills should they meet with serious accidents or illness, which are not previously known, that could result in the need for extraordinary life-sustaining treatment. 4. Lasting power of attorney. Both LPA Form 1 or Form 2 made by a person is only recognized in Singapore. Hence, if you have assets both immovable and movable in foreign jurisdictions, you have to consider executing additional legal documents, for example, general power of attorney, in the countries concerned, so that the appointed attorney can manage your assets there when you suffer loss of mental capacity. Alternatively, you can consider setting up a revocable living trust in Singapore or an offshore trust in tax haven jurisdictions, and transfer the legal ownership of those assets to the trustee. This living trust with property drafted trust deed is valid to manage those assets settled in it during your lifetime, including the period when you're mentally incapacitated after death. 5. Wills. If you have significant assets in foreign countries, particularly immovable properties and business entities, it is advisable that you should consider writing separate wills in each of the countries concerned. This will ensure speedy probate if your assets in these countries concurrently upon your demise. Alternatively, you can consider setting up a revocable living trust in Singapore or an offshore trust in a tax haven jurisdiction as proposed in the paragraph above under LPA. 6. Trusts. With reference to Section 32 of the Civil Law Act, which states the perpetuity period shall be 100 years or such shorter period as may be specified in the instrument by which the settlement or disposition is made, trusts set up in Singapore are allowed for up to a maximum period of 100 years. However, a short period can be specified in the trust deed of the trust concerned, either for a defined number of years or to terminate conditional upon occurrence of certain events, for the example when youngest son attains the age 35 or is married. The income arising from a trust may be accumulated for its entire duration and is allowed under Section 31 of Civil Law Act. Singapore permanent residence. Singapore PRs, comprising nationalities from the region countries and beyond, when doing estate planning, they have to understand the law of domicile of the country of which they are holding citizenship. Domicile of a person determines how his estate will be taxed upon his demise. It is especially significant for citizens of countries that have tax laws covering worldwide wealth of their citizens, such as the UK and USA. Hence, Singapore PRs can strive to fulfill the requirements to qualify as domicile in Singapore. Then they can enjoy a tax advantage during their lifetime and after death. In law, domicile is the country that a person treats as his permanent home and to which he has the closest legal attachment. A person cannot be without a domicile and cannot have more than one domicile at any one time. He acquires a domicile of origin at birth, as that is of his parents. He retains this domicile until he acquires a domicile of his choice by making a home in a country with the intention that it should be his permanent base. Domicile is distinct from nationality. It is also distinct from ordinary residence in that the latter may be acquired without any intention to reside there permanently. Singapore PRs most likely own assets in Singapore and in other countries, including their respective country of origin. They should consider the tax advantage of setting up qualifying domestic trust. QDT set up in Singapore by settlers, who are individuals, and administered by licensed trust company here, are granted tax exemption on specified locally insured investment income, as provided in the income tax exemption income of prescribed persons arising from funds managed by fund managers in Singapore, Regulations 2010, and foreign-sourced income is provided in the income tax regulations. QDT set up as a living trust can also be used for asset protection against liabilities and creditors of the settler, if it is set up as an irrevocable type and with the settler excluded as a beneficiary. Foreigners with or without assets in Singapore. Singapore being an established financial center with a strong reputation of transparency, security, competitive tax regime, and effective legal and regulatory framework, has long been recognized as a premier wealth management hub in Asia. She is increasingly considered by HNWIs worldwide as the preferred location for setting up trusts in recent years. Singapore law allows foreign individuals to set up qualifying foreign trusts in Singapore to enjoy significant tax exemption provided in the income tax regulation. QFT is a living trust centered and created by deed, where all of the settlers and beneficiaries are foreign individuals, i.e., individuals who are neither citizens of Singapore nor resident in Singapore or foreign companies, and it is administered by a licensed trust company in Singapore. The tax-exempt privilege of the QFT countries continues even if any settler or beneficiary of the trust who is an individual subsequently becomes a citizen or resident of Singapore, subject to certain conditions provided in Section 2A of the Income Tax Regulation. Estate planning for Muslims domiciled in Singapore. The Majlis Ugama Islam Singapura is responsible for all matters related to Muslims in Singapore as constituted in the Administration of Muslim Law Act. Generally, Muslims in Singapore are obliged to comply with the Amilah in orders of rulings of MUIS. The various estate planning instruments detailed in the previous chapters are applicable to Muslims domiciled in Singapore, particularly those instruments dealing with matters before the passing of a Muslim. 1. LPA. The MCA and LPA are fully applicable for Muslims to appoint donees, to make decisions for them when they suffer loss of mental capacity. Making of LPA by Muslims has been endorsed by the Legal Committee. In a fatwa issued by Mar 2009, the committee decided that a. The LPA is a form of planning, which is permissible under Islamic law and is in line with the objectives of the Sharia. It is also consistent with the Islamic principles which encourage Muslims to plan and prepare for futures. b. The legislative provisions in place to safeguard the entrance of a donor are already in accordance with the Islamic legal maxim of Sadsara, which would thus prevent any possibility of the donee or the deputy abusing the authority given. 2. AMD. Advance Medical Directive is also applicable to Muslims who want to make AMD and to decide in advance of their decision for not wanting to undergo life-sustaining treatment when they are suffering from a terminal illness and are unconscious or incapable of exercising rational judgment. In a fatwa issued in 1994, the Legal Committee decided that Muslims are allowed to draw up an AMD, and they opined that those who refuse the treatment can be assumed to opt for patience and to do away with extraordinary interventions, as he believes that there is a prescribed time for every person to die. 3. CPF nomination. All CPF members, include Muslims, are given the right to make CPF nomination and decide nominees of their choice. CPF nomination was endorsed by the Legal Fatwa Committee under MUIS. In a fatwa issued in August 2010, the Legal Committee decrees that a. Each CPS contributor is responsible to evaluate the option which is most suited, and fulfills the needs and protects the welfare of his or her family in the administration of his or her CPF savings. He or she may choose to either utilize the nomination instrument or distribute according to farid, or exercise both options together. This evaluation and assessment must take into consideration the financial condition of his or her beneficiaries and who is more in need of the money. B. The Legal Fatwa Committee was of the opinion that the CPF nomination system may be considered as haiba, as is made by the contributor during his lifetime. C. The nomination system is a contemporary form of property distribution not found in the writings or scholarly works of scholars in the past. However, it is permitted as it is considered as a new form of haiba. It is also able to preserve the spirit of farid and ensuring the welfare of one's dependents. This is particularly in light of the amendments of the CPF Act, where contributors will no longer receive a substantial amount which would enable him or her to spend on his or her dependents. At the same time, CPF contributors must be aware that a nomination cannot be made with the intention and purpose of unfairly denying the rights of the other beneficiaries. D. The Legal Fatwa Committee also reminds recipients of CPF monies, whether by the way of farid distribution or nomination, is obliged to ensure that all of the deceased's debts are settled before using the money for personal use. If no CPF nomination is made or no surviving nominee, then their CPF money will be distributed by the PTO according to the farid rules, the Muslim equivalents of ISA rules of distribution for non-Muslims. 4. Insurance nomination. The Legal Fatwa Committee has issued a fatwa in 2007 that allows irrevocable trust insurance nomination for Muslims, as is a form of nomination was seen as fulfilling the description and requirement of haiba. Subsequently, another fatwa was issued in 2012 that allows revocable insurance nomination by Muslims. The committee decided that revocable insurance nomination is a contemporary form of haiba. It is a new form of financial planning which is in accordance to Islamic principles. The committee is of the opinion that revocable insurance nomination is the same as CPF nomination, and both are accepted as valid forms of haiba. 5. Wills. Muslims domiciled in Singapore are allowed to write wills so long as it is in compliance with Muslim law. This is provided under Section 111 of the AMLA. A. Section 110 states that nothing in this act shall be held to prevent any Muslim person directing by his or her own will that his or her estate in effect shall be distributed according to the Muslim law. B. Section 111 states that notwithstanding anything in the provisions of the English law or in any other written law, no Muslim domiciled in Singapore shall, after the 1st of July, 1968, dispose of his property by will except in accordance with the provisions of and subject to the restrictions imposed by the School of Muslim Law, professed by him. C. Section 111 states that nothing in this section shall affect the provisions of the wills, other than Section 3 thereof. Furthermore, with reference to farid, the Islamic law of inheritance published by MUIS, writing of will is permissible by Islamic law, but only a maximum of 1/3 of a deceased Muslim's estate can be willed away to non-farid beneficiaries, and the will should be witnessed by 2 male Muslims, who are not the beneficiaries. 6. Trusts. With increased affluence of the Muslim community in Singapore over the last few decades, trust has become a more relevant instrument for their estate planning. But in practice, Muslims domiciled in Singapore have to ensure compliance of Muslim law when setting up trusts for wealth management. A. In general, according to Islamic law, lifetime gifts as haiba are not subject to the Quranic rules of inheritance, i.e. farid, and may be made freely by an individual. However, if the gift was made during sickness or death, it may be clawed back into the estate of the deceased. B. In other words, as long as the gift takes effect while the deceased was still alive, the legal title of property or estate assets transferred under these gifts do not fall under the estate of the deceased and are not subject to the Farid rules. C. Living trust with assets settled to it during the lifetime of the settlor is allowed. D. Testamentary trust embedded in a will is not allowed, as it is only effective after the death of the settlor, and is his estate assets by then can only be distributed according to the Farid rules and will, if any, written in compliance with Muslim law. E. Muslims domiciled in Singapore may use trusts to plan for bequests that don't follow the Quranic rules of succession. For instance, if an individual would like to provide his son and daughter with equal shares of his estate, a trust may be used as a tool to achieve the goal. Trusts may also be used to provide an inheritance to non-Muslim family members. Illegitimate children or more distant relatives, such as grandchildren who would otherwise be disinherited the estate of the government by Muslim law. F. MUIS has in fact encouraged Muslims domiciled in Singapore who have special needs dependents to set up special needs trusts, so that these special needs persons can continue to be cared for when they themselves are unable to or unavailable to. 7. MUIS Special Needs Trust Scheme. On the 1st of February 2019, the Islamic Religious Council of Singapore and the Special Needs Trust Company signed a Memorandum of Understanding to encourage more Muslim families with persons with special needs to come forward and set up special needs trust to safeguard their loved ones' welfare and financial security. A. Through the scheme, MUIS will sponsor eligible families with the initial capital of $5,000 to set up the trust. MUIS will also channel an additional $5,000 to these families on a one-to-one matching basis, with a total of $10,000 per trust account. 100 persons with special needs stand to benefit from this initiative. B. MUIS has also committed to allocate $1 million to support the scheme through funds that were paid to Bait al-Mul from unclaimed estates. C. To reach out to the wider community, MUIS will engage various stakeholders to promote the scheme to the public, including organizing events on inheritance issues, distribution of collaterals and sharing with mosques, madrasas, and zakat beneficiaries. Chapter 16. Conclusion by Darren Joseph. Thank you for reading our book. My name is Darren Joseph, and I'm the co-author of this book. I have been a long-term resident of Singapore since 2013. Our Singapore-based international tax team works with U.S. citizens and green card holders who invest in or work across Asia. Our team also works with Asian families that invest into the U.S. It is difficult for U.S. exposed families to easily access support in estate planning. Over time, our practice began to take on more and more clients who had issues related to U.S. estate taxes. In June 2020, my own father, Hayden T. Joseph, CPA, NBA, passed away at our family home in Miami after a long illness. I have dedicated this book to him. I am grateful to Dwi Sek Lim for working with me to produce a resource that can help families like ours. U.S. exposed families based in Singapore with estate planning needs. Trusts, wills, powers of attorney, medical directives, etc. I hope that the contents of our book can help you through a challenging process. My name is Darren Joseph, and I'm a partner with Hayden T. Joseph and Company, and a member of the international tax team at Moores Rowland Asia Pacific, with over 30 offices in 11 Asian countries. As an IRS-enrolled agent, I am admitted to practice before the IRS, and I am the author of Taxes for International Entrepreneurs and Expats, Proven Principles for Legally Reducing Taxes, and Adapt or Die, International Entrepreneurship in a Post-Pandemic World, available on Amazon. I have 2 master's degrees in economics, a certified diploma from ACCA, Association of Chartered Certified Accountants in the UK, done extensive education with Columbia Business School, and completed advanced tax coursework at both New York University and the University of London. I have had my views published in the Singapore Business Review, Forbes Asia, the American Chamber of Commerce in Indonesia, the International Business Structuring Association in the UK, Offshore Alert, and the Trinidad Guardian. Finally, I have given seminars on tax issues in the US, Singapore, Indonesia, Malaysia, Vietnam, the Philippines, Hong Kong, Taiwan, Japan, and the Caribbean. Email at help@htj.tax. LinkedIn is www.linkedin.com/in/Darren-EA-03453332. Website www.htj.tax. This has been Essential Estate Planning for American Expats Resident in Singapore by Darren Joseph and Jui Sek Lim. Narrated by Lamont Mapp. Copyright 2020 by Darren Joseph and Jui Sek Lim. Production copyright 2020 by Darren Joseph and Jui Sek Lim.